Can I have your attention, please? Can I have your attention, please? We're going to be a little late. One of our board members yesterday had emergency retina surgery. She was told that we had arranged, and we were told this morning that they had arranged for her to participate by Zoom. Now we're told that she cannot participate by Zoom, so she has elected to come down and be present here. So she, and in respect of her commitment to what we do, and while I'm not sure that's the best judgment to exercise, we're going to wait until she gets here before starting. While we're waiting, I have one more public service announcement. Somebody left a pink cased cell phone at the security check-in. If you are missing your pink cased cell phone, you can go down there and retrieve it. Can I have your attention, please? About 6 o'clock this morning, I first heard that there was going to be a large number of people representing various interests, mainly interests about paper ballot voting, that were going to attend the meeting today. The fire marshal has established the capacity of this room, and it's not to be exceeded for obvious reasons. The fire marshal has determined the capacity of this room, and it can't be exceeded for obvious reasons. So anybody who is standing needs to go to our overflow room, which is across the street in the Coverdale building. It's at 606. Well, first of all, what you can and can't do is not your prerogative. I would say this, that if somebody had told us in this group that you were going to have a large number of people here, we would have made an accommodation before this morning. But, yeah. So those people that are standing, if you would please go to the overflow room, or if some people that are sitting would allow those people who, okay, well, we can fill up all the seats. And there's some seats, ma'am, there's some seats up here. Here's one right for you. Come on. There's another seat over here. Please come forward. You can take this seat. Sit down for a second. If anybody has a seat next to them, can they raise their hand? Here's another seat up here. There's another seat up here. Are there any more empty seats? Right. Yeah. 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 All right.
Bill, you did see this.
Yeah. All right. It looks as if we have resolved the problem. There are some people that are staying here because they would like. Can I have your attention, please? So it looks like the overflow issue and the capacity issue has been resolved. There are some people that are staying here to speak. They've said that when they're done speaking, they will vacate their seat And so somebody who is in the overflow room that wants to come over and take a seat may. And I suspect that there are some people that want to speak that will not give up their seats, but at least will have additional capacity. That was offered by one of the participants and the attendees here. I'm grateful for the suggestion. I think it's really a fair one and a good one that allows us to maintain the safety of the room, but to accommodate people. And I appreciate your willingness to give up your seat after you've had a chance to speak. And as you know, the public comments is earlier in this particular meeting than it has been in the past, so that will work especially well today. So now that this is Ms. Gazelle. Ms. Gazelle is here. I think for one thing is that that's a testament to how much time and effort that we take and how seriously we take our positions and our responsibilities. We are fully aware that some of you do not agree with our positions and do not believe that we're fulfilling our responsibilities. We can have a discussion about that outside if somebody wants to do that, but I think that one of the greatest things when I was on the court was to have so many people that would attend a trial. And it was interesting that once they attended and they heard the full explanation of the evidence and the arguments of the lawyers, they would come up and say, I would never have known this process, and I certainly would not have known all of the evidence and how it has to be weighed unless I had attended the trial. I think that's what, it is a right that you have to have a public trial under the Constitution. There are other rights that you have to vote under the Constitution, but there is a process by which those rights are exercised. And I will tell you, when I presided over the terrorism trials here in Atlanta, we had to have an overflow room, and there were people that said that we have, I want to attend. And we did exactly the same thing. We would allow, as people left, we would allow more people in so that we could fulfill the obligation to allow a defendant to have their public trial and fulfill our responsibility to allow it to be public by allowing people to watch it. There are a lot of people here today. I would expect everybody to recognize that democracy is best exercised where there's decorum and people don't speak over each other and people don't interrupt. And I would ask your indulgence as we go through the various matters today that we participate in what I call a responsible democracy, which is to be respectful of other views, including those that you don't agree with. And hopefully you will see that exhibited by us. So with that, we will begin the meeting. Ms. Gazelle is here. If at any time you feel as if your eyes look a little different, but I think I know why. But if you're uncomfortable or you need to leave, let me know, and we'll see if we can arrange another way for you to participate that overcomes the technology issue that I thought we had resolved, but didn't. So with that, I'm going to call the meeting to order, and we will begin with the invocation, which I will deliver. The God in which we believe, whether it's a Christian God or a Muslim God or a Jewish God, or any other God of any other faith, we ask that you be present with all of us, including those that have no faith at all. We would like for everybody to be comforted by that which they call upon for comfort. We thank you for the responsibilities that all of us have, whether it's sitting up here behind the desk or whether it's sitting in a chair in front of us, that this country has lasted as long as it has because we are a democracy in which there are debates and disagreements, but ultimately there is respect for our country and our Constitution, and all of us seek to understand what the Constitution says, what the laws say that are enacted pursuant to the authority of the Constitution, whether it's the national Constitution or the state Constitution. And that we are privileged to live in a place where that can happen. There are places that are war-torn today that are not democratic nations, or there are not democratic nations that want to convert those that are. Lord, we have been protected against that. There are people that lie in graves as far away as France and Southeast Asia that gave their lives to allow us to do what we're doing today. And for that, we are eternally grateful. So be with us today. While there might be disputes and disagreements, we would ask that everybody be charitable to each other, and that they take their opportunities that are given according to the structure that's been laid out, so that we can do what we have been called to do and appointed by the governor to do, which is to serve on this board. So we thank you for being with us. I thank you for the participation of the citizens of this state or any other state that happens to be here. And we hope that the meeting will move forward so that we can reach resolutions on important issues. We ask all this in the name of the God that we believe in. Amen. Yeah.
Amen.
So,
Amen.
so I would now ask Matt Mashburn to lead us in the Pledge of Allegiance.
Please stand. Face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated.
All right, the first order of business is to approve the meeting that we held on June 20th and 21st. The minutes have been provided to the members of the board. Is there a motion to approve the minutes?
Mr. Chairman, I have just a couple of minor corrections, if I might.
Yep.
Please.
What are they?
On page 3 of the June 20th meetings, in the first full paragraph of text, I'm referred to as Matt, which is my name, but otherwise I'm referred to as Mashburn or Mr. Mashburn, so I'd ask that Matt be corrected to Mashburn, please. And then on the
Wait a second while that. Can somebody turn that phone off, please? Okay, go ahead.
And then on the June 21st minutes on page 3 again, under consent orders, there is a reference to a motion being passed and seconded as 5 to 0.0, and I just ask for that superfluous 0 to be taken away. That's all I have.
Is there any objection to those changes? Then they'll be made. I do think in the minutes that we probably ought to refer to anybody by Mr. or Ms. or Mrs. or Ms. Yeah, in order to, they shouldn't be as familiar as using first names. So the person drafting our minutes ought to do that in the future. All right, then is there a motion to approve the minutes?
So moved.
Is there a second? All those in favor say aye.
Aye.
For all those opposed, nay. The minutes are approved. The next order of business is a procedural matter, the first of which is a matter concerning the board's consideration of the Attorney General's Office negotiation and recommendation of proposed consent order on SEB cases 2021-181 and 2022-025 at the June 21st, 2023 meeting. And I want to address that consent order. On August 1st of 2023 at our meeting, comments regarding we've received inquiries about the process for considering and voting on June 21st of 2023 to approve the consent order on SEB cases 2021-181 and 2022-025. I want to give you some background on what had occurred before that vote was taken. The consent order was negotiated by the State Attorney General's Office with counsel for Fulton County after the 2021-181 complaint was referred to the Attorney General's office on March 16th of 2022 at a meeting of the State Election Board. The meeting was attended by Mr. Mashburn, who presided, Ms. Gazelle, Mr. Lindsay, and Dr. Johnson. The presentation to the board and the discussion and questions that followed were lengthy. Because I was not on the board at that time before the meeting that we had on June 21st of 2023, I went back and read the transcript of the discussions on that complaint, and can tell you that they were lengthy. There was a lot of input. There were a number of questions about the complaint. It was after that the complaint was referred, as is the prerogative of the board, to the Attorney General's office because the board had found a violation. Just as a matter of background, like any legal matter, when it's referred to lawyers, lawyers have to make a determination of what process will be engaged in after it's referred, in this case, to the Attorney General's office. Those considerations take into account not only the violation, but they also have to take into account the process, and there are two legal processes essentially for something that's referred to the Attorney General's office. One would be for the Attorney General's office to handle it as an administrative matter with a hearing before an administrative law judge. Or short of that, they can discuss whether or not there could be a negotiated resolution, and whether or not you decide to go to a hearing is the lawyers who are handling the matter at that time have to look at what the evidence is and have to look at what the outcome might be at a hearing and try to, in their considered judgment, to see if a reasonable resolution by consent can be reached, and it's possible that that can be presented to the board for approval if they agree with that. But we trust the Attorney General's office in reaching those resolutions and making those recommendations. Finally, although it was not the matter in this case, it could be referred to a district attorney in the county in which the conduct occurred. We have done that on occasion. In that case, it is up to the district attorney to make a decision on whether or not to prosecute or whether or not to take a plea, because they go through the same analysis as to what the evidence is and what would be a reasonable resolution of the matter. In the case of for example, in a criminal case, I often had those presented to me, and it was my decision based upon the recommendations that was made whether to accept a plea or not. Now, out of the background into some more context for what happened. A motion was made, as I told you, to refer the complaint to the Attorney General's office for further investigation. That is a responsibility and a prerogative that the Attorney General's office has. If they want, they can do further investigation in evaluating what they want to do with the matter. A duplicate complaint, duplicate to the one that was case number 2021-181, was filed by a separate complainant in 2022, and that also was referred to the Attorney General's office. And because they were essentially the same matter, they were considered by the Attorney General's office as basically raising the same allegations. Over several months, the Attorney General's office negotiated a consent order to conclude 2021-181 and 2022-25, those two complaints. The consent order was approved by the Fulton County Board of Commissioners, and it was presented for approval at the June 21st, 2023 meeting of the board. When it was presented, counsel for the Attorney General's office described the consent order provisions in some detail. In fact, having gone back now and compared the presentation that was made to the board with the actual consent order, it is largely verbatim with some summarization, but frankly, none of the material issues were different than what was in the consent order. The Attorney General's office recommended approval of the consent order, and they gave a number of reasons for their recommendation of a consent order and why the consent order that was presented to the board was in their recommendation something that seemed to accommodate not only the violation, but a responsible response to the violation. I invited board members that were there if there were any questions about the consent order and its resolution of the 2021-181 and 2022-25 complaints. There were no questions. Mr. Lindsay moved to approve the consent order, and the motion was seconded by Ms. Gazelle. I noted that the motion to approve had been moved and seconded, and again asked the board members if there was any further discussion. No board member asked to discuss the matter further. The motion was called for a vote, and the consent order was approved with 4 members voting yes and 1 voting no. The process for approval of the motion was in accordance with the regular procedures of the board and proper parliamentary procedure, including the opportunity for board members, if they had any question about the consent order, to open it up for discussion with their board colleagues. 4 of the members had the benefit of attending the March 16, 2022 meeting and hearing a lengthy discussion of the matter, which the consent order resolved, and board members received a sufficient and an adequate summary of the consent order terms and the basis for the Attorney General's office's recommendation. This matter was thus concluded with the board vote, and the consent order was executed by the board and made final, and it is a final order. Are there any comments from any of the board members? All right, so we'll go on to the next matter in the agenda, which are investigative reports. Just to give those that are not familiar with our procedure, the process is that when a complaint comes in, it is opened. When it's open, the first responsibility is for the board to determine whether or not it's what I'll call a cognizable, or whether it's a complaint that in fact is within our jurisdiction to hear. If it's not, our process is to tell the complainant that it doesn't meet certain qualifications necessary to be a complaint. Most often that's that there isn't any evidence, there's a complaint about something that happened without any factual predicate for it. On at least one occasion, and there'll be one even in today's set of complaints, where having now looked at the law that applies to the conduct that's alleged, the question is whether or not the law supports the complaint, and if it doesn't, then it's not a cognizable complaint and it's not processed. And if we don't get any further information back from the complainant, it's just not processed through the next part of the process, which is if it's cognizable and there's sufficient facts that are alleged, we turn it over to the Secretary of State's investigators. Those investigators are now investigating a board complaint, a complaint that we have authorized to move forward. After they're done with their investigation, we look at their preliminary conclusions. Sometimes, and I'm involved in this process, I'll say that I think the board members need more information, and we'll ask for there to be more investigation done. That's for the purpose of having enough investigation done so that we don't hear it at a meeting, tell them in an open meeting that we can't vote on it because we need several things to be done. We are respectful of the people that attend these meetings and of the respondents, that the complaint and the investigation ought to be sufficient for us to make a decision, and so we go through that process. If it's then put on a calendar for us to hear the complaint, and they come to us from the investigators in basically 2 categories. The first category is not that they have reached this determination, but they reach a recommendation based upon what they found in the investigation, and in some cases they will recommend, based upon what they found in the facts, that the case they recommend be dismissed. They cannot dismiss the complaint. The complaint can only be dismissed by the board, because it is in fact a complaint made to the board over which we have responsibility to make a decision. The second are complaints where they recommend that a violation be found. They cite what the violation is. They cite the evidence that supports the violation, but again, they submit it to us for a resolution of what we do with a complaint where they recommend that there is a violation. There are two ways in which we deal with that. So that larger category is broken down into two subcategories. The one would be that it's a matter where there are circumstances that would indicate to us that rather than to move to a more formal action, that we will find a violation, but then we will state specifically in writing what conduct was that supported the violation, and then because either they reported it to us themselves, which happens, or there was some extenuating circumstance that shows that while there was a violation, that we understand why the violation occurred. In most of those cases, the county accepts, or the individual accepts, responsibility for the violation, explains why they engaged in the violation. In those cases, we will find a violation and send them a letter as far as telling them that the violation, what they did was in violation of a rule or the law, and we will instruct them what they should do in the future to make sure the violation doesn't reoccur. The second set are those where we think that they are serious enough to be referred to the Attorney General's office or to the appropriate district attorney for action. And it's then, and we're going to move into the first set of cases, that we hear information about the complaints, and we go through the process of what I've just told you, is to make a determination on how the complaint will be considered and what action we will take on it. We begin with cases recommended to be dismissed. There are 5 of those, and because it's a dismissal and because we've all had a chance to read the investigation report before the meeting here today, what we normally do is sometimes somebody will read through a complaint and find something that they either want to ask a question about or that they want to discuss in more detail, and I will do that here in a second. If nobody has any questions, then I will ask for a motion for all of the cases recommended to dismiss, that we move to dismiss all of those cases, and then we will conclude that part of the complaint evaluation process. So we have, these are the complaints that are recommended to be dismissed. SEB 2022-188, SEB 2022-260, SEB 2022-268, SEB 2022-281, and SEB 2022-371. Is there any member of the board that would like further discussion on any of these cases? Dr. Johnson?
Could we hear case 2022-188?
Do you have a microphone there, Michael?
Okay, you walk over and on the side there.
Yeah, please. And this is 2022, what's the number? 188? Okay,
188.
which is tab 3 for the board members. Granted.
Like a volunteer.
Okay, I don't know if that was me or not, but
I'm going to say it's you, so.
okay. So SEB 2022-188. On July 26, 2022, the complainant, a Melissa Peace, submitted a complaint to our office regarding her late mother's absentee ballot for the 2020 special and general election and federal runoff election. She alleged that it was fraudulent and in violation of OCGA 21-561 regarding false registration. So Mrs. Peace advised she was her late mother, Lillian Ladd's power of attorney. She was checking to ensure the voting status showed an inactive disposition when she noticed her mother participated in the following elections: the 2020 special general election, November 3rd, 2020, and the federal runoff election, January 5th, 2021. She believed fraud was involved, and because she was her power of attorney and her address, according to Peace, was her address. Now, Ms. Ladd was a full-time resident at Tucker Wellness and Rehabilitation Center in Tucker, Georgia, formerly Grace Healthcare of Tucker. Peace described her mother as frail, could hardly get out of bed, and she did not speak much. Now, power of attorneys do not extend to voting, and Mrs. Ladd had not been adjudicated as incompetent by a judge. Our investigator followed up with the Tucker Wellness Center and found that 2 workers there assisted Ladd in filling out her application and ballot: Jordania Fowler and Shaniqua Coleman. Neither worked at the facility anymore. She was able to reach Coleman, who stated that she remembered Ladd. She was the activity director at the facility, and when it came to voting, they would ask all residents if they were interested, and after confirming who was, they would assist those residents that were interested. She described Ladd as sociable, enthusiastic, and funny. Coleman signed Ladd's application for official absentee ballot as the person providing assistance. She also signed her oath envelope as assisting her, and also attesting to the fact that Ladd personally communicated her preference to her. And looking at the signature of Ladd on both documents and comparing it to the signature on her passport, it appears to be the same signature. Based on our investigation, no evidence was found to support the complainant's allegation.
Are there any questions?
And we were able to go and follow up beyond and get the information from the facility.
Thank
Continue.
you. Well, the first issue that stands out with this complaint is the failure of response of the county election office to requests for information and documents regarding this investigation. The investigator's summary includes phone calls, emails, and, and an in-person visit to the County Office of Registration and Elections. At that visit, the election director advised the investigator that the previously requested documents would be provided within 3 days. That was 9 months ago. It's a waste of time, waste of resources, and unacceptable performance of duties not to provide this to our investigators. And, and really, it hampers the ability of the election board to hear these cases in a timely manner. The other question I have is the complainant stated that she was puzzled how her mother could have registered to vote in the condition that she was in. Now, I understand that Georgia election law says assistance is allowed for those who are illiterate and disabled. Election law states that assistance in voting is allowed for those who cannot read the English language or due to a physical disability. But in the case of persons with dementia or a person who's in a coma, I suppose you could say they're illiterate, cannot read the English language, and are disabled, but I cannot understand how anyone assisting a person has the clairvoyance to know what such a person is communicating. So the question is a difference in opinion of the daughter versus maybe the report of the assistants. So I recommend that the case be continued or returned to the investigators to answer these questions. And I recommend a consideration of potential.
Excuse me.
Yes.
It really is important for you to restrain yourself. This is not, we're not here to ask for your approval of a question or a request. Well, first of all, we're all volunteers. We are not employees of anybody. We're not even employees of the state. We are volunteers in these positions. And just like when somebody speaks here that we don't clap, nor do we boo when they say things, we would just ask the same response from you, is to let us move on because clapping with respect to a motion is inappropriate. In a democracy, they don't clap on motions. You can call us whatever you want to call us. We're talking about a meeting. It's a republic, and that practices a democracy. All I'm saying is that it's not appropriate when somebody makes a motion to show your approval by clapping. If you want to nod your head, you're welcome to do that. Jazz hands is fine. Jazz hands is fine, because we can move on because it doesn't interrupt the process. Thank you for the suggestion. Continue.
Wait. I also recommend that consideration of potential violation of OCGA 21-2-562B, neglect for refusal to deliver documents when the election official failed to respond to the Georgia Office of Secretary of State Investigation Division's request for records.
Well, that, of course, is not a matter of this complaint. Nobody has made a complaint with respect to that conduct. So if you want to file a separate complaint, we can take that up at a later time. The complaint here is whether or not, based upon the investigation, the complainant is who has made specific allegations about this particular voter's vote, and there's a motion to continue. Is that your motion, Dr. Johnson?
That is my motion.
Is there a second? Okay, the motion fails for lack of a second. So we're back to the complaint and the recommendation that it be dismissed. Is there a motion to dismiss the complaint? No. Where's my volunteer to do this?
Mr. Chairman, I have a lot of experience in this, and then my own mother is in her late stages of Alzheimer's right now. We've been on a 10-year journey with this, and it's a very sad and tragic event, but we've spent a lot of time in the facility with her. And one of the things that I have seen is that these directors of resident experience, whatever they're called, take their job very seriously and are very interested in the person there, their patient, that they see every day, all day long. The family sees them as much as we can, but we're not with them every second of every day. So they take that job very seriously. Now, the other thing, I have served in the role as tabulation monitor for the party, for the Georgia Republican Party for many years, 20 years in that capacity. And in that role, I've gone and spoken to many, many groups. And one of the things that I have spoken to about is people that are very interested in voter fraud and what they can do to prevent voter fraud. And my answer has always been and included the response, if you want to make the very best effort you can against voter fraud, the thing you should do is if your loved one is in a care facility, notify the care facility that you'd like to be there when they vote. And so that has been my recommendation for many, many years. So I'm very attuned to the issue from both sides. I've seen this from both sides. And here, the evidence, the undisputed evidence in the record, is that the assister found the voter engaged and capable of making their decisions that were recorded, and they were recorded in a proper fashion, and the person labeled the ballot as being the recipient of the assister. So they did everything that they were supposed to do. And now, people who aren't involved in the situation may have their own opinion about what happened, but the evidence in the record is what we need to make our decisions on. And the evidence in the record is undisputed that the person was in the facility and undertook the proper steps, and the assisters undertook the proper steps. For all those reasons, I move to dismiss this case.
Is there a second? Second. It's been moved and seconded to dismiss the case. Is there any further discussion?
Yes, Mr. Chairman.
Just want to be clear that the information was provided after we gave you all the cases. We were able to finally get that information from DeKalb County that we didn't get originally. So that's how we were able to compare the signatures that were on the documents to her passport. So they did provide it ultimately.
Yeah, thanks for that clarification.
If I may, Mr. Chairman, and this is, that additional information is what's going to keep me from joining Dr. Johnson in signing on to a complaint to the county
He's speaking to
by virtue of the fact that information was. But I do think that, and I want our investigators to have this stick, that failure to cooperate is going to create a separate complaint. And that complaint's going to be taken very seriously by us. Now, in this situation, DeKalb County was slow in responding, but at least at the end of the day, they did respond. So I would ask that while it's not a subject of a complaint, Mr. Chairman, I would ask that a letter be sent to DeKalb County directing them that when we do, that when our investigators do come and ask for information, that we expect for that information to be timely provided, so that we can reach a conclusion in a reasonable period of time, and we do not waste resources from our investigators in this board and having to pull teeth to get information that should be readily available. So I would ask simply that that be taken up.
Any more discussion?
I appreciate that the county election office did finally respond, although it took more than 9 months. However, I'm still concerned that the complainant was not interviewed to further gather information of why she thought her mother, she was surprised that her mother could have registered to vote or vote in the condition, quote, the condition that she was in.
You know, my mantra in this has always been we look for the facts that we can establish, and then once we establish the facts, we make a decision. To me, if you have two pieces of evidence, somebody who wonders whether or not somebody has the capacity is different than somebody who says, I was with that person at the time that they voted, that they were alert, that they understood what they were doing, and they voted and filled out the appropriate documentation, and then the documentation shows that they were signed by the same person. So why, there's always lots of things that you can do, but if you look at between those two pieces of evidence, one is speculation and conjecture and kind of thought about why is it that that was not possible, and then you have somebody who was actually was with the person when the vote was made and the registration was enacted, which to me is direct evidence as to her capacity to vote. Our responsibility is to protect people's right to vote. And if this person had the cognitive ability, and having gone through now three elder parents in my family, the disease of dementia is not straight line, nor is it continuous with respect to what their abilities are at any given time. My mother-in-law and father-in-law both had periods where they were perfectly capable of making financial and other decisions, that there was never any thought, especially with respect to my mother-in-law who was in a memory unit. There were periods of time where she was able to make decisions about her life and about her finances. And there were other times when she was just not aware or didn't have the cognitive skills because she was tired or on some sort of medication. So I think the fact that the investigators had the chance to talk to the person that had direct knowledge of her voting, to me is persuasive. The other thing, I'm going to go back, I told you that I meet with the investigators when there are things that they need. And this, as I recall, this was one where I said we needed to get those documents that they had been asked for. I will say that the board in the past has not done a good job of following up when we don't get the information that we want. And the board, for the first time in a long time, has been issuing more subpoenas when we don't get a voluntary production from people when we need the information that's necessary. So we have issued more and more subpoenas, and you know what's interesting? When a subpoena is issued, they produce the information. So our model is to try to get the information that the investigators need and tell them when they need more information based upon the initial review. And so for that reason, on the facts of this case and the direct evidence that's available, I'm going to vote to approve dismissal. All right, is there, yeah, any further discussion? It's been moved and seconded to dismiss case number 2022-188. All those in favor say aye. Aye. All those opposed, no. The motion passes. All right, does any board member want to discuss any other of the cases that are in the cases recommended to be dismissed category? Dr. Johnson. 2022-268, which is for the board members at tab 5.
DeKalb County early voting hours. On Sunday, October 30th, 2022, it was reported to the Secretary of State's office that DeKalb County advanced voting precincts were extending their hours beyond the scheduled 5 p.m. for Sunday, October 30th, 2022. An investigator was sent to a polling location and confirmed the report. The Secretary of State subsequently opened an investigation into the unscheduled extension of polling site hours. The findings were, on Sunday, October 30th, the DeKalb County advanced voting sites remained open beyond the originally scheduled and published 5 p.m. It was determined that a press release issued by DeKalb County on October 28th, 2022, erroneously contained the Sunday closing time of 6 p.m. rather than the previously published 5 p.m. Out of an abundance of caution and in the best interest of the voters, DeKalb County Elections decided to keep the polls open until 6 p.m. After further consideration by county election officials, the polls were ultimately closed at 5:30 p.m. There's been no evidence uncovered to suggest that the change in closing time was intentional. There was no law or rule that was identified which addressed the extension of advanced voting hours, except they cannot extend beyond 7 p.m. according to OCGA 21-2385, the procedure for advanced voting. We didn't uncover any potential violations.
Any discussion or comment on the report? Go ahead.
Press release on Friday, 2 days before the change, Sunday voting hours. Or perhaps someone from DeKalb County could answer.
Can you press the button at your station so I know what microphone is yours?
There'll be a button that says talk. You see it? There.
All right.
All right. Can you hear me now?
Yes.
All right. My name is Irene Vanderels. I'm an attorney with the DeKalb County Law Department, and I'm here today with the Executive Director of DeKalb County Voter Registration and Elections. And I just want to let you know that we're here. I'm glad to answer that question or have our Executive Director or hold until if you have more questions with regard to that. With regard to the timing, it's the practice of the office, and I'm sure our Executive Director could speak more to this, to communicate with the public as much as possible about advance voting hours. So they put blasts out to let people know when and where they can vote during the advance voting period. And this particular release just had a typographical error in it with regard to the hours for that Sunday voting.
Thank you. Did the release announce an extension of voting hours?
No.
Or just the voting hours?
Just the voting hours. There was not an intention to, ahead of time, to extend the voting hours. It was just a mistake in the
Okay.
release itself.
How many people voted after 5 o'clock on Sunday, October 30th?
I don't know the answer to that. We can provide the number, but I don't know it off the top of my head.
Okay.
Mr. Chairman. I'm going to go in a slightly different direction, but either you or the other person, because the law would have allowed you to have the early voting as late as 7 o'clock. It's up to the county whether or not to shorten it or not. And so I understand setting it to 6 o'clock because that's well within the law. My question is, why on earth was it suddenly then turned around and shortened to 5:30? And I'm also concerned that some voter who was expecting to be able to vote and showed up at 5:45 or 5:50 wasn't able to vote. That's my concern here.
I think there was some concern that the board just wanted to be consistent with what had been approved at the meeting in terms of hours and to try to minimize the confusion. The decision was ultimately made to try to close closer to the time that had been intended and approved formally by the Board of Registration and
But
Elections.
you do understand my
I do,
concern, because
yes.
it sounds like you added confusion, you didn't shorten.
Yes, I think that may have been the
Because, the
case.
confusion, I'm worried about confusion for the voter. The voter who may have gotten that press release and said 6, and quite frankly, it would have been legally permissible to keep the poll open until 6, showing up after 5:30 and suddenly discovering that they couldn't vote.
Yes.
That's my concern here.
I understand, and I think that was certainly on the top of minds for the folks making those decisions. I will say that, the decision with regard to the board approval issue was coming from the lawyers in that instance, and we may have made things more confusing, trying to keep in line with the law as much as possible in terms of the voting hours that had been set and approved by the board.
Well, I want to elaborate on that because I have the same concern, is that because what the investigator was told is that because there was public information out to voters that they could vote to 6, that you allowed it to go beyond 5 because you thought that that was the proper accommodation to the voters who maybe the only information they had was that it was open until 6. Why you would have picked a time in between 5 and 6 makes no practical sense to me.
I think our executive director would probably agree with you on that, and I'll tell you that they were following advice of counsel at that point because we were trying to keep them in line with what had been approved by the board. So I understand that may have caused more confusion than it ultimately good it did to then close the poll at 5:30.
Because the question really is how many people relying upon that publication
Right.
Showed up and wanted to vote and were told they couldn't.
Right.
Or it was closed.
I don't know that there were people at the time, who were coming in after the decision was made to close, who then came between 5:30 and 6. I'd have to probably investigate that a little bit further.
So the people that wanted to vote that weren't able to, their voting rights were prejudiced.
Well, except that it was during the advanced voting period, so I think that there may have been additional time to vote during advanced voting and, of course, on Election Day.
Puts an awful lot of burden on the voter who's
It
entitled to
does.
rely upon
And-
public
and-
information.
I agree, and DeKalb County really does put forth a great effort to make as much advanced voting as available as possible, and I think we have some of the longest advanced voting periods in the state. So I agree with you, and think it's very unfortunate if anybody was burdened by that particular situation.
Well, I understand that's kind of the mantra I hear a lot, but the purpose of advanced voting too is for people that have scheduled travel out of the country or other obligations and they're not going to be here. We tell them they can vote early. In this case, you can say, well, you could vote early and you can vote until 6 o'clock unless you came after 5:30 on that day.
Mr. Chairman, if I might, so one of the, and counsel, you can stay, stay, yeah, 'cause this, I'll eventually get to you when I finish.
I think you're saying that you could sit down until he's
No,
done.
I'm saying stand up because I'm going to
You
need you.
should stand up like Mr. Payne.
Okay, so the issue, there's several issues going on, but one of the things that we do is a lot of counties listen into these hearings to try and find out what the best thing to do is. So one of the things I want to do is communicate to the counties out there, first of all, is that you were within your time period of 7 o'clock. So there's no question, but I don't want counties to misread this case and think we can extend voting hours without a court order. So I just want to communicate that to the counties out there. So the second thing that came to my mind is that somebody decided that we're just going to cut this off at 5:30 just because there was nobody there. And the reason I base that is because if somebody had been denied the right to vote, we usually hear about it. And so the absence of us hearing about somebody complaining, kind of, it's not in the record, so I can't make a decision on it, but just that's how I kind of read it. So I think instead of dismissing the case, I think it might be better for the board to issue a letter of instruction on how we think the issue of voters that are misled by a press release ought to be dealt with. And so I think a letter of instruction would be very helpful to resolve this case if the board is so inclined. So I would make a motion to issue a letter of instruction.
Is that with or without a finding of a violation?
I believe we would find a violation. We would find a violation and the remedy would be to issue a letter of instruction.
And the violation would be of what?
They advertised that they would be open to 6 and they closed at 5:30.
But that's a violation of what rule or statute? Sorry?
Chairman?
403.
Chairman Duffy, yes. So there's a reason to publish dates, times, and locations 14 days before advance voting begins. And there's a reason not to change those published dates, times, and locations for advance voting.
Are you talking about a rule or a statute?
Well, that's an opinion. So OCGA 212403B addresses time for opening and closing of polls and extended poll hours. Poll hours at a precinct may be extended only by order of a judge for the Superior Court of the county in which the precinct is located upon good cause shown by clear and convincing evidence that persons were unable to vote at that precinct during that specific period or periods of time. Polls shall not be extended longer than the total amount of time during which the persons were unable to vote at such precinct. And any order extending poll hours at a precinct beyond 9 o'clock shall be by written order with specific findings of fact supporting such extension.
But that pertains to the extension of voting beyond 7 o'clock, not the extension of an announced.
Y'all want 3 o'clock. I want you 3 o'clock.
Is that a rule?
385 states advance voting shall be conducted between 9 and 5 p.m. And the registrars may extend the hours until 7 p.m. to suit the needs of the electors. I saw nowhere in this complaint that this was suiting the needs of the electors, but to accommodating an error that was printed 2 days before Sunday.
The accommodation to electors was for anyone who saw the
In 2
mistaken
days.
release and relied on that information to go to the polls. I don't know that there is a violation of a specific rule because we would have published the advanced voting hours with the correct dates and times and locations in accordance with that rule. It was just, in an effort to communicate as much as possible with the voters. A press release was issued to remind folks about when they could go out and vote and that weekend voting was available, and a very unfortunate mistake was made in that press release
Correct.
with regard to the time.
And I believe the investigation stated that the signs at the polling place stated 12 to 5.
Right.
Right.
Correct.
So everything but the press release
Was correct.
was correct.
Right. It said 5 o'clock.
Yeah.
Now you can probably sit down. So,
Thank you. I'm glad to try to answer any more questions you might have.
thank you very much.
And was this date a weekday, Sarah?
Sunday.
Was it a what?
It was a Sunday.
Right. Because Sunday usually is 7 p.m. It's 5 p.m. for a weekday.
Mr. Chair, I join in Mr. Mashburn's motion for a letter of instruction. I think that clearly that the technical requirements for 21-2-385, if you look particularly at D, the steps were not followed in simply a letter of instruction regarding the proper following of the necessary procedures to extend the time. And also, I am, like I said earlier, concerned that once the time, I'm not certain that the proper procedures to extend the time were properly followed, even though that would have been permitted if they had followed the proper steps. And then I'm not convinced that the necessary steps to shorten the time were properly followed. And for that reason, Mr. Chairman, I would join in Mr. Mashburn's motion for a letter of instruction.
Well, I think the idea of a letter of instruction is clearly appropriate. Just in looking at these provisions, the question is, was there a violation? And if you look at these various rules, there's nothing that addresses a county who publishes one time, but where the election board sets it at another time, where they extend it by any time, whether or not there's a rule that's violated in doing that. It's a terrible practice, and I think it prejudices people's ability to vote. Whether or not people didn't complain about it, there are a lot of people that don't complain, and so. But I think that I think it helps everybody for us to be clear that if you publish a time and it's within the time allowed by the statute, you have to stick by that time. And you cannot, upon whim, based upon the circumstances of a particular day, go back and say, yes, we told people they could vote until 6, but we decided, well, we said 5, but we're going to do it at 5:30, that's not permitted. That the best practice is, if in fact you make a mistake and publish a time, you ought to let people vote until that time. And I think a letter of instruction with our advice that if they publish a time that they adhere to it, I think is in order. But I don't think there's a violation of statute or of a rule.
Judge, if I can just make a quick comment.
Everybody's on forever.
Oh, okay.
We're all hot mics now.
That's good to know. I agree wholeheartedly with your assessment, the legal assessment. I just wanted to make a comment on best practices. First of all, I wholeheartedly support every county making every effort to publish and publicize their voting hours and to send out media blasts. It is the best possible way to inform voters. If you do not already have one in place, a best practice would be to make sure that you have checks and you go through clearances to make sure that whatever you're publishing matches up. It's very easy to have minor errors that lead to cascading problems like this. So just make sure that whatever procedures you have in place has a check off before it goes out, so that whatever has been approved by the board is what you're publishing. And then you're not creating undue expectations on voters or on your poll workers who expected to get off an hour earlier.
Thank you. And if I just may say, I think we would welcome a letter of instruction because this was a very difficult issue for the county to face. We were in contact throughout the day with Secretary of State's office about how to handle the situation, and no one was really sure about what to do. So I think it will be very helpful. And it's just an example of how difficult these cases can be sometimes between making as much access for voters as possible and complying with the letter of the law. So we appreciate your input, and we'll look forward to receiving that letter of instruction with that guidance.
Well, I just want to respond to that. This was not a difficult case. This is a county that published something and told its citizens that they had a right to vote until 6 o'clock. And that there should have been consensus among everybody to say, if we promise something to the citizens and we publish it to it, we ought to abide by our promise, and that was your promise and you broke it. So I don't find that we could find that there's a violation of anything. I guess we ought to revisit whether or not we would create a rule for this. My guess is that it's unlikely that this is going to happen again, but we can, it's always our prerogative to send and to make it clear that the board has heard this, that what our view that what the county did didn't make any practical sense, but it made sense to extend it. You just should have allowed people to vote through 6, and I agree to send that letter. And if that's a motion, I will. It has to be seconded.
I've seconded it, Mr. Chairman.
It's been moved and seconded that we send a letter of instruction, but we don't cite that we have found any violation. Is there any further discussion? All right. There being none, all those in favor of the motion say aye.
Aye.
Opposed, no. The motion passes. Any other complaints that any member of the board wants to discuss or have a presentation on? If not, there are three remaining motions that are recommended to be dismissed. That is SEB 2022-260, SEB 2022-281, and SEB 2022-373. Is there a motion to dismiss these cases?
260, 281, and 373?
Yes.
So moved, Mr. Chairman.
Is there a second?
Second.
It's been moved and seconded to dismiss SEB 2022-260, SEB 2022-281, and SEB 2022-373. All those in favor say aye.
Aye.
Opposed, no. Those are dismissed.
Mr. Chairman, you skipped over 106, I think, in terms of a motion to dismiss.
106 has been continued.
Oh, okay. Sorry. My mistake.
106, take it.
All right, we are, of course, not on our regular schedule. It's almost 11. And most people, when they came here, just sat in their chairs, so, because you were afraid somebody else would take it. I think we ought to take a 15-minute comfort break and then go on to the next part of the agenda after we take a brief break. So we'll be in recess until 11 o'clock.
Let's cut all the mics off.
Can you, everybody please take their seats? Could everybody please take their seats? I guess I should have said two things. Please take your seats and stop talking.
I like that.
Get something that's a little more aggressive. How about something a little... During the break, it was brought to my attention that there were two matters under subsection 3 that I hadn't addressed, and I'll explain why. The second and third matters under response to the Fulton County Performance Review, which is actually, should read, oh, I'm sorry, that's the wrong agenda. The two matters that are under procedural matters, B and C, relate to the same person who filed petitions. Her name is Marilyn Marks and Jean DeFort. I got a call or got an email early this morning from Ms. Marks, who was driving to the meeting, and told me that there was some accident on 85 and that she had been sitting still on 85 for an hour and 5 minutes. And then later she wrote and she said, and I'm still sitting on 85. And so I talked to her about those two matters and said, rather than her not being able to get here in time because it was beginning to look like she couldn't get here at all today, I asked if she would like for us to defer those two matters and hear them together at a separate meeting of the State Election Board. She appreciated that and agreed to that, so that's why we didn't consider them as an accommodation to her, because it makes practical sense to hear them together. Those we'll announce the date for that later in this month. What we're going to do now is to hear public comments remind you that public comments are matters unrelated to the cases that are on the agenda for today, that it is limited to 2 minutes per speaker. If you have comments, you have to read those yourself, and not, you can put them in writing. In fact, I've gotten one in writing, and those will be posted in the next day, maybe even tomorrow, on our website for anybody to read any comments that were submitted in writing. It looks to me like we have about 50 people, so that'll take at least an hour. And then the plan will be, because I've told the state troopers who provide us with security that we will break at 12:30 for lunch, and we'll have to do that wherever we are in the program, because they have to staff up to make sure that they have people to cover the meeting. So we will go with public comments and go on to the next section, but we will break at 12:30, and then we'll take 1 hour for lunch. So I've got the list of everybody who has signed up to make public comments. That list is before me. I'm going to call you in the order in which you signed up. And so we will begin with Joseph Rossi.
Good morning. Can y'all hear me? Okay, regarding SCB 2021-181 consent agreement, I am respectfully asking that this board send it back to the AG's office for revision. Specifically removes this false misleading statement. And the statement is, the discovered errors were a fractional number of the total votes counted and did not affect the results of the 2020 general election, which were confirmed as accurate by the risk limiting audit. So I'm going to, now I'll have 4 independent sources that refute this statement. Source number 1, the 36 error report sent to Governor Kemp in September of 21. The last page of this report shows that these 36 errors of double and triple counting of votes totaled 4,081 falsely awarded votes for candidate Biden. Source 2, Governor Kemp's letter dated 11/17/21 states that the 36 inconsistencies noted by Mr. Rossi are factual in nature. The data that exists in public view on the Secretary of State's website of the RLA report does not inspire confidence. It is sloppy, inconsistent, and presents questions about what processes were used by Fulton County to arrive at these results. Contrast that with the above confirmed as accurate. Those two don't match. Source 3, AJC article dated 7/17/23, a rough estimate by the AJC indicates the errors identified by the investigators amounted to about 3,000 too many absentee votes counted for Biden during the audit. Source 4, Philip B. Stark, Curling versus Raffensperger case. Stark is a professor of statistics at the University of California, Berkeley. In this declaration, he states, the audit confirmed the original result of the election. He further states, I shall explain why these claims about the audit are false. Does that mean 2 minutes? Mm-hmm. Okay.
Down, boy, sit.
Does that mean sit down or wait for questions? I'm not.
I don't know, well, the first thing it means he has to turn off the buzzers, or I'll give you another 15 seconds to wrap up.
Well, this is a very important case. As you know, it was initiated by Governor Kemp's letter after I sent the 36-page report. I believe we're close to finalizing it as the consent agreement came about last board meeting. I think it would be a shame to close it with that false statement in the consent agreement. I ask that the board send it back and have that false statement removed and then re-voted on.
Thank you, Mr. Rossi. There we go. Thank you, Mr. Rossi. No. Now, whoever it was that volunteered to take over this, I decided that I did need to find somebody who was more competent. I obviously have failed at that. Exactly. The next is Ben Eskew.
Let me just open my notes. Where is it? I'm opening my... Hello, my name is Ben Eskew. I study election trends here in Georgia. I would like to share some... I'd like to share some information that may be disturbing. Some precincts had more than 100% of the VAP voting, which is the voting age population. One is RW12 in Fulton County, which the 2020 census revealed 3,009 people were part of the voting age population or over 18. But somehow, the two-party, Trump and Biden, is numbers 3,572 votes. That is more than 100%. Another example is 8K, which is City of Atlanta. What? Oh, sorry. Sorry. I thought someone was saying something. 616 are part of the voting age population, but 817 voted. What's even crazier is there are only 847 people, meaning only 30 people in this precinct didn't vote, which seemed a bit suspicious. This may be to Eric bloating our voter rolls. We demand paper ballots, no Dominion voting machines, and no Eric. Thank you.
Thank you. Yeah. Remember, we're doing crazy hands and not clapping.
No, jazz hands.
I'm sorry, jazz hands.
Jazz hands.
That are being...
Jazz hands.
Next is Kim Brooks.
Kim Brooks, DeKalb County. I'm a data expert on Secretary of State voter rolls. I want to talk about today, everyone needs to hear, we've always heard about phantom voters, and we have about 30% phantom voters on our voter rolls across the state. That equals about 2.2 million phantom voters, so if you wonder where the cheat comes from, it's from that bucket. Let's talk about a few that's happened in the last 3 months. Mr. Edwards is a Vietnam vet that died in 2019. He served our country for 20 years with the Air Force. He has a beautiful family, and he has been resurrected to life as an active voter in Atkinson County. We've talked to his stepson. They're not real happy about it. Let's talk about Miss Dixon. She's lived in Pierce for decades, owns her home, and they started messing with her voter roll. We went and spoke with her son that runs the tractor company in town. He's not happy at all because Miss Dixon doesn't even communicate with her son because she's advanced Alzheimer's. Yet she voted in November of 2022, which he assures us she did not do and was incapable of. Let's talk about Nishandra. She's a lovely gal in the projects in Statesboro and Bullock County. A duplicate ID should never be reinstated on the voter rolls, but they are being reinstated. And Nishandra is an innocent person being set up for a felony for double voting in Georgia. Her ID, her duplicate that was canceled, was reestablished in Gwinnett County. We've canvassed Gwinnett County at the apartment. Nishandra doesn't live there. And we finally spoke with Nishandra in Statesboro. We went to great lengths to meet to her to let her know that her ID has been stolen. That's another phantom voter. Now let's talk about Norberto. He was brought back in Gwinnett County at something canceled Voter Street. Okay. The criminals are not being very creative here. Then he was moved to DeKalb County to an apartment. We knocked on that door. We talked to the lady that lives in that apartment. Norberto doesn't live there because Norberto is currently sitting in jail in Gwinnett County. He may be there for a very good reason, but he is an innocent citizen that's getting his ID stolen.
All right, can you...
This is happening thousands across the state.
Can you wrap up, please?
Okay. Thank you. And we don't believe the gaslighting from this board. God bless America.
Lucia Frazier. Give her. Hey, good idea. Jason Frazier.
Good morning, everybody.
Morning.
Lucia Frazier, Fulton County. I sat in one SEB meeting not too long ago where you guys discussed probably for over an hour about 150 feet sign placement issue. Today, you spent quite a bit of time talking about a 1 hour difference in voting time. You show a lot of care to voting, discussing such small details, and focusing so hard on voter accessibility. But you really miss the big picture. Our votes can easily not get counted after all this beautiful accessibility. Corruption of our elections is so much easier with digital data. No one knows their vote counts once the data is digitized. Elections represent all kinds of people, technical people and non-technical people, so they should be simple, so anyone can see the whole process and also participate in the execution. You should be the first in line of advocates of this. Hand-marked, hand-counted paper ballots at the precincts in public view, so it's simple and nothing new. We've done this before. It can only get better. It can't be worse than what we have now. I'd like to add another thing. Since Fulton County is my house, I have responsibility as a citizen to clean my house a little bit. There was a lot of praise given to Fulton County this year, but I don't feel like you paid attention to some of the things that we had to fight through to get Fulton County to improve their operations. They were found to have thousands of illegal voter registrations, and they didn't find them, citizens did. Thankfully, they fixed some of them. They also spend 5 times more per registration than neighboring counties. And citizens like me had to fight to be a poll worker because they would use temp agencies and then say that there's not enough people to help them, but they ignored those of us that wanted to work. And we also had to teach them. Okay, thank you very much.
Hello, Jason Frazier, Fulton County Board of Elections, or at least I should be on the Fulton County Board of Elections, but my position was denied by the Fulton County Board of Commissioners. We all know that was illegal, and you know, they are right across the street. I would hope that this board could simply just write them a letter, inform them that the word shall means shall, and instead of leaving that seat open as it is today, they should fill that seat with somebody that was actually appointed to that position. We all know why they don't want to put me on there. It's because I've found thousands of illegal registrations. Actually, we drove through a guy's house today. We made a wrong turn and went on the I-20 overpass, or the Highway 20 overpass on Lee Street. That is a location where somebody was registered to vote. There are thousands of people at MARTA stations, UPS stores, and I've even turned in many people at UPS stores that were then allowed to vote again at that same UPS store, even though they were challenged. I'm told that whenever somebody is challenged, they must cure that challenge, but they don't. Many times, they just allow them to vote. There was even a person that moved from one UPS store, or one mailbox store to another mailbox store and was allowed to vote there. Another one that moved from a mailbox store to a vacant lot, and they were allowed to vote there. Fulton County simply does not verify their voter rolls. They do not do a good job, or I would not have found thousands and thousands of illegal registrations on the rolls. I would hope that one day you guys will clean those up or force their hand to do so. In my opinion, the only way we can do this right is hand-marked, hand-counted paper ballots at the precinct on election night. That's the only way we can get around the corruption that's happening in Fulton County every single day, every one of their laws that they continue to break. I think we all know that it is cheaper to run a paper ballot operation where we are hand-counting them on election night. I've worked as a poll tech in the precincts, and I have seen the hours that it takes to set up and the hours it takes to tear down. That is much more than the time it takes to hand count an election. Thank you.
Five red states turned blue in 2020: Arizona, Michigan, Pennsylvania, Wisconsin, and Georgia. 5 states in 2020 also changed their election laws weeks before that election. You guessed it: Arizona, Michigan, Pennsylvania, Wisconsin, and our beloved Georgia. All 5 states also depended exclusively on Dominion Voting Systems, ImageCast. And now the Secretary of State of Georgia says we cannot make hand-marked paper ballots available without support from state legislators. The last 2 Secretaries of State of Georgia, that would be Kemp and Raffensperger, had no problem implementing this Dominion's voting systems without the General Assembly's full support for all of Georgia's elections. And now when the Haldeman report is right there in front of them, Raffensperger dismisses it with a flippant remark. It's more likely that I could win the lottery without buying a ticket than that hackers flip enough votes to swing an election. But election technology experts are finally speaking out. David Jefferson of Lawrence Livermore Labs states, Raffensperger has lumped us in with election deniers. But we cannot, out of fear of that confusion, stop talking about these vulnerabilities. They are real, they are there, and they must be addressed. Another election expert, Rob Graham, posits, the fundamental problem here is that Georgia decided, against expert advice, to use QR codes for ballots. That means there's no way for voters to verify their votes haven't been altered by the ballot marking devices. Our solution? The Georgia legislature must call a special session this year to force all 159 counties to replace our electronic voting system with a security-grade, hand-marked paper ballot, hand-counted at the precinct, including absentee ballots, on the day of the election. We deserve legal, secure, and accurate elections. Thank you.
The person who will go up next is Field Searcy.
Good morning. My name is Ginger Hermetz. I am a natural-born citizen of these United States and a very proud citizen of this great state of Georgia. I come before you today to plead with you to get rid of our current election system. There is a plethora of evidence that our Dominion machines are unsecure and hackable. The Haldeman report exposes these facts. You may want to roll your eyes and think that I'm just a right-wing conspiracy theorist and that I am just mad because my candidate didn't win in 2020 or those in 2022. But it's much more than that. The choice that this state has made to use this flawed system is affecting our entire country. You know how they say elections have consequences? Well, they do. And we are living in those consequences today. And I know, you are just following orders from the Secretary of State. That's what the brown shirt said, and look what happened there. And I know, you are just following orders. But most of you have taken an oath as an official of the state. You have sworn to uphold the Constitution of the state of Georgia and the Constitution of the United States. What does that mean to you? Are they just words? Or do they mean something? I believe in my Lord and Savior Jesus Christ, and one day I will stand before him to account for myself. I want to be sure that I have been honest with my fellow man. I hope that you can reflect on the choices that you are making now for this great state, see the damage that these faulty machines have created, and choose to stand with us and the citizens of this state and say no more. Thank you.
Thank you. Okay, Mr. Searcy and Brad Barr, are
No, I'm actually Kevin Muldowney. I was signed up ahead of the Frasers and then my ride home. So if I could speak in this order, it'd be great. So I don't have to walk home. Kevin Muldowney, Milton, Georgia. State Board of Elections, we need your help. The scathing Haldeman report has been released, and what do we get from the Secretary of State? The MITRE report, a rebuttal that was manufactured and paid for by Dominion Systems. A rebuttal that was written without access to the same voting machines they were intended to support. And furthermore, a rebuttal that was signed by no one. The Haldeman report, among other revealing findings, dispels any myths about the validity of the so-called logic and accuracy testing. Logic and accuracy procedure only requires that one ballot be printed. According to Dr. Holderman, the machines can skip cheating on the first ballot. It can also be set to cheat only on the day of the election. He goes on to say, no grand conspiracies would be necessary to commit large-scale fraud. He also tells us the Dominion BMD was developed without sufficient attention to security, design, software engineering, and testing. It would be extremely difficult to retrofit security into such a system. The system cannot be made secure as the SOS claims. On top of the security problems mentioned, there is the reality that these machines cast our vote by a 2D barcode that is totally unreadable or unverifiable by the voter. It's actually a spoiled ballot, as per 183-1-14 spot 07. And we actually break the law every time we cast a vote with this current system and ballot. We've had enough. At this late stage, the only answer is to go back to hand-marked, securitized paper ballots. We already have the authority to do this as per OCGA 21-2-334. These ballots must be compiled and counted at the precinct level, fully auditable and decentralized. If we stand for liberty and justice for all, we must begin with the greatest freedom of all, the freedom to participate in truly free, fair, and transparent elections. Thank you very much.
Thank you very much. Now you are, I've lost.
I am Field Cersei.
Thank you.
From Grady County. If Judge Totenberg is correct and the QR code tabulated by a black box is unlawful, that means our votes are void. That means after 2 election cycles, we have no duly elected representatives in this state. Last month, this board declared you have no authority to change our voting system. In Kemp versus Pearson, the Secretary of State argued in his defense that his office has no authority over county elections. So the question I pose to you, who is in authority? Who is accountable? If you can't answer that question, I can. We the people are the ultimate authority under God. I pray that we can rise to the mantle with the wisdom necessary to carry this republic forward. Hopefully your influence can rectify this impracticable situation. It's untenable. Thank you.
Thank you, Mr. Searcy. Mr. Barnes and Kevin Parker is up after that.
Can you hear me? Okay. Did you want to adjust it at all?
You're
okay, good. Hi, I'm Brad Barnes from Rome, Georgia, and I have a simple request for the board. Make elections boring again. We all want the conduct of elections to become mundane affairs once again, rather than every election board meeting in this entire state at standing room capacity. The only way we can achieve that is by restoring faith and confidence in the conduct of elections. And the only way to achieve that is by vastly simplifying the conduct of our elections and restoring control of elections where they belong, in the hands of the people, not under the control of out-of-state corporations. Citizens across the political spectrum, Democrat and Republican, want the end to electronic voting and have wanted that since Diebold was introduced almost 20 years ago. And they want the conduct of elections to be done on paper ballots, hand-marked, hand-counted, and an end to election month and a return to election day. This issue, in short, will not go away, and it's time that we get it done. Let's make elections boring again. Thank you.
Thank you, Mr. Barnes. Mr. Parker? And next is Mr. Schroeder.
Thank you. My name is Kevin Parker, and I'm a resident taxpayer in Appleton County, Georgia, and I am on the Georgia staff of Citizens Defending Freedom. My purpose in speaking today is to provide you, the Board of Electors, with the information needed to do 3 things: promote the termination of improper and illegal funding with local taxpayer dollars of an unlawful voting system, Dominion Ballot Marking Devices, or BMDs. 2, replace with security-featured, hand-marked, hand-counted paper ballots. And 3, restore trust and confidence in the casting and the tabulation of our vote in Georgia's elections. Judge Amy Totenborg ruled in October of 2020 that Dominion BMDs were unlawful and that it was illegal for the state of Georgia to conduct elections utilizing them. Yet here we are, 3 years later, and we are still unlawfully voting on Dominion BMDs. To continue to fund taxpayer dollars a voting system the judge has ruled unlawful could expose county and state officials to misdemeanor charges. In DeKalb County, the only 22 primary race that was fully audited found that Dominion declared the wrong winner. In the unaudited races around the state of Georgia, how many of those candidates were declared the wrong winner? We will never know until the ballots are unsealed and counted by hand. Georgia's solution: terminate the use of Dominion BMDs and replace with the hand-marked, hand-counted paper ballots. We have a crisis of confidence in our elections. According to 2 separate polls, one being an ABC poll and the other a Harris AP poll, 8 out of 10 Americans are concerned and believe our election voting machines are vulnerable to hacking and have no confidence in the results of our elections. When the electorate loses confidence in their vote being cast and counted accurately, they begin to lose hope and trust as a result, and they will no longer bother to vote. We must restore confidence in our voting process in Georgia. In closing, in Galatians 5:1, Paul wrote that for this purpose did Christ call us, and that is to freedom, and we're not to be enslaved to bondage again. So, free us from the voting practice and dump Dominion, unplug Georgia, and replace with a reliable, transparent, and foolproof voting system known as security-featured, hand-marked ballots, hand-counted ballots on the day of the election at the precinct level. Thank you.
Thank you, Mr. Schroeder. No, Mr. Parker, Mr. Schroeder's up next.
We can't hear you.
And then Mr. Carnline is after Mr. Schroeder. Are you Mr. Schroeder? Are you Mr. Schroeder? You may speak.
I just lost all my notes when I took a break. But I'm Richard Schroeder from Hall County, and I'm just going to squeeze my heart and speak from my heart. Thank you. Oh, that's better. I lost my notes, so I'm just going to speak from the heart. I was a voter all my life, and in 2020 I realized that's not enough. I was persuaded to become a poll worker and get involved, and I'm very involved now, going to a state board meeting. And I'm also a veteran, an Army veteran. I took an oath of office. All right, Army. Now I'd rather fight than put up with this crap. And that wasn't in my notes. In the oath it says, I'll defend the United States of America from both foreign and domestic enemies. I'm sorry. We've lost more to fentanyl than we lost in World War II because of an open border. I just saw Sound of Freedom last week. People can't fathom what is going on with all these tens of thousands of kids coming into the country with no parent, no pillow, no bedroom. And then you watch this movie and you get a taste of it. And it's sickening, a bunch of perverts. This is because of illegitimate elections. Everybody knows Trump won. Everybody, even you guys. We got to fix it because our country is in peril, and it's not going to take much more to make it fail. And Esther 4, Esther went to the king for such a time as this. This is different than any other time. You have to do your part for America, not the left, not the right, not the middle of the road, for every American. Because what Georgia did turned this whole country upside down.
All right, thank you, Mr. Schroeder. Mr. Carnline, and then, I can't read this name, it looks like Opitz.
My name is Sam Carnline. I drove 250 miles from the Florida line down in Grady County to come speak to you guys for 2 minutes. Thank you. You're the state election board. The state election board. Y'all have authority. You have responsibility. And I thank you for sitting in that chair. When it was evident that we the people could have no faith in Georgia's current voting system, I sought audience with the legislature early in 2021. Representative Barry Fleming told me that legislators knew there was fraud in Georgia's election. 10 hours of citizens, election workers, and computer experts said so. The system was hacked into in real time during that testimony that Mr. Barry Fleming put together after the 2020 election. On page 12, at the bottom of the page, it says that the 2020 election was so fraught with systemic irregularities and voter fraud that it should not be certified. But yet we certified it anyway. We have problems in Georgia in our election, and there's a lot of people out here that believe that way. Judge Totenberg said that that we're voting illegally, that the QR code, that the people can't read it, and that we're voting illegally. House Bill 202 was a patch, not a cure. 2022 DeKalb County Spears race proves that. We cannot trust our elections in Georgia. Courts have stalled by saying we have no standing. The Haldeman report. 29 cybersecurity experts back the Haldeman report and refute the Matter report. CISA, and it's such a long thing, but y'all know all what I mean. They agree that we have major malfunction with our electronic voting system in the state of Georgia. And here's the fact. Many Georgians, many do not trust elections in the state of Georgia.
You need to wrap up. Excuse me.
We ask you to do one thing. We ask you to say one thing. That the Haldeman report and these other things, that y'all can tell us that we know, that it's impracticable for us to continue to vote on these electronic voting systems that have major malfunction. Thank you for your time.
Is this Ms. Opitz, is that right? Oh, I'm
I
sorry.
thought you called me. I thought you called Beth McCure. Did you not?
Well, after Mr. Carnline was supposed to be, what's your last name?
Mercure. Mercure, M-E-R-C-U-R-E. If you didn't call me, that's fine. I'll give him.
No, we'll take you out of order since you're there. Go
Well,
ahead.
thank you. Beth McCure from Cherokee County. I had a chance to listen to Secretary of State Attorney McGowan's statement from last month's State Election Board meeting. She stated numerous reasons the machines could not be patched together, updated, and that the hardware across our state would not work properly together. These are reasons that Georgia should turn away from our Dominion machines, just other reasons. The excuses she and the Secretary of State used to not perform these functions are mainly based in time and money. There are not sufficient funds to afford these software's updates timely. The counties will crumble under the financial demands to stay current in this cyber environment. Ms. McGowan stated there was not enough time to have the poll pads across our state interconnect. Won't this always be the case? There will always be a new update, new hardware. Our technology changes rapidly. We are less than 5 years into the Dominion suite, and we already can't stay properly upgraded and secure. After all these issues brought before you concerning distrust and proven manipulation of the machines, without proper hand counts to verify the machine totals, without recommended software upgrades to vulnerable systems, with padded voter rolls in which deceased voters show up across the state month after month in different counties like whack-a-mole. How can anyone, this board, look Georgians in the eye and say that we have the safest, most secure elections? Milton has proven that paper is not as costly. Machines do not properly certify our votes. Our elections have not been properly certified. Definition, guaranteed for accuracy. This is not on my notes. This morning, Ms. Johnson, you brought up the state complaint 188, in which a woman is with dementia. My mother died March 30th with excessive dementia. The state went and found a worker that no longer worked at an assisted living home. You pulled them off the street and you took their word over the family. That enrages me to the bottoms of my feet. You would have taken that worker's word over my word, the daughter who cared for her every day. How dare you? Shame on you.
Now, you are Mr.
My name is Michael Opitz.
Okay.
I'm from Cobb County, Georgia. The things that are important for our civilization and our society continue is adherence to facts, truth, the Constitution of the United States, the Constitution of Georgia, and speaking accurately. And you referenced, Mr. Chairman, that we are a democracy, and we're not. And you know that. We are a republic, and we just did the Pledge of Allegiance reference our being a republic. So we have to have facts, we have to speak to truth, and we have to have the knowledge to know of which we're speaking. Many of the people in this room are familiar with the Halderman report and the MITRE report. I assume, hopefully, that you people have read both of those. And if you had, you already know what we're talking about. If you haven't, and I would ask that you raise your hands if you have read it. If you have read it, raise your hands. Don't be afraid to speak up. You're volunteers as we are.
Continue, please.
But Judge Amy Tortenberg.
It's Totenberg.
Totenberg. Thank you very much. I appreciate your comment. She stated that the voting machines are not supported by Georgia law, the Constitution of Georgia, and that they should be removed. Nobody has done anything. No politician has stood up and echoed that. Now, you all have taken an oath of office, adherence to the Constitution, Georgia Constitution says the voting machines, any vote where the voter cannot read their vote is illegal. So all the votes that have been cast in Georgia have been illegal, and y'all should be prepared to resign to stand up for that.
And you need to wrap up.
I've just wrapped it up. You know what we're talking about. We're not telling anything that you don't know.
Thank you, Mr. Opitz. Appreciate your comments. Sarah Moneymaker. Sarah Moneymaker. Okay. And after Ms. Moneymaker is Tom Talbot.
Thank you. I am Sarah Lane Moneymaker, representing 53,000 voters from Chatham County, Savannah, Georgia. Patching Georgia's voting system will not secure our elections. A patch will not secure Georgia's 2024 elections, nor ensure the results. 1, the Halderman security analysis concluded it would be extremely difficult to retrofit security into a system that was not initially produced with such a process. 2, there's no evidence a vendor patch would mitigate most of the system security flaws identified by the Halderman report. 3, there's no evidence this vendor patch would rectify other Dominion counting problems, QR codes, detected in Georgia and Tennessee during the 2020 and 2022 elections. 4, a patch will destroy forensic evidence needed for court cases attempting to force the Secretary of State to determine whether or not our voting systems were secured. 5, estimates show that an upgrade would unnecessarily cost us Georgia taxpayers well over $37 million. My pockets ain't that deep. For new equipment, supplies, and procedural changes. To ensure the re-election results for each race are correct and detect any counterfeits, have hand-marked, publicly hand-counted paper ballots. Several counties will perform a 100% audit of all races by hand-counting ballots to ensure accuracy in 2024. Why can't all of Georgia do that? The best solution is to replace, not patch, the system that a U.S. District Court has already found in violation of two Georgia statutes with hand-marked and publicly hand-counted paper ballots. Honest Georgians want to protect our votes with full hand counts because it provides a secure, verifiable, accurate, legal, and cost-effective election process. Anything less is an insult to the integrity of Georgia voters. Hand-marked, publicly counted paper ballots, please. Thank you.
Thank you very much. Mr. Talbot, and then Dale Strickland.
Chairman and board members, thank you for your volunteer service. I can't add anything that's been said already. I can't add anything that's already been said. The message I'd like to bring to the board is I have attended countless meetings across the state on election integrity. This is just the tip of the iceberg of the lack of faith in your system here in Georgia. My question to you is, are you part of the solution? Are you part of the problem? And my question is, what authority do you have to bring all of these countless cases of fraud to a reconcile to where this gets fixed and we go back to a fair and honest election system?
Thank you very much. Mr. Strickland, and then Amanda Prettyman. Mr. Strickland, and then Amanda Prettyman.
Is that Dale Strickland you were calling?
Mr. Strickland, just
Speaking.
speak into the mic,
I'm
please.
Dale Strickland. I don't have a public comment to add to this, but I agree with most of what's been said. And hello? Okay. I agree with most of what's been said, and my comment was about another agenda item that's coming on here further, so I won't have any other comment, but I do follow along with what you're saying on the paper ballots, and I'll pass this along to the next person.
Thank you, Mr. Strickland. Ms. Prettyman, and then Mr. Prettyman, I'm sorry.
Thank you. We would like to return the vote from the government to the people. For the government runs our election, they program the machines right now, and it seems a conflict of interest. We would like hand-marked, hand-counted paper ballots counted at the precinct level and open to the public and poll watchers to view. But would you ever find it acceptable to count those ballots in a secret room? Would you advocate for that? All rational, democracy-loving people would say, no, of course not. Then why do we do it with the machines? The source code, which determines how our votes are counted, is secret. This is a violation of our most fundamental rights, the right to vote. Integrity is only ensured through transparency. We want a secret ballot, not a secret count. The count is secret. The workers are simply moving things around and doing tasks. They are not counting. And you might offer up, oh, but we do risk-limiting audits. But the Philip Stark report has already shown that that is not adequate for our system. This is the, where was I? This is integrity is only ensured through transparency. I have been on mission trips to Russia with Russian Americans who fled persecution. I saw where they were raided by police for meeting in the woods to worship our Lord Jesus Christ. Both religion and voting are two sacred forms of speech. A secret count violates our voting rights. This is one of the greatest civil rights issues and civil rights violations of our time by every level of government. By continuing on a system with no public confidence, the government is, you could argue, is ultimately engaging in voter suppression. And we are not a small minority. As Gabe Sterling tweeted, we are actually a silent majority, and more of us are becoming louder. I walk on Saturday mornings and speak to people in their yards, and when we speak about this, they all want this, because it's how our system was originally designed, to be counted by our friends and neighbors in their neighborhoods at the precinct level, decentralized. And so also, speaking about suppression, an engineer in Houston County, also concerned about our voting system because of his professional expertise and understanding of the vulnerabilities and the Halderman report and the CISA and all of this, recently spoke at his commissioners meeting of a colleague of his who is a 30-year veteran who is no longer voting because of this system. We have petitioned our government for many years now for redress of grievances to no avail. Look at all of these beautiful signatures just from Middle Georgia. Okay, there are tons of pages, and this was in 2021, asking for hand-marked paper ballots. And I really give a vote of no confidence to our entire government. We know what our laws are, we know we're violating them, and no one's done anything about it. And so it seems that Georgia is lawless, and our government is lawless, and the people are asking for our rights and
Mr. Prettyman, and then Mr. Gassaway.
My name is Stephen Prettyman, and I am from Bibb County. I'm from Bibb County. On the 29th of October 2021, I wrote this letter to my state senator at the age of 13. I would like to read it to you and now address it to you as well. Board members and Senator Kennedy, as a young citizen of the United States, I am becoming more and more aware about our freedoms, voting in particular. Our rights is what makes America great. The base of America is our votes. If we don't have free elections, freedom will become absent in our country and eventually the entire world. Think of our elections as the base supports of a tower. If the base support as the base supports of a tower, think of our elections as the base supports of a tower. If the base supports or elections became unstable, the tower will fall, with our rights coming crashing down just as they are starting to now. Senator Kennedy and board members, I know that your job is difficult, but if you don't keep fighting for us, our state will start to neglect our rights. In my opinion, I think that we should have an audit to make sure that we keep those who are in power in check. Now I am asking for hand-marked, hand-counted paper ballots. Thank you for your service and taking time to listen. Sincerely, Stephen Prettyman.
Thank you, Mr. Prettyman. Mr. Gassaway, and then Linda Mink.
Thank you. Good morning. I have a simple ask. I ask that you take State Election Board case 2018-104 off the table and refer it to the Federal Bureau of Investigations. I think we all are aware there's clear probable cause of felony criminal activity associated with Georgia law enforcement in that case. I think that alone justifies a referral to the Federal Bureau of Investigations. My team will take it from there. Ms. McGowan with the Attorney General's office has already met with us. She knows that we have the appropriate cause to bring a case, and I really believe this will move Georgia forward. I want to leave y'all with some hope. If we will take that case off the table, refer it to the FBI, my group will take over, and we will see some county commissioners indicted because of that case. Nothing could do more for the citizens of Georgia and our system than to send a message to the 159 counties they have to do a better job following the law. I've read where some of you have lamented that you can't make county governments follow the law, and certainly I know that. We have felony criminal activity in the election office in Banks County and Franklin County today while we're in this meeting, and the Attorney General knows it. So what we've got to do is get the feds involved, and this case is the perfect case. I promise you. I spent hundreds of thousands of dollars litigating my two successful election challenges. I am the only person in the history of this state to throw out 2 elections because of corruption. I didn't go looking for that. I had supporters whose my name was not on their ballot. Nobody has ever explained that. Dozens of supporters who my name was not on their ballot in Habersham County. Habersham County today is the most corrupt election office in the state of Georgia. These are Trump counties that are corrupt. Banks County, Stevens County, Franklin County. I have proven this in a court of law. We need to get the FBI involved. State Election Board case 2018-104 is the right case to do it. I promise you, Ms. McGowan in the Attorney General's office knows. We've met with her. She knows we've got the felonies. We just need to find a prosecutor. The district, and I'm sorry, to conclude, I will be testifying in a big federal case that's ongoing in the Northern District of Georgia. It's a voting-related case, and I'm going to be laying out all these felonies to a federal jury. The end of that story is this case was tabled by the State Election Board in September of 2020, never to be heard from again. I want to leave that federal jury after they've heard me talk for 4 days about felonies in the election system that have gone unchecked. I want to leave that federal jury with some hope. The hope is the State Election Board referred the case to the FBI where it belongs, and maybe we're going to hold some people accountable for this horrific corruption. I appreciate your service to the citizens of Georgia. My team will do anything we can to help you, and I've got the best team in the state. Thank you.
Thank you.
Linda Bink, Coweta County, Georgia. I'm really glad I came here today. It's the first time I've ever attended a state election board meeting. But Chairman Duffy, I got to hand it to you. You laid something out for me very clearly. When you said you're all volunteers, that means you're order takers. You're taking orders from no, you let me speak. You take orders from Governor Kemp, Ratsberger, and Chris Carr. And they're as crooked as a dog's hind leg, and everybody in this room knows it. All you are, we sat here and listened to the cases that you dismissed, and I applaud the lady who spoke a few moments ago about her mother who died of Alzheimer's and the condition she was in. So did mine. That is a disgrace that you dismissed that case. How dare you? The other thing I'd like to admonish you on is that your prayer, the invocation, are you kidding me? I think the only thing you left out was Satanism. Why didn't you include it? In closing, I attended the Coweta County budget hearing last Tuesday at 3 o'clock. Our Board of Elections had the unmitigated gall to submit a proposed budget increasing their budget by 70%. 70%. You know why? So they could go buy more voting machines. So, I mean, that's pretty much all I got to say to you. That you guys are a joke. Thank you.
Thank you. Tess Sharp, and then Mark Swanson. Tess Sharp. If people would stop talking, they could hear what we're saying. Tess Sharp. Is she here? Tess Sharp.
Hello, Tess Sharp, Forsyth County. Thank you for your Tess Sharp, Forsyth County. Thank you for your service. Kind of a hard act to follow on that. I noticed that in hearing these testimonies, I would just like you to turn around and look at this room. People, if you believe that we need a new voting system, please turn around and look at this room. We are asking you not as one side or another. We're asking you as citizens of Georgia to take a very eagle eye to what we are doing to our democratic but republic system. And we are a republic that uses a democratic system to vote. That is it. And we are asking you to look at what is going on. Not this many people show up to sit there and comply with the decisions that this board has made. If everything was running well, we would be home. We wouldn't be here. And not just us, but people on YouTube that are watching this, and everybody in this room. I implore you, do not leave this morning and think it is taken care of. You need to contact all your state reps, your election boards for every county, and have them put the pressure and the facts in front of this board. We're asking you this morning to please fulfill the oath. We know you're volunteers, as it was pointed out to us earlier this morning, but you are also took an oath to take a look and serve the state of Georgia. I thank you for your time this morning. Remember, when you go home, do not leave this here on this floor today. This is only the beginning, shall it not be?
Mark Swanson, and then Cheryl Wall.
Thank you for allowing me to speak. My name is Mark Swanson. I'm from Rome, Georgia. In November of last year, I received 2 letters dated November the 22nd, 2022, from Sarah Koff, the lead investigator of the Georgia State Election Board. The letters referenced SEB cases 2021-134 and SEB case 2022-007. In both cases were recommended by Sarah Koff and her investigators for dismissal with no violation. However, the letters note that the State Election Board makes the final decisions on all investigations. The State Election Board Chief Investigator, Sarah Koff, then closes those official letters with the following statement. Your attendance is not mandatory, but should you attend, the SEB, State Election Board, will provide you with an opportunity to address them about your case. You guys may remember this. However, in email exchanges with Mr. Duffy and the SEB members, Mr. Duffy seemed to imply that I was not allowed to speak to my 2 cases up for decision at the 12/13/22 meeting. So on 12/9/22, I emailed Mr. Duffy asking, are you saying that I'm not allowed to speak to my complaint during the meeting? To which Mr. Duffy replied in writing, in an email, that is correct. I am not allowed to speak to those complaints unless a board member chooses to ask me a question. Mr. Duffy went on to say that I may also sign up to speak at the 2 minutes of public comments at the end of the meeting. That period will be after the complaints are completed. It should be noted that every email I sent to Mr. Duffy during that lengthy exchange, I copied every one of the State Election Board members. Some of you I know. Why would you refuse my constitutional right to speak about the 2 cases that were being adjudicated by the State Election Board when your lead investigator and all your prior transcripts and meetings and videos say that I could, including meetings where I spoke to other cases? But then this particular case, this board elected not to allow me to speak to those 2 cases. And the question is that you guys should be asking is, why did they want me to speak to my 2 cases that they dismissed without even discussion? There's a question there that you should be asking, and the answers will be forthcoming. Thank you.
Thank you, Mr. Swanson. Cheryl Wall. Cheryl Wall. Cheryl Wall, this person.
My name is Cheryl Wall from Floyd County, and I have 4 questions for the board.
Number one, how does the public know if the ballots in storage are the same ones that got run through the scan-it ballers on Election Day or advance voting? Number two, what does the Georgia election law say about the role of ballot scanner tapes, both zero tapes and end-of-day tapes? And I'm specifically referencing OCGA 21-2-495 and OCGA 21-2-493. Question number three, what does the Georgia election law say about discrepancies between the ballot scanner tapes and the actual ballots? And furthermore, how does such an election get certified? And probably my most important question, what if a county were missing over 60% of the ballot scanner tapes for votes cast during a past certified election? Despite what you may be told from your higher-ups, the truth is in this room, and it's even across the street from the folks that weren't even able to stand in this room. We need transparent, hand-marked, hand-counted paper ballots, no QR codes, no Dominion machines. None. Thank you.
Ms. Roberto, and then David Cross.
My name is Norma Reoredo. My parents were exiled in Cuba, from Cuba. Lost everything. You all have businesses, houses. Well, guess what? And you have a nice seat. All that is gone in one flash. I was born and raised here, first generation. So it flows through my blood. And I appreciate this republic under God, and the only one there is. We have a situation, and those individuals that have been through situation of totalitarian in this world, which there's a lot, which this republic has brought them in, and we appreciate it. My parents, mechanical engineer, doctors, attorneys, that's our family. But we worked our ass off to receive it. There is no other country of this world that you get exiled. This is it. This is it. And if all of you do not get that guts in you to do something, we're going to lose it. Because my mom, 81, or actually 82, she's seen it. She's still living. She is so worried about this because all the signs are there completely. My dad was very involved in politics in Dade County, understands it very well. He saw already the corruption in the 90s. We're now in 2023? Communism is a bite at a time, and they have placed everything in place. We are citizens. If the government doesn't do anything, believe me, we are going to do it.
Thank you. Mr. Cross?
Board members, I'd like to extend an olive branch to you today, as I've come to realize that you are not the bad guys in election security. It's the Secretary of State. You've been given the nearly impossible job of policing our elections while seeming to have no real enforcement authority when things go wrong. As you're aware, Governor Kemp validated mine and Mr. Rossi's work in his 42-page letter to the Secretary of State, and yet the record has not been corrected to strike the audit from the official record. And to be clear, it seems that this board's chair today admitted that he asked members to vote on the consent order for the case 2021-181 without reading it. I have called, I have written, I have emailed, I have texted the Secretary of State to discuss what has been found in Georgia's Swiss cheese of an election system. Instead, I have endured unlawful blocks by Raffensperger's office directing counties to deny my lawful open records request. The state has blocked the citizens for 2 years in our efforts to perform an inspection of paper ballots in Fulton County. Several of my complaints fell through the cracks, including my question of 315,000 votes that were tallied in Fulton County on the same 6 scanners with unsigned tabulator tapes in violation of Election Procedure 183-1-14-.02. The Halderman report, which is spoken about today, was sealed, and Raffensperger read it, and he knew what was going on, and he did nothing to protect Georgia's voters for 2 years. In October 2020, Dominion's Director of Product Strategy and Security said, "Our stuff is just riddled with bugs," and he admitted, "Our products suck." That's in quotes, that's him. According to a recent open records request, the brand new Jarvis system has 3,500 bugs in it, so much that it would take the Secretary of State 90 days to write it up. None of this inspires confidence. Several years ago, Democrats pushed to eliminate the touchscreens. Today, Republicans agree, but we also want the poll pads in the garbage too, along with the scanners. We the people want transparency. Civilized nations hand count their paper ballots. Australia, Canada, Finland, France, Germany, Ireland, Japan, the Netherlands, Norway, Spain, Sweden, and the UK. For the benefit of election directors here today, I want you to know that Georgia Code 212334 allows you to use paper ballots when the machines are impracticable, and the Secretary of State can do nothing to stop you. Almost done. 212379-2-C reads that if the voting system has problems with accuracy, approval of the system shall immediately be revoked by the Secretary of State. Please make that motion today.
Thank you. Mr. Hess, and then Ms. Flannery. Mr. Hess, and then Ms. Flannery. Is Mr. Hess here? Yes. And Ms. Flannery, you want to come on, walk on up?
My name is Max Hess. I'm from Fulton County. In one mass voter challenge I attended, a woman defended her registration, saying that she had used a P.O. box because she was homeless. She also said that she had used a P.O. box even before she was homeless, on her father's advice, as a way to avoid stalkers. Other women who were defending their registration that day made the same point. In another challenge, the focus seemed to be on addresses that doubled as a business address. A later challenge showed that even the challenger had a home-based business. This board has the ability to give guidance to the county boards, and here are 3 proposed reforms to make these mass challenges less burdensome. One would be to put the burden on the challenger. Another one would be to require the challenger to share the challenger's data source with board investigators. And a third would be to create the ability to dismiss bad faith challenges when there are maintenance procedures already in place. Thank you.
Well, thank you, Mr. Hess. Kimberly Flannery. All right, thank you. Lindsay Hollenbeck and Diane Van, and then Sandra Martin.
Yes. In the event, some of you remember back in 2000 how they made
Speak
a
up
big.
more into the microphone.
I'm Diane Van, and from Bibb County. Can you hear me now? You may remember back in 2000 how the hanging chads, they made such a big deal of the hand counting in Florida, and there were hanging chads, and it was so difficult to get the right votes with those paper ballots. I just want you to know that Garland Favorito of voterga.org has found that they were not using the standard of paper they were supposed to be using when they did those hanging chads. So that was just to get people involved in wanting the machines. I, Diane Van, ran in the Georgia Republican primary for the U.S. House of Representatives in 2010, 2014, and 2016. And I've included this handout at the back of the book that I've given each of you. This is my book. When researching for my book, Undermining the U.S. Constitution, a copy of which I am giving you today, I learned about the elections being stolen since the year 2000 with Dominion's predecessors. Please read pages 122 through 128, which include my lawsuit against the state treasurer, my response to the defense attorney's motion to dismiss my lawsuit, and the judge's decision to dismiss. I know you have a lot of time that you won't have, so just limit it to those few pages, 122 to 128. And I have a few extra copies for anyone that wants them here today. Thank you.
Thank you, Ms. Van. Sandra Martin. And then Julie Allen.
I'm Sandra Martin. I'm from the 6th District in Cherokee County. I want to ask the board a question. And I realize it may end up very rhetorical, and I may not get an applicable answer here today. So in the light of that, and with respect, what do you have to lose by listening to the people that you serve? What do you have to lose by serving the people that by listening to the people that you serve? What is it that seems to have you lined up in submission to agree to continue to use voting systems that have been proven fraudulent? Would any of you state here and now any reason why paper ballots, hand-marked and counted at each precinct, would not be a good idea? What do you have to lose? And addressing the prayer that started this whole thing out, that was a non-prayer, and it included non-gods. And I believe God has me up here to warn you. He will not take blasphemy lightly. Be warned.
Julie Allen. And then Denitra Cotton.
Thank you for hearing my concerns. My name is Julie Allen, and I'm a City of Atlanta resident, and I come here independently of anyone else to offer my comments to you and appreciation for your... Thank you. Thank you for your consideration. Election integrity is not a partisan issue. Polls show that distrust in elections is real. According to a recent Rasmussen poll, only 25% of voters believe the correct person was declared president in both 2016 and 2020. Trust in the electoral process is vital. Patching Georgia's voting system will not secure our elections. While Georgia politicians may advocate that Georgia's Dominion voting systems be patched to address massive security and inaccuracy concerns, a patch from version 5.5 to 5.17 will not secure Georgia's 2024 elections, nor ensure the accuracy of 2024 results, because the Halderman's security analysis, as others have referred to, concluded that it would be extremely difficult to retrofit security into a system that was not initially produced with such a process. There is no evidence a vendor patch would mitigate most of the system security flaws identified by the Halderman security analysis or would rectify other Dominion counting problems detected in Georgia and Tennessee during the 2020 and 2022 elections. Ballots would continue being counted secretly by tabulators and then sealed after certification so voters would never be able to determine accuracy of any election. Estimates show that an upgrade would cost Georgia taxpayers well over $37 million for new poll books, printers, supplies, and procedural changes. A simple solution, the common sense solution, is to hand count hand-marked paper ballots in public at polls and processing centers to ensure election results for each race are correct and to detect any counterfeits. 2 counties have already decided to perform a 100% audit of all races by hand counting their ballots to ensure accuracy of their 2024 results. Why shouldn't the state do at least this much to improve the security of Georgia's 2024 election? Please direct the Secretary of State with a motion and vote today by this board to replace the system that a U.S. District Court has already found in violation of 2 Georgia statutes with hand-marked, publicly hand-counted ballots. Recent studies show the time it takes to hand-count all hand-marked ballots is slightly more than the time it rural
Ms. Allen,
counties.
you need to wrap up.
Most Georgians want to protect their votes with full hand counts because it provides a secure, verifiable, accurate, legal, and cost-effective election process. Anything less is an insult to Georgia voters, and I ask you with deep respect to work with the Secretary of State, the legislature, to accomplish this on the behalf of Georgia citizens. And I, too, was my mother's legal guardian from 1994 to 2015. And I will simply say it was my fiduciary responsibility to assist her with her vote. I would never trust the activity director, the social services director, without giving my permission because of their influence to execute a vote. And I support board member Dr. Johnston and her concern on that issue today. Again, thank you.
Thank you, Ms. Denitra Cotton, and then I think it's Sean Cotton after that. Denitra Cotton. Sean Cotton. Anna DeBlanc. Fine, thank you.
Thank you. My name is Anna DeBlanc. I'm from Butts County. I've been in the state for 15 years. I got active after the 2020 elections in going to stop the steal votes and the rallies and all that sort of stuff. I became a poll worker. On our first meeting where they were doing our training, they said, oh, don't listen to that about being on the internet. The machines are not on the internet. However, they are Bluetooth capable. I'm like, wait a minute. If the machine is Bluetooth capable, the machines are on the internet because that's, you don't just plug it in, it's over the wire. So that's what they had, what was, they were talking about. So as a worker, I have people come in, voters that say, keep it safe. Do your best to keep it safe. I'll do I can, but I don't know what the machines do. And I do question the validity of the Aztec that's on our voter ballots that come out. We've had jams on some of the machines that we fixed. We had, but anyway, that was a minor fix. So many of us don't trust the machines. We would feel better if we were go to the verifiable hand-counted ballots. Then we would have Democrats and Republicans together counting and verifying that our votes are truly our votes, that we're not being manipulated by the machines, because we don't know the source codes. We've had years and years of complaints against the machines, and then we have the Haldeman report. So I just ask that you get rid of the Dominion machines and even the ERIC system, because it's just not something that really is doing its job. Thank you.
Thank you, Ms. DeBlanc. I told you that we were going to take lunch at 12:30. It's 12:30. We will take an hour for lunch, reconvene at 1:30. First of all, let it ring only twice, and then cut it off, and then I'll be responsible for saying stop.
And by the way, you're quite wrong. You they don't hate you. They hate.
Okay, can I have your attention, please? Can I have your attention, please? All right, I hope you had a good lunch. We are back in our meeting. We are hearing public comments, and the next person to speak is Andrew. Is it Bowl? Bell. Andrew Bell. And next to Cindy Battles.
Good afternoon. Had no idea I was going to be here today. Well, I did because you guys sent me that summons. I guess we'll get to that later. But had no idea about the movement at all. But I don't care if you all the way to the left or all the way to the right. I don't care if you're black, white, Asian, whatever. We got to get this thing straight. I don't know, is there a report about the DeKalb County one? I see all of these guys here with the Spears. She finished in last place on election night with the machines. And then she ended up, she's the commissioner now. So how did that happen? Oh, yeah, hand recount. Oh, okay. So the paper and the machine is different? Huh? Paper in the machine is different? We're not investigating that? And then I see all these other DeKalb guys. Yeah, somebody was saying the FBI, send them over there. I mean, these people, I've had a lot. In 2020, I ran, my campaign was bringing integrity back. Bringing integrity back. I've been defrauded by the Secretary of State. You know I'm suing him. And Chris Harvey. We're in the 11th Circuit Court of Appeals right now. And use these mics. My dad was here representing me last time. He's got hearing problems. He said he just could see you guys' mouth moving. He didn't know what you guys were saying. Or for the hearing impaired, have it when you're talking where they could at least read. I'm sick of this. I'm sick of the corruption. I'm sick of these lawyers getting paid, knowing what's going on, ain't doing nothing about it, ain't honoring their oath. I'm sick of these appointed people getting paid all probably behind the back. What's going on? Are you supporting somebody that's your friend, that's your buddy? If we don't have integrity in these elections, we don't have a country. I served in the U.S. Marine Corps. I served beside patriots that died. Look, I'm black. Hey, I'm blacker than anybody else. Look, we just got the Civil Rights, Voting Rights Act in 1964. So I want the same thing as everybody else. That's equality, equity.
You need to wrap up. Your 2 minutes has expired. I'll give you a couple seconds.
Let's get a clock up here next time too. I know we spending all these billions of dollars in this state. Can we get a time clock up here? I buy one. It's $20.
All right, the next is Cindy Battles.
Sorry, maybe a skirt. It's not a good idea. I'm going to make sure I tie myself. Members of the State Election Board, my name is Cindy Battles, and I am the Policy Director for the People's Agenda, and I am going to use a couple of my 2 minutes to tell you thank you for your service. I have been doing this work since 2016, and I understand the amount of work that y'all put into all of the things and making sure that our elections run smoothly. I want to very quickly talk about three things: election funding, poll worker training, and voter challenges. Number one, I have preached this, and I know that you feel the same way, Chairman Duffy. We do not fund our county's elections to a way where elections are going to be safe and secure the way that we want them to be. We brag constantly about the fact that the number of people who are registered to vote is increasing. We've seen 3 counties in the last 2 weeks consolidate polling locations. Considering the fact that Governor Kemp did a line item veto and make counties pay for the new check-in systems, less polling locations, more voters are going to be lines in 2024. We have got to, as the state election board and citizens, push the governor and the Georgia Assembly to fund elections. Number 2, we've got to do better about training poll workers. I'm asking y'all to put something together for that. We know that there were hundreds of out-of-precinct provisional ballots that were not counted in a number of counties because poll workers weren't trained the way that they needed to be after SB 202. And then the third thing, these voter challenges, I know that y'all are working on guides. I'm going to ask that those guides be stringent because the amount of work that election staff are having to put into this is daunting. And we are losing election staff on a regular basis, not just in Georgia, but nationwide. And finally, as a member of a military family and the mother of a Marine, I'm going to remind people that the First Amendment exists, and the same thing that allows you to come up here and spew whatever you want to say, it's the same thing that allows people to worship whatever faith they choose without being scared. Thank you.
Is there, who's in charge of all, whatever is popping up on the screens? How is that happening? So every now and then a blue thing comes up and goes off, and then another. Can we turn that off? Does it just come up? I feel like I'm in a disco.
Oh, this is just locking it in place.
Okay.
Oh, it should be fine.
Lonnie Hollis and then Ted Metz.
I'm Lonnie Hollis. I'm from Troup County, and I'm here because I am so disappointed with the system. I was here in 2018 on an issue that was sent by the State Election Board to the Attorney General. I have been trying to find out information about this case all these years, and no one would talk to me. I've gone to the Attorney General's office, and no one would see me. So I understand from my chair of the commission in Troup County that the Attorney General said he was not going to touch this case. You know, why not? We need answers to some of these questions. What was going on is that we had an election supervisor. The election supervisor was also the registrar. A complaint was filed against it back in 2015 by a person other than myself that was on the election board. She's deceased, but this case should have been, we should have known something about what was going on with it by now. And after all these years, you know, what's going on? I'm a taxpayer. I pay taxes. So some of the money that's coming out of the taxes I'm paid is being paid to the Attorney General. So he should be able to answer to the public. So hopefully, you know, we can get this resolved, and the election board will try to push whatever issues they are sending to the Attorney General to find out whether those cases have been resolved or not. Thank you.
Wait, wait a second, Ms. Hollis. Do you have a case number for that?
Yes, that case number is 2018-111.
Sorry, 2018 dash what?
111. I think
And
that's
so
it.
you never received any notice that that was?
I never
there was-
received any information, and I've also called, wait a minute, I gave you the wrong one. It's 2015-029.
2015-029?
Yeah, I called several times, and I could not get an answer as to when he was going to rule on it, but I didn't get any information back.
All right. Well,
And as a matter of fact, the person that complaint was filed against, he is still the registrar. The county commissioners had them to put on the online that the board is the registrar. The board cannot be the registrar. They're not trained, and they don't have access to the office.
Right.
And the other thing is, the office now is closed. You can't, even the election board members can't go in just on their own. They have to either be called back there one by one, but they don't have access to the office. And the only person that sends out any information about the elections or information you may need, it can only be sent out by the supervisor.
With that, stay there for 1 second. I want to ask the investigators and Alex to go through and see what the status is of 2015-029. Sounds like maybe it was referred to the Attorney General's office, so Beth, if I could ask you to see whether or not it's somewhere within the office and report back to us what the status is, so that maybe we can get back to Ms. Hollis.
Yep, and could get her email so y'all can get back to her as well.
Right. So if you'll leave your email address with one of us, we'll be able to communicate with you about what.
Okay, you
what
want me
we-
to tell you my email address? It's
Yeah.
L.
No, don't do it publicly.
Okay, I'll give it to you. Thank you.
So Ms. Hollis, just come over here, and Alex, would you get her email address, please? Okay, now Mr. Metz and then Gail Lee. Gail Lee and then Kelly Persons.
Gail Lee, DeKalb County. At the board's last meeting, I encouraged you to provide counties with uniform guidelines for handling various common issues in voter registrations that can be handled administratively. Today, I'm asking you to pointedly and specifically to advise DeKalb County on those issues. Mailboxes are not residential addresses, but DeKalb's board has rejected all challenges to registrants who provide the street address of a post office or UPS store for a residential address and their box numbers characterized as an apartment or a unit. If the challenges had been upheld in the spring of 2022, the UPS case that will be brought before you today would most likely not be taking up your time. And if you advise them now, future cases can be avoided. All challenges brought before the DeKalb board have been denied, whether it be mailboxes, NCOAs who registered to vote in another state, or incomplete addresses. At one of the challenge meetings, one sympathetic board member actually advised us that it was useless to bring challenges because obviously the vote would always be 3-2, not in our favor. The citizens of DeKalb County really need your help to ensure that only qualified citizens can vote and vote only once. And for that to happen, the rolls need to be cleaned up, which is unlikely without pressure from this board. Our time is limited. We have only until the first week of December to remove ineligible registrants before the March primaries. Thank you for listening. I pray that you will also do something to help us.
Well, thank you very much, Ms. Lee. I want to request DeKalb County for the next 4 months to advise us when you have hearings on challenges so that we can have somebody attend. Will you do that, please? Thank you. Kelly Persons.
Thank you, Mr. Chairman, member of the board. I'm Kelly Persons with the League of Women Voters of Georgia. Wanted to highlight something positive that I think you all can make an impact on, and that is multilingual ballots and voter education material. We have some really great counties that are leading the way on this, and we think anything that you all can do to help spread this to all 159 counties at once versus counties by county doing this for themselves.
Can you tell us what counties are doing that already?
Sure. So I know that Gwinnett and DeKalb County already have multilingual ballots and or voter education. My understanding is that Clayton County is looking at it, and we're hoping that some additional counties will jump on board with the right encouragement.
And can you tell us what languages it's being translated into?
That is more of the sticky wicket. I know a lot do English and Spanish. Gwinnett just recently expanded out to various Asian languages. DeKalb County, I know that the Board of Elections is looking at which ones to include, taking public comment and feedback as to what are the most common languages. The city of Clarkston has a wild population, so I think one of the things that they're looking at is including some very smaller languages, but have larger impact on their specific community that they serve.
Thank you, that's helpful.
Thank you.
Appreciate it. Carol Garcia. And then Pamela Reardon. At the end of the day, we're going to have penmanship lessons. I wish there was one.
It's Garcia, sir.
Garcia, I'm sorry.
My name is Carolyn Garcia. I live in Cobb County in Kennesaw. And I have been a poll watcher / poll worker for more than 30 years. Started out as a poll watcher, been active in politics since 1976. And then in the last 12 to 15 years, I've been a poll manager. And I have to tell you, I came without really notes today because I'm just going on what I have observed. I've never in my lifetime met people from across the spectrum, black, white, Latino, whatever, that are so concerned about the elections. I had people coming to me when I was poll managers. I'm actually assistant manager, so I don't want to mislead. And they would say, why a QR code if we can't read it? And I said, well, you know, you can't use your cell phone in here, and it's not allowed, and so you can't read it. And then I was told outside of that they couldn't read the QR code even if they were to take a picture. The problem is, and that's what I'm finding across the board, is people are saying, we don't know. We look at the ballot, but we don't know if that QR code is really saying what my ballot is telling me that I'm reading. And then we don't know that that QR code is lined up with when it gets back to the county office and in the state. And so this is a real concern, and I've never seen people so disheartened. Someone mentioned earlier about the fact of people not signing up to be poll watchers. They asked me to be a supervisor of an area, and I just wouldn't take it on because it's just so hard anymore to get people because they've lost faith in the system. And I want to go to, if they could fix those kind of things, we might even consider wanting those machines, but I believe they still can be hacked. Let me finish.
Yeah,
they still
let her
can
finish. That's rude. Nobody has interrupted anybody else. Let her say her piece.
Wait, because you didn't finish. Let me finish. But machines of any kind can be hacked. We know that beyond a doubt. And so therein lies the problem. Now, to paper ballots. I don't have a problem with paper ballots, but you have to have a standard. I worked on the voter review panel after the 2020 election. I could not believe what I saw. I had a supervisor over the table that I was at stand there, and I had 6 ballots, and I've testified on this. I had 6 ballots in a row from absentee ballots. They were all identical, all the same mistakes, a handwritten name written in 2 places on the ballot, same handwriting, same ink, and yet I said, this is not legal. I can't judge this person. How come 6 ballots are coming in here right in a row? And I kid you not, she said back to me, well, it was probably a group of students this their first time voting, and they got together and let one person do it. I said, that's illegal. You can't, how do we know what is going on outside of that? So if I don't know that I could hold my breath long enough to believe that we're going to get paper ballots. I might be little girl blue then. But the fact of it is that if we're going to go to paper ballots, which I'm all for, have a standard that cannot be compromised, cannot be misused, and the absentee ballots, there has got to be something done about those. I was just appalled at things I saw. I saw within the election itself, a young woman come in. She had, okay, I'll finish up real quickly.
Finish that story.
She came in and she showed a copy of her driver's license. And so I questioned her and I said, you know, well, this is not your driver's license. Well, I made a copy of it. And I said, oh, and she was very young. And I said, well, are you a student here? No. I said, are you working here? No. I said, so your purpose for being in Georgia from California? Oh, I'm visiting friends. I said, dear, you cannot vote here. You're not registered to vote here. But my driver's license says I can vote here. And I said, no. And they let her go and do, the write-in where you have to put it in your sealed envelope. I called the office. And I told them, and I wrote everything down on that thing before she put it in that envelope because I wanted them to know that this was a person voting illegally from our county.
Thank you.
Thank you, sir.
Appreciate it. Pamela Reardon, and then Jean Gabriel.
Good afternoon. Whoops, sorry.
Jean Gabriel is next. Thank you. Excuse me.
It's okay. Good afternoon, board members. Thank you so much for serving. I know it's got to be excruciating hard, especially today. But my first question is, if you're a citizen, why do you have to have a ballot in a different language than English? Because I'm from Canada originally. I had to become a citizen, and I had to take a test. And I know my English is English, or but you have to take a test. So if you become a citizen and you're legal, you take a test. Why are names different in Chinese, Vietnamese, whatever, Latino? They're all the same. That's my question. And the people who complain about how our elections are so costly, that's going to add a lot. I'm just saying, Jarvis, I can't believe that we're even talking about this because it is messed up. The election supervisors in most counties are saying that, so you have to listen to it. We are so close to a really important election. Something has to be done, and it has to be done now, so you have to haul in the SOS here, and you have to get answers. That's all I'm saying. The contract, originally, I was around for a long time, 2017 in the Safe Commission, 2019 from SB 316. In that contract, we're not supposed to have QR codes. We're not supposed to have a closed system. We're supposed to have an open source system. And the maintenance fees that we're paying every single year should have included upgrades to the software so we're not faced at the last minute the problems that we're having. I'm not advocating for that or nothing. I'm just saying the facts, okay? So we need the voter rolls cleaned up. We are going to be releasing from a data forensics company all the problems in the voter rolls, and it's going to be done shortly. So I know the Secretary of State is running the voter rolls, but the amount that they're running to take off potentially is minuscule compared to the amount that should not be on the voter rolls. And then I have it directly from the Secretary of State's office. The counties are responsible for cleaning up their voter rolls, folks, and they're supposed to do it all the time. So when we come with challenges, oh well, you got to do your job, but we actually have another bona fide software that can help them. If we can partner up with the counties, and we can help them do this, everybody together, okay? So we're not going to have this problem. So next thing, chain of custody. We had a bill, HB 17, last session, which dealt with chain of custodies. Chain of custodies have to be consistent among all the counties, and they have to do that. So if they have the proper chain of custodies for the ballots and everything else, we're not going to come into a lot of these problems. The third thing, retention and preservation of the ballots. They should not be sealed. That was House Bill 426. We did have Democrats on our side for that because they can see what the cost is to go to court to get that changed. Fourth thing, which is really important, which you demonstrated today,
and we need
vulnerable voters. The seniors are vulnerable in our homes, and we need some new regulations about them voting or having to have their, I'm wrapping up, sorry, have their caregiver vote, not the people who work in those systems. We need those things. Thank you.
Thank you. Mr. Gabriel, and then Maria Gaudio.
Mr. Chair, board members, my name is Gene Gabriel, lifetime Georgian, tech class of '93, electrical engineering. And I wrote this. I come before you to advocate the need to make a permanent move from voting machines to paper ballots. There's a mountain of evidence that voting machines are not secure. Just one example is the testimony of computer programmer Clinton Eugene Curtis, who wrote a 24-line program that was used to hack the 2004 Bush-Kerry election count in South Florida in favor of Bush. This isn't a fantasy. He, Mr. Curtis, testified to this during the U.S. House Judiciary Committee public hearings on 2004 election irregularities. The common thread that is revealed through all these instances of fraud and hacking is that the poll workers, and even you as the board members, would be clueless that the hack had occurred. As a voter, I do not blame the poll workers, nor do I blame these hacks on you, the board members. I blame it on bigger players. A hack changes the source code, the totals that are reported, and the logs, and only by inspecting the source code can one confirm the hack. Unfortunately, Dominion will not allow access to their source code. As such, I do not have confidence in our election process where voting machines are involved. As a Republican voter, I am not alone. Many Democrats don't have confidence in voting machines either. I can show you a montage video, and I will send you an email with that. You're welcome to watch it. A montage video featuring prominent Democrats challenging the security of voting machines used in the 2018 elections. They include Amy Klobuchar, Adam Schiff, Sheila Jackson Lee, Val Demings, Jennifer Wexton, Ron Wyden, Ted Lieu, Mark Warner, and even Vice President Kamala Harris. Last bit, this is not a party line issue. Whether they realize it or not, both parties have been affected by voter fraud. Let's unite as citizens of Georgia and raise the standard by returning to a paper ballot system. Let's come together as Americans first and have civil discussions to evaluate this issue so we can be confident that our votes will count as intended when we cast them. Thank you, members.
Thank you, Mr. Gabriel. Maria Cadio, and then Michelle Cobb.
Hey, thank you. Maria Gaudio, representing myself. I think we all, if many of you are retired here, but have all had 9-to-5 jobs, where if the company has new software and there's a glitch, you might give them one chance, maybe two, but definitely not three, and you're buying a new product. We know from the Haldeman report, first in 2017 and then 2 years ago, about the plethora of problems. The recent Haldeman, 96 pages of problems, and yet they still keep it. And it kind of makes it suspect. Maybe the thing is doing what it's supposed to do, cheat. And so the people who want this are fighting it. They want to be able to cheat because that's how they stay in office. I have witnessed cheating. 2 years ago over here on Mitchell Street, I saw tens of thousands of ballots stuffed into approximately 16 vans. The vans had only a little bit of stuff on the floorboards, and they were stuffed in what could take, in the time that it would take a traffic light to turn, which is 3 minutes. The longest traffic lights in Fulton County are 3 minutes. So tens of thousands of ballots were stuffed. And the chain of custody, they would not let me participate in the chain of custody that I was trying to follow, as well, there were a few other people that saw what I saw. And, but many other people did not follow the chain of custody, and that's how really they got away with it. But it was on Mitchell Street to the side building of what ended up being the 130 Peachtree front. How did they get away with that? And that has to do with not keeping the voter rolls clean. If you allow dead people, people who have moved away, people who are living in other counties or other states, and they continue to vote on our voter rolls, that's how they got away with it. So I was a witness to that. Again, paper ballots only, safety paper, no machines, not even the printers, no negotiations. Thank you.
Thank you. Michelle Cobb, and then Kay Arofi.
My name is Michelle Cobb of Spalding County. In the great state of Georgia, we seek to conduct our elections fairly in a manner that is truly transparent, verifiable, and secure. I'm here today to ask the State Elections Board to act on behalf of the people of Georgia by resolving to abolish the mysterious, unverifiable, illegal in some aspects, unsecure, vulnerable, and hackable electronic voting machines that function in capacity to suppress our votes. Webster's dictionary defines suppression as to put down by authority, to keep from public knowledge, to keep secret, to stop or prohibit the publication or revelation of, i.e., suppress the election results. That is exactly what Dominion machines do: violate transparency, security legislations, and also it could be viewed as what our SOS allegedly proliferates by refusing to take action to mitigate the known vulnerabilities in our system. This is not a partisan issue. The vote belongs to the people, and we the people deserve the right to see the ballots and to watch them be counted. Every voter deserves to know that the process is free of secrecy, hidden source code, backdoor access to electronically flipped votes, illegal QR codes, and foreign interference. Not seeking resolve, well, that fits the definition of suppressing our valuable votes. Our SOS tells us our systems are safe and secure, even though he's known for years that our current electronic voting system is anything but secure. In fact, most recently, polling pad machines across the state have been replaced with cellular polling pads. However, these new devices are not compatible with the latest security update 517 between the BMDs and the cellular polling pads. Raffensperger has specifically stated he will not do anything to correct this haphazard national security risk until after the 2024 elections. We all know that Georgia has been a swing state in recent years and has been the single state to determine the future direction of our country nationally. As a state, we cannot fail our country in our critical federal elections in 2024 like we did in 2020. I plead the State Board to abolish electronic Dominion voting machines and restore a secured system, whatever that may be, that is 100% transparent, accountable, and verifiable to the people. We, the people, deserve and demand no less. Not only our state, but our nation depends on you, board members, to take positive action by removing any process that isn't verifiable, transparent, and accountable to the people of Georgia. God bless America.
So it's Kay Arufi and then Jim Boyd. Is there, it's spelled on my sheet as Arroufi. All right. She apparently is not here. Jim Boyd. Apparently not.
Good afternoon. Jim Boyd, Cobb County. One person, one vote. Our Georgia government has failed the people. Our elections are laced with dilution of the true vote. One person, one vote. We're getting something like a nub. I rise to suggest to this board for the state of Georgia to use the powers granted by the state to enforce our elections using a secure paper ballot election process. I stress secure, meaning a standard ahead of time. At such a time, a system is designed by the proper legislative powers of the state. At that point, we might switch to whatever secure system we have designed. But we need to go after funding, and we need to have it done in a manner of designing something that really works. If not for Georgia, for the country, we have a problem all over. The current system violates our state constitution, by the way. Law that a voter reading may verify a ballot before being submitted. So this ballot should be verified. Well, the ballots that we're actually scanning are not what is being verified. Last time I read a QR code, my eyes crossed. I would suggest that we have a lot of ideas about how to make corrections, but it's going to take a body with a focus and a desire to develop a secure system. Our system today was not even designed with security in mind. In fact, it's been used to manipulate votes in other countries. Sad, but true. We need to get back on to following our Constitution in our state as well as our country. Thank you for your time. Thank you for having this opening discussion.
Thank you, Mr. Boyd. That concludes the public comment section of the meeting. And we will now move to the violation cases, beginning with those recommended for letters of instruction and those for referral to the Attorney General's office. So the first case, and we'll have first case. But there's a lot of rattling. The first case is SAB 2020-029. Can we have a report on that?
59, tab 8. Tab 8.
It's not on. Was it? Okay. 2020 029 DeKalb County Election Day issues. This was a continued case, and there were 10 violations to begin with, and 3 of the violations, after the follow-up, the investigation identified 3 violations committed by DeKalb County Board of Elections and Registration on the employee of DeKalb County Board of Elections and Registration. Allegations 1, 3, 4, 7, 8, 9, and 10 were insufficient evidence to prove a Georgia election code violation occurred. The investigation was sent back, and we looked at allegation 2, which was the 5 polling precincts had poll workers who appeared to be untrained and disorganized. Allegation 5, which was 1 precinct received its voting equipment after the precinct opened. And allegation 6, which was 7 precincts did not open on time. So with those, allegation 2 was, based on the information reported by the vendor, No Inc., there is evidence to suggest that the DeKalb County Board of Elections and Registration violated OCGA 21-2-328A when they deployed voter check-in equipment, poll pads, to the wrong precincts. OCGA 21-2-328A stipulates the superintendent shall deliver the proper voting machine or voting machines properly furnished with ballot labels to the polling places of the respective precincts at least 1 hour before the time set for opening the polls at each primary or election, and shall cause each machine to be set up in the proper manner for use in voting. Allegation 5, based on the information provided by the poll manager at Canby Lane Elementary School polling precinct, there is evidence to suggest that the DeKalb County Board of Elections and Registration violated OCGA 21-2-401A when they failed to deliver equipment and/or supplies necessary for use in a primary or election. OCGA 21-2-328A stipulates the cards of instruction, return sheets, tally sheets, oaths of poll officers, affidavits, and other forms and supplies required for use in each precinct. When ballots are used, the official ballots prepared for use therein shall be packaged by the superintendent in separate sealed packages for each precinct, marked in the outsides so as to designate clearly the precincts for which they are intended. Allegation 6. Based on the admission of the poll manager of Big Miller Grove Baptist Church, there is sufficient evidence to suggest that a DeKalb County Board of Elections and Registration polling location violated OCGA 21-2-403A when it failed to open on time. OCGA 21-2-403A stipulates, at all primaries and elections, the poll shall be opened at 7 a.m. Eastern Standard Time or Eastern Daylight Time, whichever is applicable, and shall remain open continuously until 7 p.m., at which time they shall be closed.
Do you have more specifics? I know you've cited the statute, but what was it that the county failed to do that constitutes the violations? The last one is clear that they didn't open on time, but what is it that they specifically did to violate
I'll pull that back.
violation claim 2 and the claim violation in 7? I guess what I'm saying is what happened?
On that one, they didn't open on time. Does that mean
Got
exactly?
that
Or
one. How about the other
Oh.
2?
You mean more specifically that they didn't open on time, or?
No.
Oh.
5 is 5 polling precincts had poll workers who appeared to be untrained and disorganized. What was the evidence to show that?
They spoke to Ms. Hamilton, and she advised that her staff had quite the challenge due to the COVID protocols that were in place during the 2020 election that was different than any other previous elections. She advised that training was provided to all poll workers. However, most of the poll worker training had to be conducted virtually. Due to the pandemic, there were very limited in-person training. Training began in January of 2020 and then continued in sessions until the week prior to the primary election. During the virtual training, poll workers had the opportunities to ask questions if they needed further clarification on the process, and they had an opportunity to request additional training. Ms. Hamilton stated that she was not aware of any other way to better prepare the poll workers in the current COVID protocol situation, but they did not make management aware that they needed more training or that they didn't understand their specific tasks. So they were saying that due to the virtual training was an issue with how they were being trained.
But that, the first violation is that they were deploying voter check-in equipment to the wrong precincts. I mean, what was the scope of that? I mean, was it?
With knowing, I can't hear what you're saying to me.
Well, the report I'm reading says there are 3 violations, correct? The first violation was that NoLink said there was evidence to suggest that they deployed voter check-in equipment to the wrong precincts.
Mm-hmm.
Then you cite the law that say you have to deliver the right stuff to where it's supposed to go. What is it that they didn't deliver, and on how many occasions did they not deliver to the right precincts?
Oh, okay.
I mean, specifically, was it a one-off? Did it happen in 5 precincts? Or, I'm looking for the scope.
Poll pads went to the wrong precinct, right?
Yes, they went to the wrong precincts.
There was poll pads.
The poll pads.
Well, how many precincts did they wrongly go to?
I think just, they switched the 2 locations, so they went to 2 different locations.
So 2 precincts got the wrong poll pads.
They swapped them. Yeah, they went to the,
Okay.
he received 2 calls with a polling location. They went to the wrong location.
Then the second violation is based on information provided by the poll manager at Canberry Lane. There's evidence that they failed to deliver equipment and/or supplies necessary for use in a primary or election. What is it that they did not deliver?
I'm sorry, I'm just not hearing what the question is.
Well, there's nothing in your summary that, other than a conclusion that they had done, that they had engaged in general conduct. There's no detail. I'm looking for the detail.
Okay.
And it all just relates to Canberry Lane Elementary. And it said they failed to deliver equipment and/or supplies necessary for use in a primary or election. My question is, what equipment and supplies did they not deliver?
Okay.
Chairman Duffy, it says ballot marking devices at 3 precincts did not have enough
Enough what?
ballot marking devices.
And that's what happened at Canberry Lane Elementary? Or is that what happened with respect to the first violation?
At the Canby Lane Elementary, that was the ballot marking device. She explained that the supplies were retrieved for Election Day, that there had been 2 keys to the BMD cabinets that were in an envelope with the supplies. Ms. Bird stated that she could not locate the envelope with the keys, so she sent a poll worker to a nearby precinct to borrow one of their keys. Ms. Bird stated that once the Election Day was completed, she returned her supplies to headquarters. The envelope was located at headquarters, but they had never been placed in her supply box, so she didn't have that to begin with.
But my point is this, that I want the people to know they're here, and I want the counties to know that are listening what actually happened, not to just generally say enough equipment was not delivered, so that they have an idea of what could cause them to violate a rule or a statute. That's my only intent in asking these questions. I've got that. But for the purpose of these reports, that nobody listening to this understands specifically what happened. Those are all the questions I have. Any other questions?
Yes, Chairman
Dr.
Duffy. Certainly, the polls need to open on time and they need to close on time. The 2024 elections are expected to have a large voter turnout, and there's a planned introduction by the state of the new poll pad device and procedure to be used possibly for DeKalb County. What is the emergency operational plan for DeKalb County if the poll pads do not work properly?
Oh, she's pressing the talk button. That's my fault. I'm sorry.
That's okay. Do you want me to address
Yes.
that
Would you
question
please?
now? Our former director, Erica Hamilton, is here and can address specific questions regarding what happened in 2020. I'd just like to note at the outset that the notice for this hearing that we received indicated that all 9 of the 10 violations were either had insufficient evidence or were unsubstantiated, and that only number 7 had sufficient evidence to sustain a violation. So we'd like to try to address as much as we can, but ask that the case be continued to the extent the board wants to act on it today, because we have not had sufficient notice of the alleged violations based on the notice that we received. I'm glad to show you what I have, what I received from the investigators.
Can we see it, please?
Sure.
Y'all didn't receive any of these other ones?
Oh, no, we received the other cases that were noticed for today. The summary of investigation that we received for 2020-029 is different from what is being reported in terms of which allegations have been substantiated.
Yep, we have 3 that were reported here today.
Correct.
Right. And so this is just a summary of the investigation?
Yes.
And that was, that was sent to you?
Yes, it was provided to us last.
Well, this is clearly inconsistent with the report.
So I would move that we continue this case until the following meeting.
Second.
Yeah, I mean, because you're right.
You're right.
This is, you know, we have a date of report, July 12th, 2023, and this one.
This was the initial estimate that came, and then there was an
Then you got, I know, I see that you got the June 13th, so you have a June 13th, but in our book, we have a July 13th.
Yeah. So you were just sent the wrong report.
Yeah.
Any discussion on continuing this? It's continued. Thank you for bringing that to our attention. Well, I kind of like to keep them. Do you need copies? No. Okay.
But if I may, Mr. Chair, to Dr. Johnson's point, and a little word to our friends who are listening in, if you see a violation, you see where you did something wrong, coming in to sort of explain how you fixed it will go a long way to the ultimate resolution. Dr. Johnson raised the question as to what's going to happen in 2024. So being able to answer, honestly, being able to answer Dr. Johnson's question, which will be the same question as the next hearing, will go a long way to getting this whole thing resolved.
And I'm sure Ms. Hamilton could provide more detail. The emergency procedures were followed in the instances where the poll pads were misdelivered. They were just switched for those 2 polling places, so they were able to use the hard copy voter check-in list to process voters.
Just in terms of for any county that's where there's some violations like this, if they come in and say, we see the violations, we've investigated, we see that a problem got made, here's what we're doing in order to make sure that in the next election it doesn't, it won't be repeated. That'll go a long way to us being able to resolve it with you rather than having it referred to the Attorney General or someplace else. That's just a sort of word to the wise.
And also with respect to the June primary and late opening times, that was the first election that we were conducting with the new equipment, and there was an order entered into DeKalb County extending the time for all polling places by about 45 minutes, I think, on June 9th, 2020, to account for the fact that some of the polling locations had opened late.
Correct. I'd like to add one more thing. This is another report, so maybe for the next month or the next meeting when it's presented, there is, in the investigator's report, there is a request for information and has not been received.
In which case is that?
It's this case, and it pertains to lack of training and equipment issues.
Okay. Well, I have been working with the investigator on that case to try to get her the documents that she needs, so I was not aware that there was something that she had requested and didn't have, so I'll follow up with her on that.
Thank you.
Okay, all right. Next case is SEB 2020-78 DeKalb County illegal campaigning, which is at tab 9.
Okay. SEB 2020-078, DeKalb County illegal campaigning. This relates to a continuation case that was heard in June. It involved Andrew Bell and a Benny Franklin. On August 11th, 2020, 2 photographs were provided to the Secretary of State's office that showed a black male in a gray pickup handing out small materials, flyers, with the following statements. One said, "Vote for Andrew Bell," and the other one, "Bringing integrity back." The investigator spoke with Mr. Bell. He indicated that Benny Franklin was collecting signatures for a petition to get him on the ballot. Viewing the photos in the file showed that the subject was within 150 feet of the school, which was a polling location. And once this case was presented, it was provided a continuance because of the amount of time that Mr. Bell was notified regarding this. In addition to that, in the original presentation, Benny Franklin's identity had not been concretely confirmed. However, in the intervening time, our investigator was able to locate Mr. Franklin, have a conversation with him. He at that time indicated that he was in fact the individual that was there campaigning on behalf of Mr. Franklin. So based on the facts of the case, they're in violation of OCGA 21-2, 414 sub A sub 1, restriction on campaign activities. There is sufficient evidence to suggest that Andrew Bell and by proxy, Benny Franklin Jr. violated the state election code when Bell instructed Franklin to collect signatures for a nomination petition within 150 feet of the outside edge of an established polling place.
All right, Mr. Bell is here, we know. Would you like to respond to the allegations?
Press,
What-
press the
press
button
your-
that says talk on that brass. There you go. Gotcha.
Okay.
Okay, as indicated, you can't campaign for anything if you're not on the ballot. So, I wasn't on the ballot. So that's not an accurate statement. I wasn't even at the polling location. Okay, I have no control over what other people do. Okay, so I'm at another polling location, Columbia Drive, collecting signatures. So I don't know by proxy what that means. Does Mr. Franklin have a statement? Because I haven't been privy to his statement.
Yes, I indicated that.
Can I see it? You said he wasn't identified, then now he's identified. So when was he identified?
Once we did the follow-up, one of my investigators spoke with him, and he indicated that we had pictures. He indicated that was him in the picture, and that was your truck in the picture also.
I don't have a gray Toyota Tacoma. I never have owned a gray Toyota Tacoma in my entire life. So that's not my pickup truck. I do not own or never have owned a gray Toyota Tacoma. So I don't know whose pickup truck that was, but it wasn't mine. I would appreciate if you could come with some facts. I didn't instruct Benny Franklin to whatever you're accusing him of violating the law. I don't believe he did, because you don't have any correct facts. You're saying that he's using my truck. I've never owned a gray Toyota Tacoma, so that's not my truck. You said I was campaigning. I wasn't even on the ballot.
So what's your response to that, Michael?
I have photos. Let me go. The actual file is on.
Is Investigator DeWeese with us today?
Is Deweese here today?
Well, we know I wasn't on the ballot. I mean, that's a whole nother thing why I'm suing the Secretary of State. So we could just, we know I wasn't on the ballot. So the campaigning thing, that's.
Were you campaigning for somebody else? I just
Well,
want to make sure.
I wasn't even there.
I just want to close the door.
I don't know what they were doing.
I hear you. I just want to make sure I close the door here.
He said I was campaigning.
No, I hear you, but I'm asking a question. Were you campaigning for anyone else that day?
Well, I was the person that was getting nomination signatures for the nomination petition. I was located at Columbia Drive.
Okay.
So I don't know what went on at Peachcrest. I was at Columbia Drive when the DeKalb County official called me to come to Peachcrest over the phone.
And you didn't send Mr. Franklin there, right?
No, they were entitled to do whatever they wanted to do to collect signatures.
Okay, and you didn't know Mr. Franklin was within 150 feet, right?
How can I?
And you didn't instruct Mr. Franklin to go within 150 feet, right?
How can I?
Well, I mean, you could just say, hey,
Okay.
Benny, stand out front of the door and get these signatures.
I wasn't there.
Well, before he went there, you could have said,
Before he
Benny,
went,
go stand there. So it's clearly possible that you could have. I'm asking, did you?
I did not.
Okay, thank you. That's what I'm trying to get to.
Yeah.
The question I have, was Mr. Franklin working to collect signatures for you?
He was.
Did you know he was going to this school?
I did not.
Did you care where he went so long as he got the signatures?
No.
Okay. And you were collecting signatures for a particular candidate, right?
Himself.
For yourself, that's fine. And,
Okay.
and you were collecting signatures where again? I'm sorry.
Columbia Drive polling station, which was, I think it's Hillside Presbyterian Church, I
Understand.
believe. I'm not
Do you
100%
know whether or not
accurate.
you were within 150 feet?
Excuse me, sir?
Do you know whether or not you were within 150 feet of the polling place?
No, I always make sure that I'm far enough back. Usually what I do is when I get there, I ask the polling person, who's ever in charge, the supervisor, where I can be, so that everybody's on the same accord. That's what I do. I don't know what anybody else does.
Now, for the investigator, if I can interrupt, Edward, is that okay?
I'm done.
Okay. Did Mr. Franklin tell you that he had been instructed by Mr. Bell to go within 150 feet?
Not that specifically. What Mr. Franklin indicated was that Mr. Bell was present at the voting location and that he was driving the truck that was captured in the photos taken by the complainant. That's what Mr. Franklin told our investigator.
Now, Mr. Franklin admitted to you that he was within 150 feet, right?
He said he didn't know that that was a violation.
But he
was
admitted that he
unaware
was
of it.
within the 150 feet, right?
Yes, and our photos show that.
Okay. You
Wait,
just
wait,
put words
wait,
in his mouth.
Wait a minute, I have the floor, sir. You're harming your case. I'm trying to help you. I'm going to make a motion, Mr. Chairman, that we dismiss the charge against Mr. Bell because I believe the evidence is at worst conflicted. Concerning the evidence against him, the evidence is at worst conflicted, and at best for him, there is no evidence at all that he instructed this gentleman to go within 150 feet. There's no evidence that he was within 150 feet. So I'm going to move that we move to dismiss the case against Mr. Bell, but that Mr. Franklin admitted that he was electioneering within 150 feet. So I believe there is evidence sufficient to find a violation relating to Mr. Franklin. So I would move that that go to the Attorney General's office. So my motion is to dismiss the charge against Mr. Bell and to send over Mr. Franklin over to the Attorney General.
Is there a second?
Second.
Is there any further discussion on the motion?
Would it be possible to see the photographs in the file of the truck in question that you have?
Yes, and the truck was at his residence also, so that's where him owning the truck came from, obviously.
At whose residence?
At Mr. Bell's residence.
So you
So
took a
here's
picture of the truck at my house? Of course it's going to be at my house.
Well, you said you didn't own the truck.
I'm saying I want to see it at the polling location.
Well, I think you said, I didn't own a truck, I've never owned a truck.
No, the board said, I have you guys' letter right here.
No, I'm talking about what you said
What
here.
you said a few minutes ago.
Gray Toyota Tacoma. I don't own a gray Toyota Tacoma.
Do you own a gray
I don't
truck?
know the picture you guys are referring to.
Do you own a gray truck?
No, it's pirate.
It's what?
Pirate. That's the color.
All right.
That's
It's a
what,
shade of gray.
A pirate.
Is that a shade of gray?
A pirate Toyota Tundra. That's what I own.
So is this a Toyota Tundra?
You guys said Toyota Tacoma. It's right here.
Well, why don't you come up and look at this picture and tell me if
Tell us
that's your
whether
truck?
This is his truck.
Well, I mean,
come on up and look at this
In
picture.
your thing, it says Great Toyota Tacoma.
Come up here, look at this picture, and tell us if this is your truck.
Is it at my house or at the school?
You're just gonna look at a picture and tell us, show them all the pictures of the truck.
Can I see the evidence against it?
That's what we're doing. Is that your truck? Was do one picture at a time. Did you see that truck?
I can't say.
Can I see the picture?
There's no license plate, no anything.
Oh, Mr. Bell.
I mean, this is your investigator. I mean, hold on.
Hold on.
You need more training.
So you've got, does this?
That's not me. I don't know who that is. That's not me.
You know, you need to.
You already told our investigators who it was, Mr. Bell.
I didn't say who it was. You
Does
said
that look like your truck?
I can't say it was my truck or not. That's one of my cars.
Where's the other truck picture? Is that the one you're talking about? You said
If you keep turning, there's more pictures of the truck in his driveway.
So let's try it that way. Show the picture. Hold on, sir.
Okay. Is that your truck?
That's my house. It looks like.
What, is that your truck in front of your house?
Yeah, that's my truck. But I can't say that's the same truck. And you can't either.
Did Mr. Franklin tell you that the truck that was at the polling place was his truck?
Yes.
Wait a minute, his who, Mr. Franklin or his Mr. Bell?
Mr. Bell.
Okay.
Say what now?
Mr. Bell?
Yes, it's part of the report that Mr. Franklin said that was Mr. Bell's truck.
Is that Mr. Franklin? Pardon? That's not me. Who's the person that was in the...
Do you know Mr. Franklin?
I know Benny Franklin.
Does he know your truck?
I don't know if he does or not.
Well, you asked him to collect petitions for you. Did you drive your truck when you asked him to do your petitions?
This is your investigator. He took a picture of 3 feet of the truck, and you guys want me to say it's mine. I'm not gonna do that. I don't know whose truck that is. It could be mine, it could be somebody else's. I don't know whose truck that is. I don't know the individual standing there, so, I mean, I don't know what you want me to say. I guess you want me to say, oh, I'm guilty?
No, all I want you to say is the truth.
Just the truth. I can't look at this little portion and say that's my truck. Can't do it. Won't do it.
You go back to your seat.
Well, not quite. Excuse me, sir.
He's got a mic. He's got a mic.
Could you, no, I need him.
Come on
Go
up.
back up.
Come on back.
Yeah, I'm sorry, sir. I just want to make sure. Is that your house?
That looks like my house.
And is that your truck?
Right here it says Toyota.
No. I'm talking about the picture.
I'm saying, but
I'm
you
saying
guys
the
sent me-
picture.
Hey,
I'm talking
excuse
the
me,
picture.
answer his question.
My picture.
Yeah, it looks like my truck.
And your truck outside.
I mean, I would imagine it's my truck is sitting outside my house.
Starting to be like a country western song.
You know how you guys attorneys do. You play with words.
No,
and all this
no.
kind of stuff. Come on now. No, that's how y'all do. Since I've been here, did he do this, that? He said, switching the words around. I mean,
Thank you for that commentary.
I mean, I've been dealing with this for 3 years.
Thank you. For
Y'all know I have.
Okay, you can return to your seat.
Judge, I believe I understand that Mr. Franklin did not get notice for this hearing. I understand that, so I would move that we continue this case until October and allow Mr. Franklin to come.
Mr. Franklin will be there.
I was just informed that Mr. Franklin did not get notice.
So he's responded.
Yes, and he was.
All those in favor of continuing the case?
Second and aye. Second and aye.
It's been moved and seconded to continue this case. All those in favor, is there any further discussion? I hope not. All those in favor say aye.
Aye.
Opposed, no. It's continued.
I don't think so.
Okay. All right, the next case is SEB 2020-080 Fulton County, tab 10.
Judge, you want to proceed?
Yes.
Okay. Okay, case SEB 2020-080, Fulton County runoff election. This was another continuation case from the June 2023 hearing. There were multiple complaints made by 29 citizens about the Fulton County Board of Elections and Registration. The complaints range from citizens not receiving their absentee ballots, their votes not being counted, and issues/problems at polling locations in Fulton County. The respondents are the Fulton County Board of Elections and Registration and former Elections Director Richard Barron and retired Elections Director Ralph Jones. So in looking at this case, one of the primary reasons why it was continued from that June 2023 hearing was because there were 17 instances in which we asked for information from Fulton County trying to get evidence to verify, confirm, or deny whether the allegations of the complainants did in fact occur. They were given until July 1st by Judge Duffy to provide that information. My investigator asked those questions, sent that information to Fulton County. They provided a transcript response for those 17 violations that we looked at in that June meeting.
What do you mean by transcript response?
Well, email basically, and then they kind of answered the question. However, there was no evidence on that. So she followed up, and Fulton County was able to provide information for 8 of those citizens, basically saying that they mailed the absentee ballot back in the appropriate time. We were able to get that information from Fulton County, from ENET showing that. However, there were still 7 citizens and violations that we identified in which Fulton County could not provide information to refute what was claimed in the original complaint. Those citizens, Robert Boyd, Caitlin Russell, Cal Alfonsin, Vivian Alfonsin, from the evidence or the lack of evidence that we were provided from Fulton County, we sustained that they were in violation of OCGA 21-2-384, preparation and delivery of supplies, mailing of ballots, as there was no record of them providing or mailing out the ballots to these citizens who submitted application for absentee ballot. In addition to that, Serenity Travis and Rachel Quaisbarth, they were in violation of 21-2-293, correction of mistakes and omission on ballots. States if the election superintendent discovers that a mistake or omission has occurred in the printing of official ballots or in the programming of the display of the official ballots on DRE voting equipment or electronic ballot markers for any primary election, the superintendent is authorized on his or her own motion to take such steps as necessary to correct such mistake or omission if the superintendent determines that such correction is feasible and practicable under the circumstances. So in those cases, those two individuals were sent out the wrong ballot, and there was not enough time basically for them to vote. And then finally, Margaret Scullin, Fulton County, was in violation of OCGA 21-2-418 provisional ballot, which states, at the time an elector casts a provisional ballot, the poll officer shall give the elector written information that informs the elector of the existence of the free access system required by subsection E of this code section, by which the elector will be able to ascertain if his or her ballot was counted, and if such ballot was not counted, the reason why. Her ballot was not counted, although she voted a provisional ballot. So those are that is the results of that complaint going back. As I indicated, some of the information was provided, so those original 17 is knocked down to the 7 citizens that I just cited as continual violations because we were not, or actually Fulton County was not able to provide information to refute the allegations.
First from the board, are there any questions of Michael? All right, is there here somebody from the respondent ready to respond to the complaint as respects these 7 people?
Good afternoon, Board. Nadine Williams, Director for Fulton County Elections. We reviewed the county level maintained absentee tile page in Jarvis and summarized that the applications were submitted timely. The absentee ballot page information was provided to the investigator, as was any available documents. Since this case had happened in 2020, we realized that standard operating procedures have been revised to streamline the absentee by mail document filing, which will provide more efficient responses to inquiries received. Therefore, we are requesting that this case be dismissed.
Well, the investigator said that he asked for this information. I recall in our hearing that I instructed that information to be provided by July 1st. For these 7 people, they say that they didn't get any information. Are you saying that there is information that was not provided to them?
No, we're stating that we looked at the voter history in Jarvis, and it's for some of the, I'm not sure which 7 he's referring to. I know he mentioned some names. For 3 that are, for the list is a total of 13 people. 3 of them, there was no.
Could you hold the microphone?
I'm sorry. The list was a total of 13 from what we were given. For 3 of those individuals, there's no evidence this person ever requested an absentee ballot. There's no record of that. So there's no application for us to pull because we have no evidence that the person ever requested an absentee ballot.
Okay, we're talking about 7 people, not 13.
Right. Well, yeah,
so let's take them one at a time, just so
Okay.
I don't get confused. The first is Robert Boyd, and I guess these are 3 of the same. Robert Boyd, Caitlin Russell, Kyle Alfonson, and Vivian Alphason.
Okay, so for the Robert Boyd, the original response we did, first we could not identify which Robert Boyd there was. There were 16 different Robert Boyds in the system. When we finally did receive the voter ID number from the investigator, I think our records indicated that there was no request for an absentee ballot from that particular voter ID number.
Caitlin Russell.
Caitlin Russell, again, that's another person. There was no record that an absentee ballot was ever requested.
Kyle Alfonson.
Same, there was no record that an absentee ballot was requested.
And Vivian Alfonson.
We have no voter registered under that name for I can't pronounce the last name that you just said, but we have no record of a person registered under that name.
And was that information provided to the investigators when? On what date?
I'm sorry, I don't have the dates in front of me, that we gave the investigator. I can't hear you, I'm sorry.
You were supposed to give information about all of these people by July 1st.
Yes. So
by July 1st, did you provide evidence which would show that on the records that you looked at that they had not requested an absentee ballot?
Yes, our staff went into the system and provided investigator screenshots of the notes they found regarding these voters.
Okay. Now, were screenshots showing that they had not requested absentee ballots provided to you?
We did get information on a number of the individuals, and that's why they were not part of the violation when we did
No,
the subsequent.
We're talking about these people for which you were recommending that there's a violation. Boyd, Russell, Alfonson, and Alfonson. Did you get screenshots showing that they had not requested absentee ballots?
We just got a statement from them saying that they didn't request them. In the case of Boyd.
Okay, stop right there.
Okay.
He says that you didn't provide screenshots, that you only provided a statement.
No, we did not provide any statement. All of our, I believe everybody received a screenshot. Am I correct? It was a screenshot for every person on this case. There was
And
not,
that-
there's
and
no
who was that
statement.
sent to?
To, I'm sorry, what's the investigator's name?
Marriage, Larissa.
Yes.
So has anybody reviewed Melissa Marish's file to see if what the evidence was regarding Boyd, Russell, Ms. Alfonson, and Mr. Alfonson?
Screenshots. Exhibit 51. 51. No, 53.
If the file's in chronological order, it would seem that you ought to go to July 1st or that to find out whether those were sent to you around July 1st.
No, I don't see any screenshots here as far as it relates to Boyd, for example. I was under the impression in talking to the investigators that you all sent screenshots for the individuals you had records for. And so these were the individuals that you did not have records for. That's what my understanding of when I talked to the investigator. And I don't.
We're not talking about understanding here, we're talking about evidence. The county said and told us this afternoon that they sent to you for Boyd, Russell, and the two Alfonsons screenshots showing that they had not asked for a ballot.
And I don't see that. It says Exhibit 51. I'm looking at Exhibit 51, and it's not a screenshot.
So did Fulton County bring their file to show the copy of what they sent to the investigator?
No, but I can pull it up on my laptop if you don't mind. Okay, thank you.
Kind of feel like I'm in a deposition.
So we're left with Boyd, Russell, and Alphenson.
2 alphas.
2 Alphensons, okay.
Have an answer? You've got to hit your button to talk.
Gotcha.
Okay?
Judge, we do have the screenshots in this email right here, and if there's an email that we can forward it to, we can do that right now.
And to whom is the email?
Sorry. My bad.
Yeah, I relinquish this responsibility. So who was the email sent to?
Larissa Marriage, Judge.
Would you show that to Michael, please? So maybe that will point you where in the file you might have, where Ms. Marish might have filed it.
While he's looking through that, Fulton County, can I ask y'all? I got Boyd, Russell, Alphenson, and Alphenson. Can we go through those? And which one do you have no record of them at all, that they're even voters? And which ones you have no record they requested an absentee ballot, just so I can get this straight in my mind?
Okay, so Vivian is the one we have no record of them being registered to vote.
Vivian Boyd?
Carbon, I can't pronounce the last name, I'm sorry. Yeah, Carbonell. That, there's no record of her being a registered voter in Fulton County.
Okay, but what about the Boyd, Russell, Alphenson, and Alphenson?
Okay, for Boyd, there were 16 different Robert Boyds. Once we were given the voter ID number,
You said once you got the voter ID number, you didn't have any, you went and saw that they had not requested a ballot, correct?
okay, so the Robert Boyd, once we were given the voter ID number from the investigator, it was in reference to the August 11th election, and they did not request an absentee ballot for that election,
Okay, so a voter but no request.
for the August 11th election.
Okay, good, thank you. All right, so let's go to the next one.
Which is Caitlin Russell.
Okay,
There's no record that Ms. Russell requested an absentee ballot for the August 11th election.
okay, voter but no request.
Correct.
Okay.
Alfonsin Kyle, also for the August election, there's no record that they requested an absentee ballot.
So voter but no request. Okay,
I'm sorry, what is the other names that you?
the other, or is it?
Vivian Alphonson.
Alfonso?
We have it as Vivian Carbonneau.
Pardon me?
There's a Kyle
We have the name as
Alfonso.
Vivian Carbonneau.
I can't hear you.
You're on, just hold it closer.
Okay. Can you hear me now?
Yep.
Yeah, we have it as Vivian Carbonneau on our records, well, in this complaint,
Yeah,
so.
that's what we have.
Under that name, no, there's no record.
No record of the voter at all, or no record of a request?
No record of the voter. No record of the voter.
Okay. Thank you.
How about the others? Rachel Quasabar?
Well, yes, Serenity Travis and Rachel Quasenbarth. These are where the ballots were not exact. So what's the county's response to the finding that there's a violation of 21-2-293 regarding Serenity Travis and Rachel Quasen Barth?
For Serenity Travis, the application was not located to find out what party preference that voter wanted. So for that one, we did not locate the application. Because Jarvis does not have a record of the party preference in the system.
I don't understand that.
The allegation was that they received the ballot, but it was for the wrong party for the August 11th for the August 2020 election. But there's not a record of the party preference in Jarvis from the screenshot that we were able to provide. And we did not locate the application for those two to see what they would have indicated was their party preference
Well,
on the
is that a
application.
Jarvis problem, or is that somebody didn't enter it into Jarvis? Or is it, I mean, did you call them and say, we want to send you the ballot, what's your party preference?
Is that a question is that something that the Secretary of State could look up in the data that they have? Do they have access to the underlying ENET data? So they could actually, in this case, they could look up and see what the application actually said. And if it wasn't on the application because since this is a runoff, if they had voted in the primary, they would have to have the same ballot, either the same partisan ballot or nonpartisan ballot for the runoff.
That's correct. I'm not sure if the Secretary of State is able to see, behind the scenes in Jarvis, but these two voters did not vote in the June election.
Okay.
So it is practice.
Okay,
if they
so
don't,
they did have to select a primary, a
right.
partisan.
And if they did not on the application, we automatically send nonpartisan.
Right. Okay. So that would have to be researched and sent. When was the Jarvis search done on this, and has an update been made since the search was conducted so that perhaps you could have that? Do you have access to that data today that you maybe didn't when you first did this?
I had someone at the office check today. It's still the same. So
Okay.
we're not
Thank
able
you.
to see it.
Well, and thank you for anticipating that question since you obviously did.
Thank you.
Most of this investigation shows exhibits from ElectionNet. So I would think our investigators would have the documentation.
From ENET and not Jarvis?
ENET.
So basically, regarding this investigation and the complainants, if they couldn't show us, based on the initial allegations, some of the complainants indicated they emailed on certain dates, basically making requests, and it was in Fulton County's hands to show us, to give us evidence to show that they did what they were supposed to do. And in these cases of these 7 individuals that I named off, they weren't able to do that. And so that's why we ended up going through with the violations. The ones that they were able to show that they did what they were supposed to do, those are the ones that fell off from the last meeting. So based on that, even if they took a picture, a screenshot saying that there's no record, these are individuals that filed a complaint saying they applied for an absentee ballot, and we don't know what happened with the records because there's nothing in their system saying anything about what happened.
So you have, if you don't mind, you have evidence from the complainants that they did affirmatively apply for these absentee ballots? Were they able to send you copies of the emails that they sent? Because I know that at the time there was an online portal, and most people were applying either through the portal or from email.
Yeah, and that's one of the issues in looking at this. It's saying that the people sent emails, but I'm looking through and I didn't see them in the exhibits. Unfortunately, they're saying, I definitely applied. Some of them say they followed up and they never got a response. So, sometimes there's not any evidence of that. And like I said, I didn't see it in here in the exhibits, the emails that they sent.
Well, just because I like doing this, this is a really important point that for voters, if you want to cast a ballot in a runoff and you want to, and if you applied for an absentee ballot for a primary or for a general election, you have to apply separately again for that runoff ballot. So I always try to point out little voter education moments, and this is one of them, because I think in a lot of cases voters assume that their initial application will carry through to a runoff, and unless you are on the rollover list, it does not. And voters have to apply separately. So that could be the cause of confusion. For some of these voters, there's no way to know.
Well, and if I might, okay to go? When you're investigating something, what you're trying to do is you're trying to develop evidence to exclude something. You're trying to say, okay, in a criminal, this is not a criminal case because we're not a criminal court, but in a criminal case, you say, we're trying to exclude you as a suspect. So we need an alibi or something that it helps us to exclude. So y'all have one standard with regard to your investigation. We have another standard, is that the state has to make a proof, has to carry the burden of proof that a violation occurred. And so if the state doesn't meet its burden of proof, we can't go forward. And so while I'm not saying y'all did anything wrong or were improper or didn't do what you're supposed to do, I'm just saying there's a different standard that we have than what y'all are trying to do, because y'all are trying to investigate and we're trying to adjudicate. So here, I think on these cases, the only evidence that we have that's undisputed is the county's evidence that there is no request made. And sometimes voters are mistaken when they say, I requested this, and so that's why we need the proof. But again, we're under different standards than y'all are. So I'm going to move that the state has not met, in my opinion, the state has not met its burden of proof, and therefore I'm going to move to dismiss these counts.
Is there a second?
Second.
Any discussion?
I would like to discuss this case. These complaints came on top of mentioning other cases that were related to this, SB 2020-016 and SB 2020-027. And case 016 included a June 9th primary allegations of 254 complaints of not receiving absentee ballots for the primary election, and 107 people did not vote. In case 2020-027, there were multiple complaints of absentee ballot issues. So I would like to amend the motion to consider, because of these multiple issues with absentee ballots, I would like to ask that this case be referred to the Attorney General with consideration of asking the county auditors to conduct an absentee ballot process review and provide a report back to the SEB.
I appreciate your comments. I won't amend my motion to accommodate it, but as a courtesy, I will allow you to make a motion and supersede mine and see if you get a second, but I'll let you go first.
Okay.
Dr. Johnson, are you asking that we continue to get the additional information or send it to the Attorney General? There's two different things.
I think in the totality of these three cases, this one we're considering today and the two prior cases, there are enough issues with absentee ballot process that I think in order to maybe facilitate a best practice for this county and other counties, it would be I think it would be novel and prudent to ask the county auditors to perform an absentee ballot process. It's not an audit, but a review of the absentee ballot life cycle, and to provide observations and suggestions of how to better improve that process.
Well, aren't we already, I mean, Mr. Chairman, aren't we already doing that by the previous referrals that we've sent to the Attorney General? Like, I understand, you know, and I voted to send the previous ones to the Attorney General. But in this particular case, we have some specific evidence. The problem was in the previous cases, we did not. That's why we sent it to the Attorney General. We have a rebuttal here, so that's my curious.
Right.
And we also have, the Attorney General already investigated the same thing regarding the previous cases, correct?
We do. Well, and here's my view too, is that it is not something that we have the prerogative of doing, nor is it the responsibility of the Attorney General's office to come up with a best practice by doing an audit or by doing a review. That's something that's separate and apart. They're supposed to take cases that we refer to them, they look at the specific allegations, they determine whether or not there's additional investigation that they need to do with respect to the specific allegations, and then they present it to us. Now, when we get it, when it comes back to them, we can always, and we can, I guess if they wanted to talk about a consent order or anything, we could say, we would like for you to include this, agree as part of the consent order that they would do this. But I don't think that it's the responsibility at all of the Attorney General to make sure that that's done before they decide what to do with the case. They're supposed to represent us with respect to specific complaints that are forwarded to them with respect to allegations or violations that we found. I just think it's a fine process, a good idea. I just think it's in the wrong place.
Well, I think it would be something good to consider should there be some negotiation with the consent order. Because there have been so many cases of issues with absentee ballot process, not only with this county, but in other counties also.
And I would agree with you, but my point, I guess, is that there's already a vehicle. Let's see what they try to come back with the consent order with those other cases, keeping in mind this. But we're dealing right now with the specific allegations in this case for which the county has come forward with specific evidence that the absentee ballots were not requested.
Yeah, I agree.
And so I have to, I do have questions. That's why I said the previous as to the previous, but let's see what they come back with, and let's make sure we earmark it, so when they come back with perhaps a proposed consent order, we can put our input in there as well. I think that's probably the more judicious path.
And also, the county could, on its own, make a request of itself.
And quite frankly, that's probably a good idea. And that's something that we oftentimes encourage folks, that when you come before us with dealing with a complaint, or for that matter, if you go to the AG with a particular, dealing with something that we've sent to the AG, to have already gone forward and started to investigate further and make sure that your house is in order, things go a lot better for you.
Well, I think there are three things here that we need to deal with. First, there's this idea of the process review, because Beth Vaughn's here, aren't still. I don't know what you're going to do with the two cases that were referred to you previously, but we would like for you to think about whether or not that's something that you could request the county to agree to as part of the consent order, should you decide that that's the right way to go as opposed to going to a hearing. So can you at least just make a note of that when you get to that that's something that, if it's not in the consent order, we might not approve it, but we would like to see that done. Now, how do you avoid that? Well, you do avoid that, and I'll ask the county attorney, would you be willing, you've heard, to meet with Dr. Johnson and have the appropriate person at the county, and maybe somebody from another county or two other counties, to talk about the process that she has described and do it now? Well, that might be the way to get it done more quickly, and to make it more than just a Fulton County thing, to make it more of to something that would benefit other counties. The third issue then is with respect to Alphonsons, both of the Alphonsons, Boyd, and what's the last person?
Russell? Boyd
Russell.
Atkinson?
That our obligation is to see whether or not the complainants, and there's sufficient information from the complainants and from other sources that would persuade us that the evidence that has been offered by the county, which I think is unrebutted, whether or not we can refer this or whether we should dismiss these four individuals. So I think we need to, we have a separate motion on them already that's been seconded. And I think first we need to vote on that, because I don't think there could be a friendly amendment, and I think what Dr. Johnson suggested is not germane to the motion that's pending, and therefore would not be a proper amendment anyway, but it can be a separate motion. So it's been moved and seconded to dismiss the complaint regarding Robert Boyd, Caitlin Russell, Kyle Alfonson, and Vivian Alfonson. Is there any further discussion? There not being any, all those in favor of dismissing the complaint as it relates to those four individuals, say aye.
Aye.
Opposed, no.
No.
Now, is there a separate motion you would like to make?
The, I suppose that if there are these other two cases pending, then it would be best to wait for the Attorney General's report.
I'd say there's nothing pending before us with respect to those cases. It is been turned over to the Attorney General's office for their collective judgment on what the proper disposition would be, and then it will be back before us when they make their report and recommendation with respect to whatever they want to do. But I would agree with you, I don't think a motion on that is appropriate at this time. We ought to let it work its course.
Mr. Chairman, what about the other ones that are here?
The people that were not found to be in violation, I guess we need to move to dismiss them.
Cheryl
as well.
Heading, Angela Cantor, Quentin Nixon. What about those?
Well, there's more than that, isn't
I
there?
know, yeah, well, I'm doing those on this page, and there's Rachel
Well, there's-
Quasbarth, Serenity Travis, and Margaret Scullen. And,
Well, can I just interrupt for a second? In my list, the complainants I have that have not been dealt with the motion that was passed are Henning, Olson, Bergeron, Cantor, Nixon, Diane Boyd, Scott Russell, Callie Cullum, Portia Williams, Andrea Fox, Vivian Carbonneau, Rachel, oh, I'm sorry. No, we've got you're going over the next two. So you're correct. Okay. So now we're at Travis and Rachel, where violations have been found in regarding OCGA 21-293. So what should we do with them? Is there a motion? And this has to do with the fact that there wasn't a party preference on the application for the absentee ballot for the runoff. Correct.
Well, there was not information in the database that Fulton County had access to. It doesn't mean necessarily that there wasn't the information on the application, and that's the information we don't have.
Right. And the information we do have is that an application was made, but we don't know the detail.
Yes.
So let me ask this question. Did the investigator with respect to Serenity Travis and Rachel Quassenbarth, because it had to do with no evidence of party preference, which was the inconsistency, Did somebody go back
So-
to them and say, when you filed your application, did you put your party preference? I
No.
assume on the application for the absentee ballot, there's a place to put your party preference. Is that right or not right?
Yes.
Yes.
Yeah, yes, there is. In Serenity Travis's case, she actually took a picture, of the wrong ballot that was sent to her. Even, obviously she shouldn't have took a photograph of that, but she took a photograph. So we do have proof that she was sent the wrong ballot. In that case, I think it was her sister that was sent the correct.
She was sent the wrong ballot if she expressed the party preference and it came back with a different party preference.
Yes, exactly.
So my question is, did she say when she sent in her ballot that she wanted, did she fill in the blank that showed what her party preference was?
Yes, she said that, yes.
So in that case, she received a ballot that was inconsistent with what she expressed on her application.
Yes.
Now, how about Rachel Quasenbarth? Did her ballot come back with the wrong party preference?
No, she got a nonpartisan.
Let me just
Oh,
make
that's right.
sure.
Yeah, you're right. Did she express?
Yes, she expressed that she sent in. That's the one that they have no record for, though. So we have record of Travis because she took a picture. In the other case, they couldn't find it in their system, what her preference was.
But we have the voters' testimony that they requested.
Yes.
So the county's position is we sent them a nonpartisan ballot because they didn't tell us which party they wanted, right? That's what the county's position is.
Or do you have any evidence at all whether or not they expressed a partisan preference, or you just simply don't have access to that data at this point?
We don't have access to that.
Okay.
And what did,
Well, when
what
you
did
say
what
you
did the
don't-
voters say? I'm sorry.
When you say you don't have access, does that mean you can't go online? Is there another way that you could call somebody and say, look, we have an absentee ballot. I know we're not allowed to access that, but we need to know whether or not this person expressed a party preference. Can you tell us whether they've expressed a party preference? Or are you saying because you couldn't access it, you didn't know what to put there?
No.
For Ms. Rachel and Ms. Serenity, for those particular two, we cannot confirm if they did a party preference or not because we could not locate the original application. Since it's not in the system, we attempted to locate the application, we did not locate the application. So that's the only way we'd be able to confirm or deny if they received the correct ballot, if we actually find a hard copy of the application to see if they indicated what party preference they wanted. And
Okay,
since
well,
we could
so-
not locate that,
But they say they received a ballot that was wrong.
they said they received it. They said it was from what it, well, not they, because we didn't speak to them, from what the investigator put on this form that we received for this case. It's stating that the voter received the ballot, but was for the wrong party. And the only way to confirm that is to go back to find the voter's original application, see what party if they checked the party or not on the application. And unfortunately, we were not able to locate
And
the
you
application.
can't, you can't do that. So you can't really rebut what their testimony
I
is.
cannot confirm or deny because we don't have the actual physical application.
And on that one, I'm gonna go with the voter. On that issue, I would move to send it to the Attorney General.
And Judge, if I may, I'm not sure if the investigator mentioned that he had copies of the application, and I think if there's no copies of the application on the investigation side, then it suffers the same infirmities from the as the cases that you previously dismissed. So, if
Now, there's a difference because in that case, you had screenshots showing, but in this situation, y'all don't have any evidence to rebut what the voter said.
well, I think it goes to Mr. Mashburn's point that the state has to carry some sort of burden to show some sort of.
In this case, we've got the voters'
We've got the
affirmative.
voters.
We have the voters' affirmative statement. You see where I'm going?
I understand that, that this body is going off of the assertion, but I think that should not be enough to carry the day.
And that's something that the AG was gonna have to decide in terms of trying to decide how to resolve this, which may very well be a consent order in which Dr. Johnson's point gets handled. I hear you. You know, and part of it is we have to figure out a way for the counties to have the proper records to be able to come forward and tell us. And maybe that may not be entirely, and maybe that's something that can be worked out with the AG. Keep in mind, when we send it to the AG, doesn't mean that it's adjudicated. It just means that there's enough evidence to go to the AG for further consideration.
Right. And for further investigation if they believe that that's necessary.
Yeah, and for that matter, if they feel that you know, they come back and say and tell us that this is a glitch in the system, that's something else that we can deal with as well.
And if I might add, as Mr. Lindsay had mentioned in a different context, when the AG comes back with a proposed solution that includes a description of how the counties have made sure the steps that you're taking to make sure this doesn't happen again, we see that very favorably. And we also understand that you all have just undergone a 2-year performance review process, and the procedures for handling absentee ballots were certainly part of that.
Well, may I make a recommendation that instead of the AG giving us the guidance and instruction, that we get this from the state election board in the form of a letter of instruction as to what we can do the next time.
I can't hear you.
I'm sorry?
Can't hear you.
May I make a suggestion that instead of getting the guidance from the Attorney General's office, we get it from the state election board in the form of a letter of instruction. That way we can have an idea of what we can do next time from, you know, a body that's an expert when it comes to election matters.
Well, there's a motion that's been made to refer the matters involving Serenity Travis and Rachel Cuisinbart to the Attorney General's office for further investigation. Was that seconded? I think it was, wasn't it? Well, is there a second for that motion?
I got a second
I'll
down
second.
here.
Right, so it's been moved and seconded that the complaints regarding Serenity Travis and Rachel Cuisinbart be referred to the Attorney General's office. Is there any further discussion?
Just by way of discussion, I want to explain why I'm voting in what seems to be an inconsistent fashion. On the other ones, there was no ballot. We got no request. Our evidence shows no request. On this one, they did get a ballot, and there's no record of which ballot they requested. And so that's the difference, is the county should be able to say one way or the other, we got this request and we either gave them the right ballot or we didn't. So that's, in my mind, why these cases are different. So
Yeah.
I'm gonna have a different conclusion.
Well, the one further thing I would say is there is evidence by the testimony of the people who received the wrong ballots. They saw that it was a wrong
Yeah.
ballot because they had stated their party preference
Yeah.
in the application that they
Well,
sent.
and in the other ones, you're trying to kind of disprove a negative because it's like, it wasn't, it doesn't exist, we don't have it. But here you have the wrong ballot, and you have the proof that they got the wrong ballot. So that's why I'm going to take what appears to be inconsistent positions, but in my mind, they are consistent.
But if I can, I'm gonna give my county, and this is my county, give my county one more shot here before I can continue with my own motion. What records are we lacking in
Yeah,
terms
exactly,
of,
yeah.
this is my question, what
That's exactly
records are we lacking so that we can't tell what the application asked for? Why do we not have that? Where would that information be?
I think Director Williams can speak to that.
Right, so we recognize that the filing that our previous managers did in 2020 could not let us easily access the applications for those two individuals. So but since that time, we've streamlined absentee ballot processing, absentee ballot filing, so we'd be able to locate those files. So we recognize that we should have been able to find that application and say the voter did or did not request this ballot. Unfortunately, we cannot do that. But again, we have changed our filing processes over time. So that this will not occur again. If somebody were to bring up this allegation, we'd be able to easily get the application and say, no, this voter did or did not select this party on their application.
And I'd just like to add that the fact that we made these improvements goes to what Mr. Lindsay said earlier today, that
I'm listening.
improvement should go a long way, so.
I'm listening to that.
Yeah.
And just, again, one final note, if you all are able to further develop the file between now and the time that you meet with the, and if you're able to get some of the underlying data from the applications somehow through ENET, or accessing or requesting that somebody go into that data, that would go a long way as well to help us resolve any remaining questions.
You know, the one, I think we've said this a lot over the past months, that we distinguish between mitigating information sometimes to decide whether or not we're going to proceed by referring something to the Attorney General's office. But we certainly always consider it too in mitigation, and we don't have a template anymore, like I think we've had in the past, which if there's a violation, there's got to be some punitive measure. Maybe the resolution would be some instructive measure and an agreement that it won't happen again. So all the things you've said, I think, will still play into the matter, and I think will play into the matter as it goes to the Attorney General as they decide whether they even have to do any additional investigation, or do they negotiate something that is more instructive than punitive, if you understand what I'm saying. And I think that our track record is that we do that quite often.
So Judge, are you saying that there's a chance, because I couldn't really hear you as well, I think you were a bit far from the mic. Were you stating that sending this to the AG's office may result in instruction versus punitive measures?
Yeah. We don't know what they're going to do. All I can tell you is that we have a whole panoply of options to us, and I don't want to commit anything to them. If I say something, we say something, then they're going to feel maybe obligated to include that. We're going to leave that up to them. We have final say on what happens.
Yeah, if it comes back, we get to decide whether or not to go with the consent or get to go with a letter of instruction. All we're doing is sending it, quite frankly, for them to, they have the option to do a consent order. And
Understood.
But what I hear you saying is, what I hear the county saying is, we'll be amenable to a cease and desist because we're not going to do it anyway.
Yeah. Well, I don't think I don't think
we can't
we
tell
ought to
anybody
go
what
into
to do.
that. That we need to have a decision on this motion and let the process work the way it's supposed to work, which is not to suggest who'd be amenable or what we're going to do. We leave that to the Attorney General's office.
I just wanted to make sure the county understood we were hearing them.
And just one last point. I'd be remiss if I didn't mention this. I'm not trying to beat a dead horse here, but you know, like I said, this was based on a different system, so there's no chance of this happening again. I just wanted to let you guys know that before.
Understand
you make
that
the
it
final
did
vote.
happen.
I understand that. I mean, the more the serious nature here, and the reason why, in some situations, let's just say there's a procedural issue that happened in a county in which, for instance, polling place didn't open, but there's no direct evidence that a voter wasn't able to cast their ballot. In this situation, there is evidence that a voter, from the voter, that the voter wasn't able to cast the ballot that they wanted to cast. That is taken more seriously by this board. And that is also an added consideration. When we have, for instance, somebody who's out of state, this is totally different, but a voter who's out of state and voted illegally, trust me, that's going to the AG's office. There's not a letter of instruction given for that. So those sort of things where a voter has voted and they shouldn't have voted, or a voter has not been able to vote when they should have been able to vote, those are issues that are taken at a much higher level. And in this situation, we have two voters, I believe, that weren't able to cast the ballots that they wanted to be able to cast for the voters, for the candidates they wanted. That's why we sort of take that and hold that at a higher standard. And I'm sure y'all do as well, because y'all work very hard. And that's why we propose sending it to the Attorney General, whether it be a consent order or cease and desist and that sort of thing. We can work that out down the road. that's sort of, that also is sort of an added consideration. But, you know, the fact that y'all were able to come forward with some affirmative evidence to the contrary earlier is why I voted to dismiss on the earlier. This one I'm sending to the Attorney General. Hopefully that explains the difference. Thank you.
Is there any further discussion? I hope not. All right, the motion is to refer to the Attorney General's office the complaint as it relates to Serenity Travis and Rachel Kassenbach. All those in favor say aye.
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 All those opposed, no. The motion is approved unanimously. Now, I do want to remind the board members that we have 19 more matters. It is 3:45. So let's be mindful of the time if we want to finish today and not have to continue it tomorrow.
Judge, can I get confirmation that the next Fulton County case is not, we're not the respondents for that one?
Well, you have an agenda, don't you?
205.
Yeah. Thank you.
Well, the next Fulton County case is the next case, which is SCB 2020-80 Fulton County. It's at tab 10. We have a report on that, please.
No, we just did
We
that.
just did it.
Okay, sorry. Then we only have 17 to go. SCB 2022-205 Fulton County vote by. Tab 13. Can we have a report on that from Ms. Koth?
So we're doing 205? We're going to do 205?
205.
Okay. This one's actually a multi-county vote buying. When the original complaint came in, it was strictly Fulton County, but then when more complaints came in, it actually covered more of the state.
No. 086, 2020 086.
Okay.
On September 6, 2022, the Secretary of State's office was made aware of a political action committee called 34N22, who on or about June 4th, 2022, were giving out $25 gas vouchers while campaigning for U.S. Senate candidate Herschel Walker. There were reports of several other events that were held on different dates throughout the state, where the respondent distributed vouchers while promoting Herschel Walker. A potential violation of OCGA 21-570, which is giving or receiving, offering to give or receive, or participating in the giving or receiving of money or gifts for registering as a voter, voting, or voting for a particular candidate. On June 4th, 2022, a $25 gas voucher giveaway event was held at a Chevron located at 1192 Pryor Road, Atlanta, Georgia. There is evidence to suggest that the event was sponsored and funded by the Super PAC 34N22, Inc. There were, I'm sorry.
Go ahead, I'm sorry.
Oh. There were videoed portions of the event. The voucher distribution varied. Sometimes the vouchers were given to the recipient prior to the interview. That happened about 2 or 3 times. The vouchers were given to the recipient after they were asked questions such as, if you had to go to the polls today, who would you vote for? Would you consider giving Herschel Walker your vote? Most of the patrons replied that they would vote for Walker, and a Miss Stanton King then stated, give him or her their voucher. There was one recipient who received a voucher who, when questioned by Miss Stanton King about Senator Warnock, the recipient replied positively towards Warnock, then appears to walk away retaining their voucher. On August 9th, 2022, a $50 grocery voucher giveaway was held at a Piggly Wiggly grocery store located at 59 Magnolia Street, Jeffersonville, Georgia. There is evidence to suggest that the event was sponsored and paid for by the Super PAC 34N22, Inc. The investigator spoke on phone to one of the store managers, Laura Poole. Ms. Poole stated that her sister, Sarah, coordinated the event, but Ms. Poole said that she was present when the event took place. She said that she believed that there were about 170 $50 vouchers given out and about 165 were redeemed. She witnessed the handing out of the vouchers, and she said that everybody who walked through the door got one without conditions. She stated that they gave them to everybody until the supply ran out. And then there were other locations that this was happening with. They spoke to other store managers where $8,000 was given up front, and the grocery vouchers were given out to everyone who came into the store until the supply vouchers ran out. He did not, Russell Miller did not witness any conditions agreed upon before the customers would receive their voucher. Based on the video and documentary evidence, the allegation that the respondent Super PAC was offering free gas and grocery vouchers to patrons throughout the state, while openly encouraging voters to vote for a particular U.S. Senate candidate, was substantiated. There is sufficient evidence to suggest that the respondent Super PAC was engaging in vote buying, which is a violation of 21-570.
If I may, Mr. Chairman. If I may. And I hope you'll excuse me, I'm going to give you a little history for me. Having been an elected official and run several campaigns, I mean, I gave away a lot of barbecue. I gave away some T-shirts, and I gave away water from time to time in places where people were running. And there would always be material there for my candidacy. And my folks would generally encourage. But you know, they clearly understood that everyone got it regardless of what they said to them. And I guess I'm not sure where the evidence is. For instance, there was evidence that someone said they were going to vote for Warnock and they still got a gas voucher. Is there evidence that y'all had in which someone said that they were going to vote for Senator Warnock and were denied a voucher?
No.
Yeah. So that's my question.
I thought because we've had this before, but it got deferred because of representation issues, that there was at least one person that asked for a commitment to vote for Walker, and only after that commitment was made was a voucher given. Where is that true? Am I remembering that right? And if so, where was that?
They kept suggesting, looking at all of these. They had the signs, the two young females were holding signs. It says, Warnock isn't working, gas prices are insane. I don't recall anyone where they didn't get it.
If I might, the record says that the voters were first asked, if you had to go to the polls today, who would you vote for? Would you consider giving Herschel Walker your vote? And then the person stated, give them their voucher after the recipients asked those.
That's what I was remembering.
Asked and answered those questions.
Do we know what location that was?
I think that was the gas. But I guess my question, Mr. Chairman, was whether or not the person who said they were going to vote for Warnock also got the gas.
I think that's a different location.
I thought that was no. Sorry, were those the same locations?
Because there were multiple locations here.
And Mr. Chairman, I am here on behalf of 34 and 22 and am ready to speak.
I can't hear you.
I am here on behalf of 34 and
Yes.
22 and am ready when y'all are ready for me.
Well, we want to get that clarification first.
It was the same location. It's Atlanta Chevron gas voucher giveaway, Fulton County. It's on page 5 of 9. 1192 Pryor Road. It's in the 1, 2, 3, 4th paragraph.
Ms. Koth, it looks from the record like this was actually videotaped. Were you able to review the videotapes of any of this?
We watched some of the YouTube videos. It looked like everybody they were campaigning, but we didn't see anybody get turned away from them.
Right. But did it appear that there was a clear linkage between voting for a particular candidate and these giveaways?
Yes.
You say there was a clear linkage?
There was. They had like the signs, Warnock isn't working, vote for Herschel Walker. I mean, they were, but there wasn't, from anything we observed, that anyone was turned away if they didn't vote or, said favorably for the other party.
But going back to what Ms. Gazelle said, that there isn't, this is something that was videotaped, so I assume that you videotaped, that there were times, I guess 2 or 3 times, the vouchers were given to the recipient after they were asked questions. If you had to go to the polls today, who would you vote for? Would you consider giving Herschel Walker your vote? Most of the patrons replied that they would vote for Walker, and then they got their voucher.
And then one of them said, there was one recipient who received a voucher, and when questioned about Senator Warnock, the recipient replied positively towards Warnock. He appeared to walk away retaining their voucher. That's what it looked like on. That was stamped at 2210, timestamp.
Okay.
But the discussion about Warnock was after they had already been given the voucher.
Yes.
But do you know was that person around when people were saying, would you vote for Walker? And after they said yes, they got the voucher, was he then asking for a voucher? Because it looked to him as if, at least in the video, did it look like he was just following the course and he wanted a voucher too? But then when he was finally asked her, "You're going to vote for Walker?" and he said, "No, Warnock."
There were just a lot of people wanting the free gas cards. I mean, there were.
Okay. All right, Ms. Birch, do you want
Yes.
to take up your motion first?
Yes, Mr. Chairman and members of the board, Tippy Birch on behalf of 34 and 22. Thank you for the opportunity to be heard and for your service. As I think you know, 34 and 22 is a registered federal PAC that supported the election of Herschel Walker. As part of its political activities, we hosted the giveaways of the gas cards as well as some grocery vouchers to help amplify our message that the existing political leadership in DC was making those items more expensive and that was bad for voters. In each of its press releases, which are attached to our motion to dismiss, and if anyone doesn't have their copy handy, I have copies here for you, so please do let me know if you need one of those. But exhibits A, B, and C are the press releases we issued in connection with these events, and we made clear that the vouchers were available to anyone on a first come, first served basis, and they were not conditioned on anything. All of the contemporary press accounts made that also clear. That the vouchers were available to anybody on a first come, first served basis, that they were not conditioned on voting, they were not conditioned on registering to vote, they were not conditioned on requesting an absentee ballot, and they were not conditioned on voting for a specific candidate. 34 and 22 did encourage people to vote for our candidate, but they did not condition, we did not condition the vouchers or cards on that. Just as when you hand out a barbecue sandwich or a t-shirt, I hope I'll have your support. That is the type of thing that was happening there. I will be honest, this is the first that I have heard about the interviews that occurred. That was not included in the summary of investigation. The summary of investigation did not have a lot of information at all on the detail. I understand y'all have more information in the report of investigation, but hearing that today, that's consistent with what I understand happened, in that even the person who indicated they were not in favor of our candidate was able to retain their voucher. That that shows that it was not conditioned on having the right answer or agreeing to vote for a particular candidate. And then one other thing I wanted to point out about these is the timing of these giveaways. These occurred in June through September of 2022. So, there was some distance there from the actual election that later occurred. I know that this board has always prided itself on treating like cases alike, regardless of political affiliation of the group that's in front of you or the candidate that's in front of you. And if you look through your past cases, which we tried to detail in our motion to dismiss specifically at pages 5 through 7, the standard this board has used in considering whether there's a violation of OCGA 21-570 is whether or not the thing that is given away is conditioned on voting or registering to vote or requesting the ballot or voting for a particular candidate. Conditioned on. I mean, that language is really the important part of the inquiry. In the case of 34 and 22, the voucher was not conditioned on any of those things. Really, even when you look at when the findings of the investigator are read in the summary of the investigation, as well as apparently in the report of the investigation, the finding talks about voters being encouraged to vote for the particular candidate. It does not talk about it being conditioned on. We detailed those cases in our motion to dismiss that show the facts in those cases where there was not a condition on that those were dismissed, and that the board has consistently dismissed those based on that type of fact pattern. But maybe the most analogous case that we were able to find is one that you just dismissed at the last meeting. It was an Uber and Lyft case. It was SEB 2021-0119. And in that case, vouchers were made available by Uber and Lyft for rides to and from the polls. So that was happening on Election Day. So whether it's a voucher from the Arthur Blank Foundation for an Uber or Lyft ride, or a voucher for gas or groceries, doesn't matter under Georgia law. Those things really should be treated the same. They're both things of value, so they can't be distinguished on that front. The facts in that case also are similar in that they established the receipt of the voucher, both there and here, is not conditioned on voting or voting for a particular candidate. Through an Open Records Act request, we were able to look at Lyft's response to this board's investigation, and the facts established in that case are really similar to the facts here. Lyft made their vouchers available to any Lyft users, just like 34 and 22 made the vouchers available to anyone on a first-come, first-served basis. Lyft did not require proof of voting. Neither did 34 and 22. The Lyft voucher could be used by voters, non-voters, people who were registered, people who were not registered, without any inquiry by Lyft. The same applies to the vouchers given away by 34 and 22. They were given to voters. They could be used by voters, non-voters, people who were registered to vote, people who were inclined to vote for other candidates. They were given away on a first-come, first-served basis, and there was no condition on those. And then, in some ways, this is really more appropriate for dismissal even than the Uber and Lyft case. In those cases, the voucher that was at issue was for a ride to the polls, and that's occurring on Election Day. So that's really, I think that gets a lot closer to being the for purpose of voting, given the proximity in which all of that is happening. So in contrast to giving away a voucher on a polling place to and from the polling place on Election Day, which this board has just determined was not for the purpose of voting in violation of the statute, 34 and 22 gave vouchers away in 5 different events in June and early September of 2022. And the vouchers that were given away were not given in proximity to polling places, and voting wasn't even taking place in that time period. We were at gas stations and grocery stores. As we also outlined in our motion to dismiss, if the board departs with its prior precedent and finds there's a violation here, that would be a violation of 34 and 22's First Amendment rights under both the U.S. Constitution and the Georgia Constitution. As the U.S. Supreme Court has recognized, the First Amendment has its fullest and most urgent application to speech uttered during campaign for political office. A finding that there was a violation here would run us, head into a First Amendment violation. Because the vouchers and cards here were given out on the first come, first served basis and weren't conditioned on voting, registering to vote, or voting for a particular candidate, and because this board has consistently dismissed cases with this fact pattern, including at its last meeting, I ask the board to dismiss this case. Thank you. Happy to answer any questions.
Any board members have any questions?
Well, I think you really represented your client admirably, and had it not been for the record stating that people get in charge of giving away the vouchers first asked about people's voting and said, will you vote for my candidate prior to handing out those vouchers, then I would agree entirely, but I think that changes the face of the case. And again, looking at our last meeting, we have a consent order that we're going to review where there was one inadvertent advertisement that linked joining a raffle with either registering to vote or checking your registration. And that was enough for us to send that case, and that was nonpartisan. It was a completely nonpartisan case, and we still sent it to the AG's office with instructions that they come to a consent agreement with a cease and desist, and that was it, because it was a minor violation. I mean, this statute is a felony statute. Clearly, there is not enough evidence in my mind to suggest that any felony was committed. I cannot see fit to dismiss it myself, and therefore I would move to refer it to the Attorney General's office with the instruction to resolve it in the same fashion that the head count case was fashioned, with a consent order and a cease and desist.
I share that opinion, and this is why I think it's different. That from past cases, when somebody decides to go to a place where a voucher is immediately usable, in this case a gas station, and you have instances, specifically instances at one location, where the evidence is that to get a voucher you had to make a commitment to the candidate, and when you made that commitment you got the voucher. Any person who decides to run for public office that engages in this sort of activity where money, in this case, while it's a voucher, people were buying gas at that location, or I guess at other locations, but it's $25 in value, immediately convertible to cash. That where there's a linkage of this kind, which is pretty direct, then people need to say, not only do I have an obligation, I can exercise my First Amendment rights, I can hand out sandwiches, which, knowing Mr. Lindsay, the sandwiches were not very expensive, so, but
Respectfully, I don't think that the value matters under the law.
Well, that was a joke, I'm sorry. He happens to be a good colleague that I'm fond of. If somebody wants to engage in this sort of campaign conduct, they have two responsibilities. One, to design it correctly. The second is to do something to monitor the way that it's enacted. And in this case, you had somebody who either didn't get the message or decided that they were not going to give somebody a voucher unless they agreed to support your candidate. I think crosses the line. And while there were instances in here in voucher distributions which I do not think violates any statute. And as much as we only have 2 to 3 times where this happened, it happened.
Respectfully, the evidence I heard today, which was evidence I heard for the first time today, did show that at the same place where that inquiry happened, at that same location, the person who indicated that they were going to vote for a different candidate or were positive to another candidate walked away with the voucher.
The difference is, they got the voucher, and then they were asked, would they?
But that happened at the same location. So to me, that does not really make a lot of sense as to why that's being interpreted that way. I will say that other videos show very clearly, particularly ones where people are walking into the grocery stores, those things are just being handed out to every single person that walked in.
I've made my point that there's lots of conduct that look to me to be fine. But I think it's indisputable that there's a direct linkage that before I give you this voucher, you have to make a commitment to the candidate. And I think everybody in the state needs to know that if you want to engage in this sort of campaign conduct, you've got to be really, really careful, not only in the design, but also in the enactment of it. And when the evidence in the case is that, in fact, that somebody decided in the voucher program at this particular location that they were going to say, here's a voucher, would you consider voting for and supporting Herschel Walker? And when they said they did, they were given the voucher. And I think that shows that the linkage was they got the voucher because of their expression and desire to vote for their candidate. I just think that's wrong.
Respectfully, I don't think it's a violation of the statute, and I think we have First Amendment problems as well.
I don't think we have First Amendment problem, but the fact that folks who indicated that we're going to vote for Senator Warnock were also given a voucher, and I think that there's evidence that that's generally what happened there, pulls it back from a situation that I'm comfortable sending to the AG. You know, I could be, let me just sort of say out loud, I could be persuaded to send a letter of instruction, just simply making sure that everyone understands where the line is. But I do think that the intent was clear. I think that at worst, you've got some sloppiness that went on. But it appears that everyone got a voucher. I haven't seen any evidence that someone was ever denied a voucher if they didn't vote for Senator, rather if they didn't vote for Herschel Walker instead of, and were going to vote for Senator Warnock. Absent that, I'm not comfortable sending it on to the Attorney General. Like I said, you know, as part of this deliberation, I could vote for to dismiss, or I could vote for a letter of recommendation. I don't believe I could vote. I can't vote to send it on to the Attorney General. I just don't think the evidence is there.
Well, if I might, first I have immense respect for my colleague Sarah. I think she's one of the smartest and hardest working people that I've ever had the pleasure to serve with, and I very rarely disagree with her because she does such a good job of being reasonable about most things, and she's not being unreasonable here. I just disagree with her. But another preliminary comment is that was perhaps that was the best, most well-written brief I've ever read in my service on this board. The brief was just terrific because it said, here's a list of similar cases that you decided this way, here's a list of cases that you decided the other way. And I thought that was well-researched, well-written, and just absolutely brilliant. So I really appreciated all the hard work that went into that. In my mind, the question is this a publicity stunt or a quid pro quo? And that's where it comes down to. And what we've done previously with regard to cases like this is the question is, did the organization tell the person to do that? Or did the person decide to do it on their own? And so I think on the other case that we're thinking about that we're going to talk about today, I think it was the organization that said, this is the deal. And so it wasn't a rogue actor doing it, as we seem to have here, because that person that was acted contrarily to the instructions that we have from the organization, that the organization shows that they did it. And so in my mind, this made me think of voter registration cases where you had rogue actors on behalf of organizations that would turn in, voter applications for Jesus. you know, and Mickey Mouse. And so the question was, do you hold the organization responsible for that or the individual? And as my thought is that we've never held the organization responsible for that. But it's, you know, it was the individual's fault. So here, I think it was a publicity stunt. I think the council makes a very good argument that it was separated in time. So it wasn't like a direct quid pro quo. In the other cases that we have cases that says, come and get this food that we're handing out, and then everybody immediately go to the poll and vote. And so, I mean, it was compact in time and pressed on top of each other. And here, it was a publicity stunt. So I'm not convinced that there was a violation. And so, had Sarah not beaten me to it, I would have made a motion to accept the motion to dismiss. But Sarah got her motion heard first. So, but I'll vote very respectfully and with great care against the motion to send it on, and with the utmost of respect and appreciation for my colleague Sarah.
I will amend my motion because I find your argument quite persuasive about the agent versus the actor, and I would amend it to sending a letter of instruction that when activities like this are done, the training must be done with great care. And when if we find that an organization has sponsored a giveaway and has not trained their agents to make sure that they make very clear that whatever giveaway is not dependent on any activity or action on the part of the voter, then they will be held responsible. But in this case, there's no evidence that that was not done. So I withdraw my motion to refer it to the Attorney General's office and instead move that we issue a letter of instruction on that basis.
I would like to add, I see a couple of issues. One is the continuum of campaigning for someone, to a survey if you vote for someone, to encourage to vote or register for someone, an election, to a promise to conditioned on. And it's the whole continuum from campaigning to buying votes, basically. And I think a very important thing to consider is the proximity in time to the election and the proximity of location to the polling place. So I think we should look seriously at any cases that are brought, or complaints that are brought to us, that address proximity to location and time of the election much more carefully than very distant from an election, which is more like, I think Mr. Mashburn said, it's a campaign stunt or publicity stunt.
So would your client enter into a consent order that has the letter of instruction language? That
We would request dismissal. On the grounds that it's not a violation. I think it would be difficult for us to agree that this is a violation.
Anybody else? So what's the motion? Motion is to grant the motion to dismiss?
Yes, but also issuing a letter of instruction.
Sorry.
We are not finding a violation, but nonetheless, I would like a statement on the record that is available to other parties to put them on notice of how these programs must be run if they are going to be run.
Yeah. And here's why that makes sense to me and why I think it's a good argument, because we don't want to set the line that the next campaign pushes and says, well, you said this was okay, and so we're going to push it to the next level now. I think it's good to say this is as close to that line as we want anybody to ever get.
Yeah. I mean, your intent was clearly, I didn't mean to be overly dismissive when you said First Amendment, because I think the intent was clearly First Amendment. I think, I'm a little, in reading to this, in listening to my investigator in terms of how some of the volunteers were acting. I think that it would be beneficial to your organization and any other organization to say, hey, you have good intent, this sort of thing would be permissible, but you have to very clearly stay within your lane. That's, like I said, there's going to be finding, in my mind, I'm not going to vote for a violation, but I do think using your situation as a case in which we can tell folks, here's where you need to stay inside your lane. So dismissal with a motion, with that letter of instruction is what I would agree to.
Is there a second for that motion?
Second.
Is there been moved and seconded that the case be dismissed, but that there be a letter of instruction admonishing and directing that the respondent carefully and lawfully enact their programs, and then we can flesh that out so that people that in other situations with other campaigns would know that this is troubling to the board, and that they have a heightened responsibility when they're giving out anything that is directly convertible into a dollar amount. So it's been moved and seconded. That's the motion to dismiss and for a letter of instruction. All those say aye.
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 The motion passes unanimously. Thank you.
Thank you.
Right, the next is 2020-043, absentee ballot tabulation of the DeKalb. You know, we've been going almost 3 hours since lunch. Let's take a 10-minute break before we get to this next.
Agreed. Unanimous consent.
Could somebody ask the people that are outside that want to continue in the meeting to tell them that we're getting started up again, unless they're gone?
Okay, board members, live mics.
Okay, so you're saying.
Live mics.
All right, before we get started, of the people that are here that are individuals that are appearing because they want to respond to the complaints, can you raise your hands? I'm sorry. Okay, and what? Yes, which one is yours?
Can you press your button on the
I got
plate
it,
in
I
front
got
of you?
it. 202-117.
Mr. Chairman, there's a young lady back there as well.
So, and you're both in the same case? Yes. Okay.
And there's another young lady back here.
And you are, what's your case?
117.
Okay. Anybody else that's an individual responding to appearing here because they're a respondent in a case? All right, so for all four of you, the disposition of the case does not require your presence. And so I would go home or go wherever you want to go, but you don't have to stay here. And I'm sorry about that, but I never thought it was going to take this long to get to this, but as you know, it's taken a long time. And I'm sorry, I wish I could have told you earlier, but.
Can you press your button? The court reporter needs to take down what you're saying.
You got to hold, now you got to hold the
There's a
microphone.
little talk button on that brass plate. Okay, I see you. All right, I got you.
Will we be notified about the resolution somehow?
Yes, if you'll write down your email address, all four of you, I will send you an email about what happened.
Okay, thank you.
Okay? So if you'll do that and give it to Alex here, and also put your name so that I know who it is, and we'll take care of that for you. All right, we took the second Fulton County case, which was 2022-205, because the Fulton County people were here. We skipped over the Floyd County case of 2020-86, which is at tab 11. So let's do that next. When?
Friday.
How about DeKalb County 2020-234?
Yes.
Okay, let's do that one then.
This is a continued case from the previous meeting. On November 30th, 2020, we received a complaint that an elector submitted his absentee ballot via a ballot drop box in DeKalb County. The elector checked the online My Voter page and found out that the AB ballot had been challenged and not counted. This occurred during the early voting of the November 2020 general election. The complainant, James Ullman Jr., stated that he and his wife requested an AB ballot for the general presidential election held November 3rd, 2020. He stated that they received their ballots by mail, completed their ballots, and signed their oath envelopes. Mr. Ullman stated that he placed both ballots into the DeKalb County Board of Registration and Elections drop box on Memorial Drive. He found out later, while on the MVP page, that his absentee ballot was not counted. He said that DeKalb County Board of Registration and Elections told him that their record showed that he had early voted in person at a church precinct. he advised that he did not vote in person at the early voting church location, that his precinct is a school. The election supervisor, Tiffany Gilbert, stated that she personally looked through the absentee in-person applications for the date in question for the Berean Christian Church early voting poll precinct and did not locate an application for Mr. Almond. Mr. Gilbert further stated, because she did not find an application for Mr. Almond, that she concluded that an error had been made at the advanced voting location. Ms. Gilbert stated that she did not feel that a thorough search was conducted. In summary, an unknown poll worker allowed an unknown respondent to vote in person during early voting for the 2020 general election at the Berean Christian Church precinct using the identity of the complainant, James Doyle Almond Jr. A search for the absentee in-person application for him was conducted by the election supervisor but was not found. Then an unknown poll worker challenged the valid absentee ballot of elector James Almond Jr., failing to notify him of said challenge and follow the procedures for a challenged absentee ballot in OCGA 21-2386. There is evidence to suggest that an unknown DeKalb County poll worker did fail to write challenge, the elector's name, and the alleged cause of challenge on the outer envelope and deposit the ballot of an elector in a secure sealed ballot box and be counted as other challenge ballots are. There's evidence to suggest an unknown absentee ballot clerk failed to notify the elector of said challenge. Violation of OCGA 21-386-7 subsection E.
Are there any questions for the investigator? Is the respondent here to respond to the complaint?
Yes, thank you. Irene Vanderels here on behalf of DeKalb County Board of Registration and Elections. We do not have evidence to contradict the report by the investigator, although I'll note it appears to be an error in giving credit to the correct voter at the early voting location. And I would just note that it doesn't appear to be a violation of 21-386, which are absentee ballot challenge procedures, but a 21-388, which sets forth the procedure for canceling absentee ballots when the voter comes to vote in person, and had that procedure been followed and the appropriate documentation completed, the voter, Mr. Almond, may have received earlier notice of the issue. That's really just a technical legal point. But glad to answer any questions. The former director, Eric Hamilton, is here with us today as well.
So do you acknowledge the violation, but are saying that it isn't as significant as it appears to be?
Well, I don't know that. I think there was it appears based on our inability to find the documentation from the advanced voting site that the proper procedures were not followed. My point is simply that the reference statute may not be the one applicable to this situation.
Yeah, thank you for pointing that out. I appreciate it. All right, is there a motion?
Before there's a motion, if I could ask a clarifying question.
Sure.
Was this voter ever notified that his ballot was challenged?
No.
Until after the fact?
My understanding from staff is that what appears to have happened is that Mr. Almond's voting record was credited for voting during advanced voting, and his absentee ballot, which had been issued but not returned, was canceled at that time. And under those procedures, the voter is not notified of the canceled absentee ballot because the presumption is that the voter is there canceling their ballot.
Okay, so there was no actual challenge issued against the voter, and it was simply the cancellation. There was no challenge. It was simply canceled because of the prior vote accredited to his record. Okay.
Correct.
Okay, thank you. That's what I was having some confusion over. Thank you.
And we did not, apparently the department did not learn about the issue, which was reported by Mr. Almond until after the election results had been certified.
Any discussion? Is there a motion to discuss?
The only question I have, Chairman Duffy, is that the investigative report says the poll worker challenged. Was that an error?
I believe so, based on my discussions with staff, that the poll worker, well, we don't know which poll worker it was. That individual has not been identified. But what it appears to have been is that when they were attempting to credit the voter or enter the voter into the system, they canceled the absentee ballot because the person was there to vote in person. So it wasn't a challenge for cause, meaning the person wasn't qualified to vote, but rather a canceled absentee ballot.
Is there a motion?
I just want to make sure the voter in the end wasn't able to vote. Is that right?
Mr. Allman's absentee ballot, which he reported having returned, was canceled and not counted, is my understanding.
But he voted in person, right?
No,
Okay.
He says that he did not vote in person. His voting record was given credit. We have not been able to locate an absentee application or canceled ballot affidavit in his name from that advanced voting location. And so based on the evidence before us that's been presented, it appears that an error was made by the poll worker during advanced voting in crediting Mr. Allman's voting record rather than the voter who came in to vote. And I'll note there are two voters with that name. I don't know if it was the other Mr. Allman or not. We don't know that because we don't have the absentee application or the advance in-person application to verify that.
Any other questions?
I would move that, that we refer this to the Attorney General's office. But I want to thank you for that last clarification that there are two voters with the same name, because that really puts a fine point on exactly what happened and exactly how important it is that that in voter challenges, in votes like this, that there are it's shocking. I have been shocked how many voters there are with the same name, sometimes with the same date of birth, and how easy it is to disenfranchise a voter inadvertently by making a match with incomplete data and incomplete information. So I really appreciate that. And that makes me a lot more confident in how it happened, exactly what happened, and also that given the fact that we are updating our poll pads and we'll be able to scan driver's licenses, that it will be far less likely for this to happen moving forward. That being said, I nonetheless move that we refer this to the Attorney General's office because someone was denied the ability to cast a ballot.
Second.
It's been moved and seconded to refer case number 2020-234 to the Attorney General's office. Is there any further discussion?
Just I appreciate the CABs being upfront about it and being straight with us. It makes it a lot easier and makes these things go a lot faster if people just are square with us. So I appreciate it.
Well, I was going to say the same thing. I really appreciate your candor, including pointing out the statute section that really does apply as opposed to the one that was cited. And this process goes, and this is a good example, really well, when people understand what happened, acknowledge what happened. And that's also important to us and to the Attorney General's office when we decide how to ultimately dispose of the case. So thank you again. All right, there being no further discussion, all those in favor of the motion say aye.
Aye.
Opposed, no. It passes unanimously. Okay, the next case now is SEB 2020-043, DeKalb County absentee ballot tabulation, tab 15.
Okay, SEB 2020-043, DeKalb County absentee ballot tabulation. On 6/22/2020, the Georgia Office of the Secretary of State Investigation Division received a complaint regarding the tabulation of absentee ballots during the DeKalb County 2020 primary election. The allegations are as follows. Number one, the Canon optical scanner, DRG 2140, used by DeKalb County are not authorized for ballot scanning by the Georgia Office of the Secretary of State or the federal government. Sub A, the Georgia Office of the Secretary of State did not certify the Canon optical scanners. B, the settings on the Canon optical scanner caused thousands of absentee ballots to be rejected. Second complaint, as of 6/22/2020, the DeKalb County Board of Voter Registration and Elections had yet to post the results of the 2020 presidential preference primary and special elections onto the county website. 3, thousands of absentee ballots were left unattended inside the DeKalb County Board of Voter Registrations and Elections office. 4, a DeKalb County Voter Registration and Election Board member publicly endorsed and may have a business relationship with a candidate on the DeKalb 2020 primary election ballot. This board member was also involved in the ballot tabulation process. 5, the DeKalb County Board of Voter Registration and Elections printed an excess number of blank absentee ballots. 6, the DeKalb County Board of Voter Registration and Election poll workers appear to be creating absentee ballots as opposed to duplicating absentee ballots that were rejected by the optical scanners. And finally, number 7, the poll manager at a precinct on Memorial Drive lost a ballot scanner data card. So in looking at the allegations, starting with number 1, and I'll read it again because you probably forgot after all of those different allegations I read off. So it's about the scanner basically not being authorized. So actually the scanners, the investigator spoke with Michael Barnes, the director of the Election Center, regarding that, and he stated that the Office of the Secretary of State does not certify specific equipment, but the software used on the equipment is in accordance with OCGA 21-2-368. He also indicated that as far as the parameters, 14% and 28%, he said that is incorrect. They're actually set at 12% to 35%, and this setting provided a wider margin of error than the settings reported by the complainant and her source. Number 2. So for that, there was insufficient evidence to prove a Georgia election code violation occurred. Number 2, as of 6/22/2020, the DeKalb County Board of Voter Registration and Elections had yet to post the results of the 3/24/2020 presidential preference primary and special elections. So according to the complainant, they weren't posted as they should have been. Later, the investigator did speak with Erica Hamilton, the DeKalb County election supervisor at that time. Her response was that several election staff were sick with COVID, which directly impacted day-to-day operations. As a result, the election results were not posted on the county website until 6/25/2020. So that was a violation, and I'll continue to go through the rest of the violations and then I'll cite what that violation was. Number 3, thousands of absentee ballots were left unattended inside the DeKalb County Board of Voter Registration and Elections office. So another interview conducted by our investigator with Supervisor Erica Hamilton. Her response to the allegation was that all ballots were always in plain view of the election staff and security cameras. All ballots were stored in secure rooms overnight. And in addition, there's some photographs that were taken, and those photographs did fail to capture ballots left unattended as alleged in the complaint. Number 4, a DeKalb County Voter Registration and Election Board member publicly endorsed and may have a business relationship with a candidate on the DeKalb 2020 primary election ballot. This board member was also involved in the ballot tabulation process. That member is Samuel Tillman. Investigator interviewed Mr. Tillman, and his response to the allegation was he has not publicly endorsed or campaigned for the candidate, nor has he ever had a business relationship with Jones, who was the candidate. Regarding the ballot adjudication process, he had no involvement in the adjudication and duplication process of absentee ballots. He did not handling ballots at any point. He was only there to sign the opening zero tape report, and he stayed there to observe the election process. Allegation number 5. The DeKalb County Board of Voter Registration and Elections printed an excess number of blank absentee ballots. Another interview conducted with Supervisor Erica Hamilton. She confirmed the election office had the capability to print ballots. However, they are printed on demand and as needed. At no point did her office maintain a stockpile of blank ballots. Number 6, the DeKalb County Board of Voter Registration and Election poll workers appeared to be creating new absentee ballots as opposed to duplicating absentee ballots that were rejected by the optical scanners. Another interview conducted with DeKalb County Election Supervisor Erica Hamilton and Samuel Tillman. She explained that the adjudication process took place in 2 separate rooms. The adjudicators would review and mark ballots in one room, while the ballot duplication team recreated the ballots in a separate room. That would explain Stringer's observation of election staff independently duplicating ballots. And there was also an allegation that was part of that regarding the review teams as it related to that. And so there was some interviews conducted by members. One was a DeKalb County Sheriff candidate who indicated that they were told on some occasions not to show up, for example. So the reviewers were told, hey, don't come in and show up. There's nothing for you to review today. He initially agreed to provide a written statement regarding that, but then he later rescinded. The investigator did interview a Robert Bryan, who is a Republican Party representative of the ballot review panel, and he indicated that he received a telephone call from Tillman not to come into work on a particular date, but he could not recall the exact date. He stated an HR director of the board, he described her as, quote, a young Caucasian female with red hair, was his point of contact for scheduling. He indicated she would have the exact date. He did indicate further that there was one date when he arrived to work late and a second Democratic Party representative served on the ballot review panel in his absence. Bryant informed Tillman of the issue of having 2 Democrats serving on the ballot review panel, and Tillman immediately removed the second Democrat and added Bryant to the panel. Bryant could not recall the exact date of this incident. Bryant further stated he was unaware of any instance when the county election staff acted as a ballot review panel and duplicated absentee ballots without the assistance of designated political party representatives. So, Mr. Tillman also indicated that he did not know the members of the adjudication duplication team, nor did he have their contact information, in refuting the allegation that he's the one that would call and say, don't show up today to review. He's saying basically that he didn't have their information, he didn't have their, he had no way of contacting these individuals and didn't even know them. So now, on this date, the investigator requested that Hamilton provide contact information for each member of the ballot adjudication or duplication teams for interviews. And unfortunately, that information was not provided. He said he sent multiple emails and that information wasn't provided. Finally, allegation 7, the poll manager at a precinct on Memorial Drive lost her a ballot scanner data card, and that is in fact factual. a poll manager by the name of Jerry Carter. He forgot his ballot scanner data card in his precinct bag and failed to check it in at the end of the night. Once the election office realized the data card was missing, they began to search for it. They got in touch with him, and he told them at that time that he left it inside his precinct bag that he dropped off at the election warehouse at the end of the night. They were able to find that card that night, election night that was. So ultimately, from this investigation, there were 2 allegations that were sustained, or more accurately, 1 allegation that was sustained, and then another that resulted from the failure to provide information to the Secretary of State's office. So the first violation is OCGA 21-2-421A, posting of required information after closing of polls, when the election staff failed to post the results of the 2020 presidential preference primary and special elections in a timely manner. The second violation is DeKalb County's failure and neglect or refusal to deliver documents. That's OCGA 21-2-562 sub B, when they failed to respond as it relates to obtaining the information for the ballot adjudication duplication team. And in addition, there was a request for the information for Mr. Carter, and that wasn't provided either. So those are the 2 violations.
Does the board have any questions for the investigator and his report?
Chairman Duffy, I have some questions about allegation 5 and allegation 6. Allegation 5 pertains to printers. OCGA 21-2-283 and 294 say the superintendent shall keep a record of the number of official ballots printed and furnished to each precinct and at each primary and election, and the number of stubs, unused ballots, and canceled ballots returned. My question is there a record of the number of ballots printed by DeKalb Election Office? Is there a record of the number of ballots furnished to each precinct by the election office? Is there a record of the number of stubs? Is there a record of the number of unused ballots? Is there a record of the number of canceled ballots returned? The other 2 questions concerning printers, the county printer were the printed absentee ballots used for duplication of absentee or Yokapa ballots? And were the Dominion BMDs used to print ballots for duplication of absentee or Yokapa ballots?
We attempted to obtain that information from DeKalb. I had an investigator send those requests to DeKalb County.
Hi, I'm Shelley Momo. I'm here on behalf of the Board of Registration and Elections and our former director, Ms. Hamilton, who's also here. Just at the outset again, I want to note that the notice we received doesn't have a vast majority of this information. It only has more information detailing the violation for allegation 2. It says that there was insufficient evidence for the rest, and we weren't provided with any of that, including, I know that there is a potential violation listed of the OCGA 21-2-562, neglect or refusal to provide documents, and we didn't have any allegations in our summary to investigate. We weren't aware of what you were talking about. So just at the outset, we're kind of just hearing about a lot of this for the first time. However, we are here to speak on potential violation 2, and Ms. Hamilton can also speak to Ms. Johnson's questions about the ballots printed. And I know I can tell you, Ms. Keisha Smith is also here and received a request for those records. We do maintain those records. I believe the last correspondence she sought clarification to make sure she was providing you with the right thing and was waiting to hear back. But if you'd like to hear from Ms. Hamilton before I proceed.
Yes.
Erica Hamilton, I'm the former director of the DeKalb County Board of Elections and Registration. And to answer Dr. Johnson's questions, yes, there's a record kept of the number of ballots, emergency and provisional ballots that you send to a polling place and advanced voting locations. Those records are kept as what were required for the 2 years. I'm hoping DeKalb still has those, as I'm no longer with DeKalb. Also, we did use the Dominion Ballot on Demand to print the absentee by mail ballots.
Thank you, Ms. Hamilton. Is there a record, though, of how many ballots were printed on the DeKalb printer?
We can give you how many we printed for the actual number of absentee ballots that were requested, but when we duplicate ballots, we always have an extra so that we can use those to duplicate UOCAVA and any ballots that are kicked out of the machine for tears, torn, and any that have to go through the review panel.
Right. Could those, the record of all these printed ballots be provided?
I can't provide them. You would have to speak to the current DeKalb County employees to see if they can still provide those records, but I'm sure they can.
Yes, and we still have those records, and we can provide those if you provide us with a list of what you want. We, in our last correspondence, we just wanted to make sure we understood the full request of the county. So if you'd like to also, if you would like for us to speak to the alleged violation of allegation 2, I can also speak to that today while we're here.
Let me ask one question, Michael. The documents described by Dr. Johnston, did you request them in connection with your investigation?
Yes, we did, subsequent. So kind of at a later time. Not during the initial investigation, no. Those records weren't requested at that time.
So when did you request them?
Probably about a week ago.
Yeah, last Thursday. And our current director is here as well, and she can speak to the current maintenance of documents.
And what prompted you to ask for them a week ago?
During a review. A review of the cases. Just a more in-depth review that we conducted.
When you said
With
the review you conducted, was that the pre-meeting?
Yes, pre-meeting.
That was more than a week ago, I think.
I had asked.
Yeah, Dr. Johnston.
How is that related to the allegations that we're considering? Do you need that? I know you asked for it. That was a good thing to do. But is it related to the allegations?
Well, they allege that they printed up an excessive amount. They didn't say exactly how much, but an excessive amount of these ballots. They saw it at the tabulation center, I guess, is one of the allegations. Yes. Allegation 5, the DeKalb County Board of Voter Registration Elections printed an excess number of blank absentee ballots. That was one of the.
But Dr. Johnson, do you continue to need that in order to make a decision on this?
I think I do need more information, and
Are you moving to continue?
I would move to continue.
Is there a second?
I think the DeKalb County also didn't feel like they had everything. Is that correct?
Well, they asked for some clarification, apparently haven't gotten it yet. Isn't that right?
Yes, we asked for clarification on specifically what was
That
requested.
clarification was to the investigators, and you're waiting to hear back from them on the clarification?
As of yesterday, we were.
What it is the respondents are not given notice that they need to come ready to answer questions about matters they're not being charged with. And so they didn't get notice that they were going to be charged with 5, so they didn't come ready to respond to 5.
That's what I'm saying.
Yeah.
If I can ask you, do you feel like you would be better prepared to respond to questions if we continue this case? Is it in your best, do you think it's in your best interest to continue?
We can respond to allegation 2, and we can probably respond to the excessive ballot allegation, but it sounds like you need more information, so I think a continuance is probably best.
Yeah.
So if Dr. Johnson is amenable, I would like to amend her motion that we continue 5, but that we go ahead and proceed with the others.
Continue 6. 5, I'm sorry, I have questions about 6.
Oh, you have more?
but I would
Oh,
like to
okay, okay.
continue
I
also.
think we ought to just continue the
Okay,
case.
okay. I was just trying to see if we could not
Right.
get some of it
If
done.
I can amend make a friendly amendment that we make sure that DeKalb gets the more complete investigatory report so that they can respond, so they know that what we're looking at and we're all looking at the same thing and they can respond.
Okay.
Then I second your motion for
So
continuance
they should get
under
the
those circumstances.
report, what we call the report rather than the summary.
Yes.
Well, we had 2 or 3 instances where the summaries have not informed people. This has happened in the last couple of meetings. What's the objection to providing the full investigatory report?
Well,
I
Mr.
mean, the
Chair-
full summary.
Mr. Chairman, that was exactly the question I was going to ask you.
Well, let me ask you, what do you?
I have no objection.
I
And
had-
I'm waiting maybe for the
Well, here's
investigative secretary to say.
Here's what I was told. I was told, when I said, why don't we just send them everything? They said, we don't do that. We only send the summary because the investigation report is an internal document that is given to us, but not to respondents.
Well, if it's not internal once it's in my book.
Well,
because
it's internally within your book.
Yeah, but if this gentleman way back over here were to send me an open records request.
No, I think that it would only be available after we made
After
a
the hearing,
decision.
okay.
And-
Still,
and-
nevertheless, I do think, this is the lawyer in me, and someone did disparage lawyers earlier, but this is my due process hat. I like for respondents to be able to see the allegations.
I do too.
And so, and it will also do away with a lot of we didn't have this investigation, or we didn't have this claim. So can we continue? So that would do away with that. So I would like for us to consider in the future, turning over the full investigative report that will be presented to the board so that the respondents can
It also, it also might provide the opportunity to respond to some of the requests that were not provided.
Yeah.
That suggested a neglect or refusal of providing
exactly
records.
right. So yes, Mr. Chairman.
All right, it's been moved and seconded to continue this case. All those in favor say aye.
Aye.
Opposed, no. Passes unanimously. Thank you. We'll see you again.
Right now, in fact.
Well, we'll see you again on that matter, and we'll see you now on the next matter, which is SAB 2020-139, which is at tab 16. Who's going to report on that?
Yes. So regarding this complaint, on or about October 26, 2020, the Georgia Secretary of State's office received a complaint alleging that the Dunwoody Library advanced voting site had an unsecure absentee ballot drop box that a poll worker was able to access by lifting the top of the drop box, which did not appear to be secure.
I'm sorry, could you do that again?
On or about October 26, 2020, Georgia Secretary of State received a complaint alleging that the Dunwoody Library advanced voting site had an unsecured absentee ballot drop box that a poll worker was able to access by lifting the top of the drop box, which did not appear to be secure. Investigator Humes at that time, now supervisor, confirmed that the DeKalb County Board of Elections and Registration posted the county's official drop box locations on the homepage of the county's election office. However, the Dunwoody Library was not listed as an official drop box location. He went out to that location, which is located at 5339 Chomley Dunwoody Road in Dunwoody. He met with the poll manager, Sherry Method. She reported she was advised by DeKalb County Elections Office Director Erica Hamilton that her advanced location could receive and store absentee ballots at her location. Ms. Method further explained that she maintained the absentee ballots in a secure storage bin that was marked ballot box. It was left in the public's view and was always under the control of either herself or one of her 2 assistant poll managers. The voter was always escorted by a manager only, and the manager visually observed the voter deposit the absentee ballot into the drop box. Ms. Method escorted Humes to where the drop box was located and demonstrated how it was used and showed where the drop box was kept during normal operations and secured at night. Humes observed a makeshift box that was in public view but secured with a zip tie. The drop box opening at the top was too small to accommodate the absentee ballot envelope, so it required the top of the box to be raised slightly so the absentee ballot envelope could be dropped into the drop box. Mrs. Method also explained that at the end of every day, she personally stored the drop box in a secure location to which she only has access. Regarding the process for emptying the drop box containing the absentee ballots, Ms. Method stated that herself and her assistant managers were going to collect the ballots at the end of the advanced voting period, complete a ballot transfer form, and transport the absentee ballots to the main office for processing. After discussing the amount of time that could elapse between the time a voter submitted their absentee ballot and the advanced voting period, a voter could assume, due to the delay, that their ballot was not received. Mrs. Method advised she would arrange for the drop box to be emptied this date and will no longer accept absentee ballots at that location. So the findings in this complaint was that this drop box did not meet the requirements as put forth in Georgia State Election Board Rule 183-114.6-14, and that's a 1 through 9, but specifically 4, 5, 6, and 7. 4 says the drop box location must have adequate lighting and use a video recording device to monitor each drop box location. The video recording device must either continuously record the drop box location or use motion detection that records 1 frame or more per minute until detection of motion triggers continuous recording. 5, video recordings of the drop box location must be retained by the county register for 30 days after the final certification of the election or until conclusion of any contest involving an election on the ballot in the county jurisdiction, whichever is later, and shall be made available to Secretary of State investigators upon request. Number 6, a drop box shall be constructed of durable material able to withstand vandalism and inclement weather. The opening slot of a drop box shall not allow ballots to be tampered with or removed and shall be designed to minimize the ability for liquid to be poured into the drop box or rainwater to seep in. And finally, number 7, a drop box shall be securely fastened to the ground or an immovable fixture. And that's,
So are you done?
yes, I'm done.
So this was a COVID, wasn't this for COVID that we allowed these drop boxes?
Yes.
And the idea was that we wanted to facilitate the ability of people to deliver their absentee ballots in drop boxes and envision that that might actually be, not prominently be in locations outside. So my question is this just a absentee ballot container, or is it a drop box that was made available so that people could deliver their ballots to?
May I? I just wanted to provide a little context, and I think you've kind of hit the mark. So this was a practice of DeKalb's that predated the authorization of drop boxes. We allowed, and it was authorized by law, allowed deputized poll officials to accept absentee ballots. This was in a zip-tied box. It was just a container. And we actually were later told by the Secretary of State to discontinue this practice, and we did. But we did not consider it a drop box. It was just a practice that predated this that allowed them to receive and hold those. And Ms. Hamilton can also speak to this if you have more detailed factual questions.
So your point is you can't be charged with violating a regulation that didn't exist at the time that you were doing whatever you did, right?
Well, I think it doesn't apply. I do think there was a drop box rule at that time, because my recollection is that they were authorized for the June election, and this is the November 2020 election. However, this was just deputized poll officials accepting ballots separately, not related to the drop box.
If I
Let me ask you one more question. When the Secretary of State, I guess, was somebody from the Secretary of State's office actually present and saw this practice that you had? Or did you have questions about whether or not that was proper and asked them for their opinion?
It was brought to our attention that that someone called the Secretary of State's office. This practice had been in place since, I guess, absentee ballot drop-off absentee balloting was a process. And so we just allowed the managers and assistant managers to be deputized to accept absentee ballots. And they were brought back at the end of advanced voting with a transport sheet. Now, if the ballot container got full prior to then, the manager would call in and we would send 2 people out to pick up those ballots to transport them back to the office. But that was always a practice, and it was done before Election Day so that the voters could also get updated credit before Election Day to know that their ballot had been received. So that was a practice. But we received, when someone made a complaint to the Secretary of State's office, a member of the Secretary of State's investigative group went out, and they, from that point, told us not to continue that practice going forward.
If I may, Judge.
Can I ask you one more question, since you're better on this? Are you still allowed to accept absentee ballots? And I bet there's a statute on that.
There is. And this is current law. OCGA 21-2-382, subparagraph A. Any other provisions of this chapter to the contrary notwithstanding, the Board of Registrars may establish additional registrars' offices or places of registration for the purpose of receiving absentee ballots under Code Section 21-2-381, and that is mail-in absentee ballots, and for the purpose of advanced voting under Code Section 21-2-385. This provision pre-existed SB 202. It pre-existed any drop box provisions that we've had, and counties have either ignored it, most counties have chosen not to implement this, but DeKalb County has had a long history of doing that. So meaning that they can establish deputy registrars or remote registration offices for absentee in-person voting, but also accepting mail-in absentee ballots delivered by hand. There are no rules with regard to how it should be conducted, so there's a big gap. And in fact, there are other counties that have piloted different versions of this and set up remote receipts in locations that are not conducting absentee in-person voting. Some of them choose to accept the ballots and check them in right then. They look them up and they literally register it into ENET or at the time. Some of them were just collecting them physically. I think there are definitely best practices that we can look at, but I think that this was a practice that was allowed under the statute, even if it might not have been, like I said, the best practice to put them in a zip-tied box and only collect them at the end of early voting. Maybe not how I would do it, but it seems to be contemplated within the statute.
There's nothing in the COVID drop box statute that says, by the way, if you have a method for collecting absentee ballots in the voting location, that you have to now use something that complies with the...
Right, because this has always been in there. And the Dropbox rules were rules, and this doesn't fit that pattern at all, because the Dropbox rules as the investigators have pointed out, it's a whole different provision.
So it's a drop box, but not that kind of drop box.
Well, I don't think that I would call it a Dropbox, though.
Yeah, that's what I would need.
Yeah, I wouldn't call it a Dropbox. I would say they were just simply how they were storing the ballots that they accepted by hand at the additional registration location.
Okay, so the ballot went through the government. It wasn't deposited directly by the voter into this container. The government put it in the container.
I don't know who physically
The
placed it.
container was in the presence of the manager. But the voter, they allowed the voter just to put it in. So it wasn't really a drop box. The manager took it, but the voter didn't want to take it out of the manager's hands, so the manager just allowed the voter to drop it into this bin.
And the Secretary of State said that wasn't a good idea, so y'all stopped doing it?
Correct.
Okay.
I don't disagree with the Secretary of State's assessment that that was not the best practice, but I think it's arguably within the scope of the statute.
Yeah.
So I would move to dismiss on that basis.
Is there a second? I'll second. So it's been moved and seconded to dismiss the complaint against DeKalb County. Is there any discussion on the motion?
I think that's fine.
I think it does highlight a need for rulemaking,
Yeah.
because this is still good law. So if counties
people
want,
can do that.
if counties want to accept ballots at early voting locations
Yeah.
or in government sites, they should be able to do that, but there need to be stricter rules around how they can do that and best practices in chain of custody and that sort of thing.
Yeah,
So,
we got to get that straightened out before
Yeah.
2024.
Yeah, we have
Agreed.
to
For
put it
sure.
on our to-do list.
yes.
Well, yeah.
There's a second possible violation of oath not being executed.
Which item, Dr. Johnson?
I only have one violation.
Oh, 129.
What page are you on?
That's the last page.
Page 17.
Last page.
Page 5 of 5 of the report.
129.
Page 5 of 5 of the report, not the summary.
Well, I don't have the report. I guess I was only working with the summary. Do you have a copy of the report?
My report's only 4 pages long.
What's that?
Report of investigation?
I have a summary of investigation under tab 16, but I don't have the report of investigation.
I don't either. What's that? 120, what is it? 139.
He doesn't have it either. Look at this with me.
I don't. Yeah, yes, I think it's 139, not 129. That's the next case. It's the next case, yes.
You might want to just start loading this up.
Yep, add this, yeah, definitely. Definitely,
Thank you for
definitely.
agreeing to take this on, I appreciate it.
Definitely.
I figured I might as well volunteer, Mr. Chairman. It's gonna come to me anyway.
Definitely, definitely, definitely.
I believe I've been voluntold.
And Sarah, come to me and Sarah anyway. We'll also take Dr. Johnson, who's already agreed to that.
All right, and all those in favor of dismissing case number 2020-139, say aye.
Aye.
Opposed, no. It's dismissed. The decision was unanimous. Now we're to 129. Did you give me yours?
Yes, sir.
You want it back?
Yes, sir. Thank you, sir.
All right. We have the report on this one?
Yes. Case SCB 2021-129, DeKalb County absentee ballot box procedures. Secretary of State's office received a complaint alleging that DeKalb County violated absentee ballot drop box procedures in the November 2020 election. The allegations are as follows. Out of the 61,731 absentee ballots deposited in drop boxes, 28,194 were not received by the registrar's office until between 13 and 22 hours after they were removed from the boxes. Additionally, it is alleged that 15,713 absentee ballots had no receipt time recorded on them by the elections office. There is an additional allegation that in the case of 14,925 ballots, there was an extended period after the ballots were collected from drop boxes, over an hour before they were received by the election official. The allegation is that this was not an immediate transfer, quote unquote. So regarding this investigation, the investigator contacted Mrs. Hamilton. Actually, he ended up speaking with Ms. Hart. I think Ms. Hamilton indicated that she was going to be leaving soon, something to that effect. He ended up meeting with Mrs. Hart at the DeKalb County Elections Office. He asked her to explain the process that was in place for bringing the absentee ballots back to the office. She explained to him that a team of 2 people would go collect the ballots from the drop box. The team would place the ballots in a large red locking container and come back to the elections office. Once at the election office, the team would take the containers inside the building, and if no workers were present to receive the ballots, the collection team would place the containers inside the warehouse. Once in the warehouse, the collection team would secure the room, set the alarm, and the ballots would be received the next day. The entire building, to include the warehouse storage area, are monitored 24 hours a day by an array of cameras, as well as cameras on the outside of the building. The investigator then took a tour of the facility, took photos of that, noticed the alarm system, the door access, surveillance cameras, etc. The investigator reviewed the ballot transfer forms for the month of October 2020 up to November 3rd, 2020. There were some occasions where there was not a signature for the absentee ballot clerk designee receiving the ballots. Several had no time of receiving the ballots. Several had no pickup, had no indication of when the pickup was done from a drop box. He spoke with a Ronald Hardaway, who was the main person in charge of collecting the drop boxes. Apparently it was mainly him and several other drivers from the warehouse. He asked Mr. Hardaway why they did not go to every box in the county, and Mr. Hardaway stated that they simply did not have the staffing to do it, and he could not do it all himself. He did not find a ballot transfer form for 11/2/2020. So, further inspection, he noticed that there were 81 instances of drop boxes that did not get checked off as being emptied. There were 9 instances of no one signing as receiving, and 120 forms with no time noted when received. A further breakdown of the form revealed the following. There was a total of 62,055 ballots represented in the ballot transfer forms. There were 1,142 ballots represented on forms that no one has signed as receiving. There were 14,694 ballots represented on forms that had no time noted as being accepted. He asked why there were some forms that did not have a time as received and why some forms did not have a signature as being received, and he was told that it was an oversight and they will work on correcting deficiencies in their process. He did note there was a police officer hired to stand by at drop boxes when they closed. The police officer would wait until the collection team arrived. Once the collection team collected the ballots, the police officer would follow them back to the county office and escorted them into the building. So ultimately, based on the investigation, there was evidence to sustain SCB Rule 183-1-14.6-.14, 10 secure absentee ballot drop boxes when DeKalb County failed to sign or place the time as received on several of the ballot collection forms for drop boxes immediately upon the delivery to the election office, and for also failing to check and empty all drop boxes every 24 hours as required during the time period beginning the second Monday prior to the election through Election Day. And also OCGA 21-293, oath of office for managers and clerks, when Erica Hamilton failed to execute the oaths before entering their duties and for not attesting to the oaths taken by clerks who picked up absentee ballots from drop boxes in DeKalb County.
So let me ask DeKalb this. Why should we pass rules? I mean, I understand occasional, isolated incidents. This seems to me to be wholly disregarding an obligation that they have and just making excuses and just doing it the way that you want to do it and you don't really care. I mean, how do we respond to this?
Well, respectfully, we do not have the documentation to contradict what has been set forth in the investigative report. I don't know that there is any excuse for not following the rules that were in place at the time with regard to drop boxes. I can provide you an explanation for why the forms were not properly completed and why the oaths, why we don't, we simply weren't able to locate oaths that predate Election Day of that year, but I fully respect your question. All I can say is that the Board of Registration and Elections and the staff take the work very seriously, and this was an enormously challenging time during COVID with new procedures. The rules have changed as the board knows, significantly with regard to Dropbox procedures. We have new written practices, protocols in place, as well as new training to ensure that staff can follow those. But I hear what you are saying, and understand how very important the rules are in this work, and the staff take it very seriously, and we'll do our best to continue doing that. But we don't, we can see that there is a probable cause of violations of the rules that were in place at this time.
Yeah, just in the context of treating similar cases similarly, we had a Fulton County where they set up boxes and didn't have video surveillance, and we sent that to the Attorney General. So I don't think we have much choice but to send this to the Attorney General.
Well, we're not sending it because we did the same thing for Fulton County. We sent it because this demands that it goes to the Attorney General.
True.
This is totally unacceptable conduct.
If that was a motion, then I second it.
I move that we send this to the Attorney General.
Oh.
Second.
You made,
Either
I made a motion?
Either one.
No, he made the motion. We just weren't sure if you seconded it.
Oh, is there any further discussion? It's been moved that this be referred to the Attorney General's office. Is there any discussion on the motion?
Just to make the comment that as we're moving into a municipal elections, signatures may seem like a small thing and a slight oversight, but they are absolutely critical to chain of custody and to confidence. And I want everybody listening to make sure that you literally dot your I's and cross your T's on this. It has never been more important to do everything that we can to reinforce the rules and the procedures, and we can follow and trace every piece of paper along every step of the way. This is it. This is the bread and butter of election security, is following everything and having the proper signatures, the proper witnesses, the proper timestamps, everything in order. That's not ancillary to what you do, that is core to what you do. That's it.
Point. All right, it's been moved and seconded that we refer this complaint, which is 2021-129. All those in favor of the motion say aye.
Aye.
Aye. Opposed, no. It passes unanimously. The next is 21-21-172, incorrect precinct assignment, which is a tab 18.
Okay. On November 8th, 2021, the Georgia Secretary of State's office received an email from Twyla Hart, the registration supervisor of DeKalb County Voter Registration and Elections, who self-reported that 167 electors were not in the correct precinct. Secretary of State's office advised her that the data needed to be corrected on ENET. On a subsequent date, March 2nd, 2022, the investigator contacted Ms. Hart. In following up, she stated that the error was discovered during the municipal elections on November 2nd, 2021. She also advised the corrections were made on November 11th, 2021, before the runoff. She advised that Glenda Woods did the redistricting, mapping for the precinct, and the electors were sent eligibility letters to notify them. He later talked to Mrs. Woods to find out what exactly happened, and it looks like this was a mix-up as it related to the city of Atlanta, and the 167 voters lived in an apartment complex that was on the border of DeKalb County and Fulton County. And so that's where it looks like the mix-up occurred for this particular situation. So ultimately, based on this situation, there is evidence to suggest that Glenda Woods, Twyla Hart, and the DeKalb County Board of Registration and Election violated OCGA 21-2-226, which stipulates it shall be the duty of the County Board of Registrars to determine the eligibility of each person applying to register to vote in such county. Upon finding an elector eligible to vote in the County Board of Registrars shall have the duty of determining and placing the elector in the proper congressional district, state senate district, state house district, county commission district, if any, county or independent board of education district, if any, and municipal governing authority district, if any, such other voting district, if any, and precinct. So the corrections were obviously made subsequent to that, 7 days after that election.
Did that cause any ballots to have to be redone, since the ballot format would be different for at least those 167 people? I mean, it had
I thought it was 11. Let's see, let me go back.
I mean, had any of them voted on a ballot format that was not correct for their precinct? Or for their...
So the statement that we have regarding the 167 is that out of the 167 voters, 11 voted in the municipal race.
So did any of those people have a ballot that really didn't pertain to them? Guess so.
Yes, until they corrected it for the runoff. So I guess that's how they figured it out, is that I guess a voter came and wanted to vote in the runoff, and then that's when they discovered, oh, you know, we made this mistake, and then they corrected it. So I guess before the runoff, then everybody was able to vote.
Yeah, but in the initial election, people voted on a ballot. Does that mean that some of their votes didn't count?
Chairman Duffy, if I may, our records showed that there were 13 voters that voted in that municipal special election on November 2nd that didn't receive the correct ballot.
How do you feel about that?
So they didn't vote for the
How do you feel about basically denying a voter, even if it's only 11, the right to vote on the people that they want to lead them?
I think I speak for the board and all of our staff that just denying one person is a huge deal. This resulted from an error made after an annexation of this property into the city of Atlanta, is my understanding. And I think we take these seriously, and that is shown by our self-reporting immediately. We then sent out eligibility letters before the runoff to all of the affected voters, worked with the Secretary of State to make sure this was fixed and they could either manually vote or the issue was fixed in ENET. And I know that there were 2 affected precincts, and we also made sure the eligibility letters were on file at those precincts so they could be double checked.
So in mitigation, it seems like this was one error that impacted 167 people rather than 167 separate errors, right?
Yes, it was one address that just happened to be an apartment complex.
I would like to suggest that it was very responsible to self-report and to do it immediately upon discovery, and that helped mitigate not just our perception of what went wrong, but it mitigated the impact for the voters because you were able to work very quickly to get it corrected for the runoff. And I do appreciate that, and I certainly don't want, and again, speaking to folks who aren't here but are possibly still listening, it's really critical that that counties, when you find errors, you do report them so that they can be addressed as quickly as possible.
I mean, I think that's right. You know, this is the first time we've begun bucketing county complaints. So we're going to do more of that so that we don't spread them across, because it helps us to look at the overall conduct of a county by considering as a group the complaints against them. And, you know, in this case, 1, 2, 3. It's 17 out of the 25, 68%. Yeah.
But To be fair, a number of these are about voters and not about the county activity necessarily, so just want to be clear. At least some of them are.
But several of them are about voter disenfranchisement.
Yeah.
Yes, absolutely. Were these voters disenfranchised, or did they receive ballots that they should not have?
They just received the wrong ballots, so my understanding is that they didn't get to vote
That is
correct.
My point is that you're disenfranchised
Yeah.
if you receive a ballot to vote in race D, but you don't live in D's district, so you didn't get a chance to vote for your representative.
Yeah,
Right,
Similarly,
they wouldn't
the
have been able to
candidate
vote
has
in
people
municipal
that aren't in
races.
their district voting for them.
And, you know, unfortunate for, you know, it's two issues. One is, it's a voter issue, and like I said, we take very seriously anytime a voter cannot cast a vote for his candidates of choice in the community he lives in. But, you know, we had this discussion that, from Mr. Gassaway earlier. In his particular race up in northeast Georgia, they actually had 3 different elections for the same office because the race was tough. You know, it really did come down to about a dozen voters each time. And there were a dozen voters that were in the wrong precinct, or in the wrong district. And so, the most serious thing is certain voters weren't able to vote here and there. But the second thing is it impacts elections. In that situation, you had, for one office, you had to have 3 different elections. So, you know, close races happen. Races are decided by a few hundred votes sometimes.
Yeah, I don't think we have any choice but to send this over, so I make a motion that this go to the Attorney General.
Is there a second?
Second.
Been moved and seconded to refer this complaint to the Attorney General's office, which is the complaint in 2021-172. Is there any further discussion?
I do appreciate DeKalb County's attitude when y'all come in and don't try and blow smoke, but you just say, if you messed up, you just admit that you messed up. So I appreciate that.
And hopefully that'll be something that you guys can work out quickly with the AG. We can get a consent order and then move on. But we do need to have these sort of things addressed seriously, given the fact it impacts that individual.
And to the extent that this is a problem that we are going to continue to see, because I have never seen a redistricting process where this doesn't happen in multiple counties.
Yep.
So we will see this again, and we encourage every county to face it like DeKalb has, as straightforwardly as you can, and so we can get it resolved as quickly as we can, but most importantly, so that the errors get corrected in the record and voters get their correct ballot.
Well, and to an extent that in redistricting, it has become so precise. In the old days, there was a river that divided it. There was the city line or a county line or whatever, and now we're trying to do it. Neighbors vote in different, so we understand it's really hard. It's gotten a lot harder. So we're not insensitive to the difficulties that are being placed on you.
Yep.
The other thing that I'll suggest is that with the Supreme Court's decision about redistricting in Alabama, it's likely to have an impact in Georgia. That impact is liable to put you under greater time pressure, which will make it easier to make mistakes unless you're really, really vigilant.
And if it makes you feel any better, DeKalb County, that means that we'll get sued again.
Who will?
Yeah, we get sued for that.
I'm tired of being sued. All right, the next
Motion, did we vote?
Yeah, no, we didn't.
Motion and second.
All those in favor say aye.
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 Opposed, no. Passes unanimously. Thank you for the correction, reminder. We're now to SEB 2022-117. Let me just make a couple historical context comments about this. Because we're not going to hear this today. And we're not going to hear it because for a couple months now, as I've begun to look at the investigative activity that the Secretary of State's office has been through, and I'm working on, I keep telling people this, that at some point they're not going to believe me, that we have this memo to go out to the counties about voter challenges. And that will be done soon, right? So, but I think it'll be a good work product. But what I've found is, especially now that there are these large challenges that occurred in the midterm elections, that began to wonder how that's happening. Of course, I know it happened because SB 202 allowed an individual person to bring more than one challenge, and so that would clearly had an impact. But then I began to look at the challenges themselves and the number of challenges, and I said, what is the rule about this? And the rules are pretty plain. Although there's some difficulty in applying several of them when you're trying to determine somebody's residence. So when we first looked at this at one of our pre-meetings, I said, boy, this is an awful lot of people. Who is the person who's making the challenges? And the challenges are being asserted by, let's see, let me just make sure I'm right about this. But what's the first page of the investigation report that has? Wait, maybe I got it here. So who's asserting the challenges? And when I heard how much time was being taken by the investigative staff on this particular complaint, I just asked who the complainant was, and they said it's totes legit. And I said, well, who is totes legit? So, well, we don't know. And I said, well, have you ever contacted him to ask him where he lived? He said, he won't tell us. And I said, well, that's not the rule. I think there are a lot of people that don't understand that only an elector can challenge somebody's registration. And the elector has to be from the same county as the person being challenged. And I said, so how do we even know that this person qualifies under the statute to bring a challenge against any of these people? And we don't, there's not enough facts. Facts, my mantra is facts. What are the facts, and then what does the law say? The first fact is, are you qualified under the statute to bring a challenge? And here, there's not sufficient factual support to conclude that this person, whomever it is, and wherever they live, is somebody who is qualified to bring these challenges. And then as you dig a little deeper into it, you say, well, where does the information come from? And it's people that troll through databases and look for residences and found that these people all used a UPS address. And then I began to read this and found all the different reasons why people were using UPS addresses. And I don't know if any of them understands what Sarah has been telling people all afternoon, which is the reason why you have to put a residence there is because of what we just talked about. You need to know where somebody lives to know what ballot they should get and in what precinct they may vote. But that doesn't mean that you can't have a separate mailing address. But the process requires the election officials in the county to know where somebody lives for the purposes of deciding One, can they vote in the county where they are? And second, what ballot do they get, depending upon what precinct they're in? So I have, and I would say that the amount of time to research this has been enormous. And if the amount of time to research this is enormous for us, I can imagine what the burden is for the counties. And that's why we're trying to get some pretty firm analysis to give to county attorneys and also to give to county election officials to help them say, there are rules that you're allowed to apply, and if you have facts that don't allow you to proceed with something or to hear a challenge because it doesn't qualify to be heard, then you have the right and probably the duty, not to allow that challenge to go forward. So we don't know who Tokes Legit is, and for that reason alone, I don't know if this is in fact a person who is permitted to bring the challenges that have been brought. And for that reason, and ultimately, it is not, the other thing is that this is an end run around the challenge process. You can't just say, I have a complaint, there's a challenge, and therefore you have to hear the challenge. The challenge is the prerogative of the county and the responsibility of the county. They're the ones that determine who is and who is not allowed to be a registered voter and who is and is not allowed to be on the registration list in their county. And why is that? Because it's their county. It's the reason why they get to look at people who are complaining that are residents of their county about whether somebody can be is properly registered and on the registration list in their county, because it's their county. And it's not the state election boards. One, it's not legally our responsibility, nor should it be. It's the responsibility of the counties. And so if in fact this was even legitimate, it would be something that would necessarily have to be referred back to the county and not hidden in the form of a complaint to get a second opinion or somebody else to analyze these, who is not supposed to and is not obligated to and shouldn't. So this complaint is not going forward, and I'm going to move that it be dismissed. And that's my motion.
Second.
But you want to say something else?
Of course, I always want to say something else. There were a number of respondents in this case who responded with information that either they did not have a permanent residence or they refused to register under their residence because they were under threat of domestic violence. I wish the Vote Safe program were better known. There is a way to register to vote, and if you have a domestic violence background and you have a protective order, you can have your residential information suppressed. The Secretary of State's website has that information available. If there's any way that somebody could promote that in our local newspaper. But that's really critical information that gives voters who are afraid the tools to still be able to participate in our democracy while remaining safe. There are also other ways. There are ways that people who don't have a permanent residence can register to vote. They can keep a mailing address and register at a courthouse or even at the registrar's office as their residence if they don't have one. So some of the challenges that people face, there are ways around them. They just have to reach out and ask for help. Reach out to their registrar's office. And then other people just move around a lot and use a mailbox for a residential address. Well, don't do that. Have a separate mailing address as a mailbox as your mailing address, but you have to register for your residence. So I just wanted a little PSA. Thank you for bearing with me.
Well, and by way of discussion, one of the responses that we received was particularly heartbreaking because this person responded, I use this UPS box not for purposes of fraud, but because somebody wants to kill me. And I don't want them to know where I'm at. And therefore, I give up the right, I'd rather give up my right to vote than to give this person my address and get killed. And so, I mean, that is something that, you know, people aren't really privy to, and I had not really given that much thought until I got it. But that's just heartbreaking that somebody thinks they're put to the choice to give up the right to vote just to protect, just to save their own life. So it'd be really good to get out that information that you're not put to that choice, but people just don't know.
Likewise, it's interesting how we look at things with different perspectives. I think there are good reasons to protect people's address, such as threats or protective orders. But you do need to know the residence of a person in order to determine if they're voting in the right location or if they actually live in the jurisdiction. So I looked at this from the perspective of this is more of an issue with DeKalb registrars doing their due diligence to make sure that most people just inadvertently signed up to get a driver's license and put a post office box down, and that just was translated into a voter registration address. So it's part of the 228 code that says that the registrar should, from time to time, examine the qualifications of the electors. And so it should be part of your maintenance program, monthly, daily, weekly maintenance, to screen addresses for ineligible or commercial addresses and get those corrected. Contact the voter and get those corrected, because assuming they're all legitimate, eligible registrants, we'd like for them to be able to vote and not be challenged. And so if the county does its job, there should not be many citizen challenges.
Well, I wish I was more optimistic about there being less citizen challenges. But certainly if there are citizen challenges like we've seen in the past and like we see here, I think it's our responsibility to provide guidance as to how to respond to those so that you don't end up doing what we did on this case, which was to spend a lot of time it was not warranted. And I would say that the AJC and other Cox Media outlets that, sometimes if voting is important to all of us, sometimes we need help in campaigns to get the word out about how somebody can live their life without the fear of whatever fear they have, to know that there's a way of giving the county the information they need to know where they're entitled to vote. At the same time, not making that widely known to people and allowing them to use a separate mailing address. And so if you could, I know that you have tremendous seniority at the paper, but if you would talk to somebody and ask that we would like to talk to them about maybe a simple banner on some of your pages, on your digital presentation of the paper, that just encourages people that have those concerns to call a specific number, we would appreciate that. You might have to give up a couple of column inches. But a little heads up in your article would help that.
Moved and seconded. Ready for a vote.
Yeah. All those in favor of dismissing complaint number 2022-117, say aye.
Aye.
Opposed, no. Passes unanimously. All right, next is SEB 2022-154, DeKalb County double voter, which is at tab 20.
This is DeKalb County double voter, SEB 2022-154. Upon review of the reconciliation documentation by the Secretary of State's office, it was found that a single elector potentially voted twice during the May 24th, 2022 general election primary. So what happened was Abraham Muhammad submitted 2 advanced in-person voting applications and cast ballots for each during the May 24th general election primary and received credit for the 2 votes. So when the investigator spoke to Ms. Claudia Callaghan Hill regarding her recollection of the application by Mr. Muhammad, she stated that she didn't recall the application on May 4th and referred him to the poll worker, Ms. Denitra Cotton, who would have processed the second application. But Ms. Hill said that if she was in the system that showed that a voter had already voted, she would have canceled the original ballot and issued a new ballot to allow him to vote. She said that she was working the early voting site near South DeKalb Mall, which is consistent with where Mr. Muhammad described where he had voted. The initial CCH were in line, which indicates who certified approved both of the applications. The investigator then spoke with Ms. Denitra Cotton, who processed the second application for Mr. Muhammad. He emailed her a copy of the application and the screenshot in ElectionNet showing that it was edited by Ms. Cotton on May 19th, 2022. She replied that she vaguely recalled the incident because it was discovered during their internal audit on the day of the election. She stated that when she received the application from Mr. Muhammad, she noticed that the date on the application and the date in the system did not match. She said that she thought the application had an error, and so she had changed the date. She believed that there may have been a system error and that causing the date to have been entered wrong in the system. She said that she edited and updated the date in the system so that a new ballot could be issued, resulting in Mr. Muhammad voting a second time. She advised that in hindsight, she should have gone through the applications from May 4th to see if there actually was an application on file, which there was. On August 16th, he spoke with Mr. Abraham Muhammad at his apartment. After explaining the situation, Mr. Muhammad said that he had difficulty recalling exactly what took place during the election. He lives in a senior living complex and said that he does recall taking the community bus to the voting precinct near where it was described in South DeKalb Mall area, and that he thought that he went there one time to register and then a second time to cast his vote. He said that he tries to vote in all the elections but does not recall voting twice in May of 2022. He reviewed the advanced in-person application and confirmed that all the information was correct and that both signatures appeared to be his. He declined to write a statement because he advised he just couldn't recall with confidence exactly what had happened. The findings were there was sufficient evidence to suggest that there was a violation of OCGA 21-572, repeat voting in the same primary or election, and OCGA 21-596, failure of the public or political officer to perform duty, and that was for Denitra Cotton and Claudia Callaghan Hill.
Do any board members have any questions of Sarah about her report?
Just one very quick question. Is there any indication in the file how old Mr. Muhammad is?
He said he was a senior adult, but it didn't give a particular age.
Well, you're a senior adult.
Exactly.
I don't have his birthday in here.
I'm a senior adult.
If it's not a problem if there's not, I just didn't know if it was something you could easily find, Ms. Coffin.
It's in one of the exhibits. I can pull it off though.
It's not necessary.
154.
But this is again a case where the advanced voting periods or early voting periods, when they were arguing that they just might be too long, we've had lots of seniors that just forgot that they had voted in an election. So this, I mean, it's come up a lot.
And the procedures in place should prevent it from happening.
Correct.
If they're followed.
Correct.
So I would move that we.
But we're going to hear from the respondent.
Oh, yes, I apologize, yes.
Thank you. So I'm here on behalf of the Department of Registration and Elections. I did speak with Ms. Denitra Cotton. At this time, we don't represent her, but she was here today, and unfortunately, she had to leave. I haven't, in our investigation, had a chance to speak with Ms. Hill to determine what happened on her end. But my understanding is the same as Ms. Koth reported. Ms. Cotton told me that she was doing an audit of the ballots, and the stack it was in made her think that the date was wrong, so she went in to correct it. And then I think that error set off kind of a domino effect that let the second application be approved. In response, the department has actually made sure to implement training on this into their training of poll officials and the procedures associated with this, and I believe this actual specific scenario is covered during training of poll officials to make sure it doesn't happen again.
Thank you.
And if I may, I will add one thing, although I haven't talked to Ms. Hill. I did speak with Ms. Cotton, and as the report says, and in my investigation, I also haven't found any evidence of willful neglect or refusal to perform their duty. So I would say that. I did want to note that because they are poll officials that are accused of a violation of a misdemeanor statute, which requires willful neglect and refusal, and not just neglect as is reported.
All right, is there any further discussion? If not, do we have a motion?
He's in his upper 80s.
Upper 80s? Oh, okay.
Young,
you.
very young. Is there a motion?
You guys send. I'm moved to send it to the Attorney General.
Is there a second?
I didn't hear. I'm sorry.
Let's move to send to the Attorney General.
Everybody, including Mr. Muhammad.
Will he responded?
Yeah.
He was, yeah, I mean,
how do you not do that? How do you not do that?
Yeah. Well, the case I was thinking about was an elderly lady, but it was where she voted for her dead husband. So that was the case I was thinking about, and I was the one who said, we can't just let you go. But that was a different thing, but, so we're sending everybody, so is that up for a second?
I mean, I'm trying to be consistent, and
Yeah,
I
okay.
understand he's in his upper 80s, okay? I understand that.
Yeah.
But he did vote twice.
Yeah. Agreed. Second.
And, there's certain things that can't speak for anybody but me that I send to if there's evidence that someone was denied a vote and through proper administration they should have been able to vote, I think that's a more serious problem.
Yeah.
If it's only one. And the second one is if someone votes that they shouldn't have voted. That's more serious because that ends up diluting at best, negating if at the worst, some other voters' vote. And so yes, under these circumstances, I would send it to the Attorney General. Of course, person's age, person's intent, the fact that the board is taking steps we can work our way through. Mind you, I anticipate having one joint consent order for all of this, rather than breaking it down, and so we can work our way through all these matters to make sure, and y'all appear to be trying to make sure this sort of thing doesn't happen again, and that's good, and that should be taken into account with any consent order. But when it comes to voters, and for what I've just said, I don't see where we have a choice.
Second.
It's been moved and seconded to refer Case number 2022-154 to the Attorney General's office. Is there any further discussion? There being none,
I can have one further discussion. To the extent it is reported back to me, it doesn't mean you're going to jail. Okay. It means that there's got to be, you know, some type of discussion as to why this shouldn't happen again. That doesn't mean we're going to be sending somebody to jail if we're sending it to the AG's office. That's a civil issue as opposed to sending it to a DA. I need, in case that ever gets to him, I want to make sure that that's, I don't want to make somebody in the 80s nervous about that.
okay. All those in favor of the motion say aye.
Aye.
Opposed, no. It passes unanimously. The next is SB 2022-316, DeKalb County Briarwood scanner issue.
2022-316. The Secretary of State's office opened an investigation after receiving a complaint in which the complainant stated that after printing their ballot, they were asked to place their ballot into a scanner which was labeled with an alphabetic letter range which didn't correspond to their last name. When the complainant requested to place the ballot in the other scanner, the poll worker flipped their ballot over, exposing the voter selections, to show them the precinct code which corresponded to the alphabetic letter range, potentially violating Georgia SEB Rule 183-112.11, subsection 8, conducting elections. So what happened was the complainant, Ms. Gould, stated that on October 31st, 2022, she went to the advanced voting site located on Briarwood Way in Atlanta, Georgia, which is Briarwood Recreation Center. She said that she printed her ballot and began to walk over to the scanners, and prior to reaching the scanners, she was directed by the poll worker at the scanner to place her ballot in the right scanner, which was marked with a placard M through Z. She said that since her last name begins with a G, she asked to place it in the left scanner, which was marked with a placard A through L. She advised that the poll worker then flipped her ballot over, exposing the marked selections portion of the ballot, then pointed to a code at the top which started with the letter S. She stated that he told her that it was her precinct code, it had nothing to do with her last name, and then placed it in a scanner marked N through Z. Ms. Gold was also curious how the poll worker knew which scanner to send her to prior to her reaching him. The investigator went to the Briarwood Recreation Center and met with the poll manager, Chris Henson. Mr. Henson confirmed that the labels on the scanners reflect the precinct code which the voter is assigned and not their last name. He also confirmed that there is no way to determine which scanner to place the ballot into without viewing the precinct code, which is located at the top of the ballot, next to the QR code. He stated, however, that if the ballot was placed into the wrong scanner, it would automatically reject it and the voter would have to use the correct scanner. The investigator explained the need to protect the privacy and confidentiality of the voter and that they would need to devise some means to avoid the poll workers from having to look at the ballot to determine which scanner to place it in. As the investigator was leaving, Mr. Henson was actively trying to devise a solution and was also on the phone with the DeKalb Elections headquarters to inform them and to seek some guidance. The investigator then met with Melvin McCall. He was one of the workers. He confirmed that everything Mr. Henson stated regarding the labeling of the scanners and that the only way to determine the precinct code was to view the top of the ballot. The investigator observed poll workers looking briefly at the face of the ballots to determine which scanner to direct the voter to scan their ballot. The investigator inspected both scanners and the seals were present. The scanners had their total counts as follows, and he had listed the numbers. He checked ElectionNet and found that Ms. Gould's precinct code begins with SE, therefore the ballot was entered into the correct scanner. The findings were there was sufficient evidence to substantiate that poll workers were briefly viewing the face of the voter's ballot to view the precinct code to determine which scanner to direct voters. A potential violation of 183-112.11, subsection 8.
Mr. Chairman, while I don't want to short circuit the ability of a respondent to respond, let me make a motion and see if they want to respond, which was I would make a motion for us to find a technical violation and send a letter of instruction.
What do you all think of that?
we would certainly accept that.
Second.
Have you developed a solution to this?
The issue has to do with the number of precincts that we have in DeKalb County during the advanced voting period, because of course voters can vote at any advanced voting location, so the scanners have to be able to read the ballots from any of the precincts. And in the past, my understanding is that the scanners were programmed in a way that they could only process about half of the data for the precincts, and so they were split alphabetically. But they apparently have come up with a solution so that will not have to occur in forward-going elections, so that both scanners can be used to try to, eliminate this as an issue.
All right, so is there a motion?
That's my motion, Mr. Chairman.
Second.
Is there any discussion on the motion, which is to send a letter of instruction
Technical violation.
for technical violation?
I agree with that solution. There will be a solution to this to allow a single scanner, but I think that will only be applicable when we upgrade the system to 5.17.
I think that's right.
So I would encourage you to create some kind of signage that would highlight, like a sample ballot, highlight and circle the precinct code so that voters can identify where it is on their own ballot themselves. And I'm sure that the Secretary of State's office would work with you on developing that if they need that, or reach out to the Center for Civic Design.
And that perhaps with utilizing Sarah's assistance, that would probably help you with your letter of instruction, because I think this would be something that would be helpful to just about every other county doing early voting.
Or every county that has to use multiple scanners.
Yeah.
It all depends on
The larger county.
Yeah, the big ones.
All right, the
Sorry.
motion is to send a letter of instruction for a technical violation with some language suggesting how the correction that needs to be made. Is there any further discussion on the motion? There not being any, all those in favor say aye.
Aye.
Opposed, no. Passes unanimously. SB 2022-328, DeKalb County voting equipment issue, tab 22.
2022-328. The Secretary of State's office opened an investigation regarding a DeKalb County polling site at Stonecrest, which was reported to have extremely long wait times, and allegedly had multiple voting machines which were not being used or inoperable, potentially violating Georgia SEB Rule 183-112.14, maintenance of equipment. The findings were, it was insufficient evidence to suggest that any of the Stonecrest polling site equipment was dysfunctional or inoperable during the last day of advanced voting. It appears that the extended wait time at the polling site was due to a high voter turnout and not due to any equipment malfunctions. The investigator spoke on the phone with a complainant, Ms. Russum Reynolds, and she said that she went to vote on the 4th, the last day of early voting, and she said that she arrived between 5:30 and 6 p.m. and waited in line for about 3 hours. She stated that the poll workers who were checking voters in were extremely slow. She was timing them, how long they were about 3 to 4 minutes per voter. She said that there were about 24 voting booths, and there were only about 8 being used at any given time. The investigator actually went out there and checked the machines, and they all appeared to be functional and they were working. They just didn't have that many workers to have. They didn't have as many people to get that many people through to have 24 people voting at the same time. She also advised that the line was inside of the building, that there was no air conditioning, and it causing it to be stuffy. Along with her complaint, Ms. Russell, 21-2413E, conduct of voters. In the video and photos, it shows that there is a sufficient amount of BMD booths, but the majority of them are unoccupied by voters. She was advised that the use of photographic devices was prohibited while inside of the polling site. She said that she was aware because the poll manager kept yelling at everybody to put their phones away while they were standing in line. On December 1st, 2022, during advance voting for the December 6th, 2022 runoff, the investigator went to Stonecrest polling site and met with the poll manager, Francis Johnson. Ms. Johnson told him that the extended wait on November 4th was due to the large voter turnout. She said that there were no problems with any of the equipment and none of the BMDs were out of order. She said that for the runoff election, she added 2 additional poll workers to assist with the check-in process to help reduce wait times. And she said that in addition to the large voter turnout, voters had to also fill out an advanced in-person application, which added the additional step station to the check-in process. The findings were this were insufficient evidence to suggest that any of the Stonecrest polling site equipment was dysfunctional or inoperable. And there was sufficient evidence to suggest that Ms. Russell Reynolds took photos and video while inside of a polling place, which is a violation of OCGA 21-2-413, conduct of voters.
All right, any questions of Ms. Kopp from members of the board? No. Let's start first with the county. Would you like to respond? You know what the recommendation is, but would you like to respond to the claims that were made by the complainant?
No, we don't have any reason to disagree with the report on that.
Okay. And is Ms. Rumson Reynolds here? Apparently not.
I think there's sufficient evidence to prove a violation has occurred and move to refer it to the Attorney General.
As relates to Ms. Rumson Reynolds?
Correct.
And would you then move to dismiss the action against the county?
Yes, sir.
Okay. Is there a second?
Second.
All right, it has been moved to refer the complaint as it relates to Ms. Rumson Reynolds to the Attorney General's office, and that we dismiss the complaint against the county. Is there any discussion on the motion? There being none, all those in favor say aye.
Aye.
All those opposed, no. The motion passes unanimously. And the final complaint is SCB 2023-26, DeKalb County election warehouse theft in April of 2023. We have a report on that, please.
Yes. 2023-026. On April 27th, 2023, the Georgia Secretary of State's office opened an investigation after it was reported that a DeKalb County elections warehouse was believed to have been entered and 19 poll pads taken from within the warehouse. The scope of the Secretary of State's investigation focused on the storage and security of the election equipment in accordance with State Election Board Rules 183-1-12.04 and 183-1-12.05. There is evidence to suggest that the DeKalb County elections failed to adequately store components of the voting systems under lock and key at all times after it was determined that a DeKalb County election storage facility door was left unsecured, which contributed to the theft of 19 poll pads from inside the building. The video surveillance showed a suspect pull on the door handle of an exterior fire escape door, and the door opened. Once inside of the building, the suspect had access to over 600 poll pads, which were laid out on tables in the open area of the warehouse. There were no records of any burglary alarm activations at the location during the time of the theft. The allegation that the DeKalb County elections failed to store components of the voting system under lock and key at all times was substantiated. There's note that DeKalb County Police did make an arrest of the suspect believed to have committed the burglary. However, at the time of the report, the poll pads were not recovered. So what happened was the video showed on, we got the call on the 27th, and originally thought that it had happened the night before. And in the video showed the theft occurred on Saturday, April 22nd at around 7 p.m. And it shows the suspect walk around and he's kind of just pulling on the door handles, and he gets to the one fire door and just pulls on it, and he's got his food with him in a beverage. And he goes inside and there's all the poll pads just laid out on tables. There wasn't anything on them, so there wasn't like a breach of data. They were used for training, so they didn't have information on them, so they were wiped. They didn't have people's information on these poll pads. And so he kind of selected them from different locations. So he didn't take 19 from like one table, and he went and got a canvas bag and just kind of selected some and walked around and left after about 40 minutes, hid the bag in the woods, and came back, got his food, and then left again. So they did track him down, and he's currently in care of DeKalb County, but we didn't recover the pole pads at this time.
You say we have or have not?
We have not at this point, because they were turned off.
You mean centrally by the vendor turned them off so they can't be used?
Well, they were just really a paperweight at that point. They didn't have, once they were linked, we were just trying to track them though, but they didn't have any data on them, because once they hooked up to internet, we could track them.
Shall we hear from the county?
I think Ms. Koth has accurately described the facts as we know them. We have implemented new written protocols for teams of 2 to ensure the building is secured at all times, especially opening and closing the building. So those are being implemented. We worked with the police department in their investigation, which I understand is ongoing. And Ms. Keisha Smith, who is the executive director of the department, is here and can answer questions that you may have, more detailed questions about security protocols. But we can see that there's probable cause for violation of the rules in this case, because the pole pads, at Stonecrest, which is, serves multiple purposes for the Department of Voter Registration Elections, there is an internal area which is under additional lock and key from the rest of the facility, and the pole pads at that time were not within that area as they should have been, which facilitated the conduct, apparently.
Of course, all suspects are presumed innocent until proven guilty,
Yes,
but
alleged,
there's
yes.
no evidence this was an insider. This is just a random thief, right?
As far as I know, that's the case, but we're, as I said, the investigation is ongoing, so we haven't been privy to all the details, at least I have.
Do you have a contract with an alarm company?
Yes, there is an alarm system. It did not sound. I don't think that we have an explanation as to why that particular opening of the door did not sound the alarm.
All right, is there a motion?
Yes, I mean, they've got to be kept under lock and key. It wasn't kept under lock and key, so I think we got to send this over to the Attorney General.
Is there a second?
Second.
It's been moved and seconded that SB 22326 be referred to the Attorney General's office. Is there any further discussion on the motion? There being none, all those in favor say aye.
Aye.
Chairman, I think the DeKalb County Election.
Yes.
Okay. I'm Keisha Smith. I am the Executive Director of DeKalb County Voter Registration and Elections, and I just wanted to first introduce myself to the body here and just let you know that I am committed to ensuring that the office operates within the parameters of the law. I joined the county February of last year. And I know that the board is also committed to rectifying issues of the past, and which one of the changes that they made was to hire an executive director. Since being on board, I have hired a training coordinator who was watching this today, and will incorporate all of these types of scenarios into the training for our poll workers this fall. We have established and enhanced standard operating procedures that covers operations throughout the department. And I just want you to know again that we are diligent in correcting these things. And I always say, you know, when I have audits, this isn't, I've managed other agencies and departments. Repeat findings are not something that I like to see, and so we can show you better than we can tell you that we are making progress. And so that's just what I want you to know and leave with today. But I do appreciate your thorough review and your recommendations, and we look forward to working collaboratively and getting those instructions and the memos on the different practices that we can implement to ensure that our operations are done with integrity, transparency, and in the spirit of excellence. So thank you.
Well, first, thank you for introducing yourself to us, and thank you for being with us today. And we appreciate your commitment to continue to move forward and operate with integrity and efficiency.
We didn't get to the finals.
What?
We didn't get to
I know, because you stopped me. So, all those in favor of the motion say aye.
Aye.
Opposed, no. Passes unanimously. That concludes our review of the complaints. We now turn to the Attorney General's report. And so, Ms. Vaughn, if you would do that for us, please.
All right, good evening. I'm going to go through each of these cases one by one, starting with the consent order as it relates to McIntosh County for State Election Board Case 2020-061. The proposed penalty in this consent order is a consent order with a cease and desist, a public reprimand, and a $500 civil penalty to be paid by the McIntosh County Board. The State Election Board voted to refer this case to the Attorney General's office at its August 22nd, 2022 meeting. The findings were that the respondents violated OCGA 21-2-3882 when on June 9th, 2020, poll worker Dolores Walker failed to confirm whether a voter's requested absentee ballot had been returned, failed to allow her to cancel her absentee ballot, and failed to provide her with a provisional ballot, thus denying this individual the right to vote in the June 9th, 2020 general primary election. The Attorney General's office believes that this proposed resolution of the cease and desist, the reprimand, and the $500 fine is appropriate, given that Ms. Walker, the poll worker who made this mistake, passed away prior to the referral of this case to the Attorney General's office, and proceeding to an APA hearing without her would present some challenges. The report of investigation for this particular case also reflected that Ms. Walker, the poll worker in question, had attended multiple poll worker training sessions, so there was not an indication that the county had somehow failed to train her. This was just an unfortunate mistake, and therefore we believe that this proposed resolution is appropriate in regards to McIntosh County.
All right, thank you, Ms. Vaughn. Would anybody from McIntosh County like to respond, or? All right, not. Is there any discussion among the board as to the consent order recommended by the Attorney General's office or its terms?
Move to accept.
What's that?
Move to accept.
Second.
I think we're moving to approve.
Move to approve.
Right. There's been a motion, and I assume that's what your second was. It's been moved and seconded that we approve the consent order that is presented by the Attorney General's office in case number 2020-061. Is there any discussion? There being none, all those in favor of the motion say aye.
Aye.
Opposed, no. Passes unanimously. The next is 2020-271.
Yes, this is a proposed consent order relating to respondents headcount.org and its executive director, Andrew Bernstein, under State Election Board Case 2020-271. This case was referred to the Attorney General's office at the State Election Board's June 20th, 2023 meeting. I can go into more detail regarding the case, but I know it's been referenced by the board even today in some of its ongoing discussions. The proposed resolution is a cease and desist from further violations of the Elections Code. This proposed resolution was actually discussed by the board in ongoing conversations with headcount.org's attorney, Sam Olens, during the June 20th, 2023 election board meeting as it relates to alleged violations of OCGA 21-2-570 regarding the giving of things of value relating to registering to vote, voting, or voting for a particular candidate. And so the board at the meeting had expressed that they believed the consent order for a cease and desist was appropriate, and that is what we are presenting today regarding headcount.org and its executive director. And if anyone has any questions about the additional underlying facts, I'm happy to answer those.
Well, Mr. Olens is here. Would you like to say anything before I ask for a motion?
Your Honor, just that Mr. Lindsay needs to recuse himself.
I'm familiar with what I need to do.
I know, but it's late, and I'm sure everyone's tired. He'll growl at me later.
I was about to make that comment, but thank you so much for the reminder.
It was a pleasure to work with Ms. Vaughn, Your Honor, and our client agrees to the terms of the administrative order.
Well, thank you, and thank you for your comment about Ms. Vaughn. She really has served us well and is a terrific lawyer. We're happy to have her and lucky to have her.
Thank you.
And as General Olens mentioned, I do need to recuse myself from this.
And complimented General Owens. He represented his client very, very zealously and ably, but he did move the process along and was quite reasonable in his request, and so we appreciate that.
Just a comment. This would be a case that I would really want to look at quite closely because it occurred, this giveaway was during the time of the election, during the election period. And an ad that I see says, make sure you vote and enter to win a free Tesla, courtesy of a celebrity and headcount. So that's the thing that makes me pause when prizes or gifts are offered right during an election. And the wording sounds like, make sure you vote and enter to win. Now, does that vote in order to, so the implication there, the suggestion, is something that I think we need to really look carefully at in the future.
Move to approve.
Is there a second?
Second.
It's been moved to approve the Attorney General's recommendation and to enter into the consent order negotiated in case number 2020-271. Is there any further discussion? There not being any, all those in favor say aye.
Aye.
Opposed, no.
No.
It passes 3-1 with Mr. Lindsay abstaining. That's okay. All right, the next is final order in SEB 215-073.
Yes, before I transition to those final orders, I just wanted to provide a quick update on a matter that I had mentioned at the previous State Election Board meeting. At that meeting, I had noted that we had an upcoming hearing regarding Brian Pritchard before the Office of State Administrative Hearings. That hearing was continued due to the health of his attorney and has been rescheduled for October 18th in Gilmer County. And that is a case regarding allegations related to the individual voting while serving probation for a felony sentence. And so hopefully we'll be able to have an update once that hearing occurs.
Thank you.
So just wanted to note that because there are several moving parts to these final orders. I I'm going to start actually with the final order regarding 2017-081. This is all kind of under the same tab in your binders, I believe. This is in regards to respondent Aretha Hill, who was bound over to the Attorney General's office for various cases, which are being addressed in these proposed final orders. The proposed final order regarding 2017-081 is to dismiss Ms. Hill as a respondent in that case. As noted in the Attorney General's office analysis, the violations for which Ms. Hill was specifically bound over were not the direct responsibility of the elections supervisor. And as reflected in the cover memo, the City of Sparta entered a consent order regarding violations already as it related to that case. There was a consolidated consent order that the City of Sparta in Hancock County entered into in August 2022. And so I believe the proper procedure would be to consider the final order under 2017-081, which is the dismissal of Ms. Hill as a respondent from that case.
Are there any questions by the board? Is there a motion? Is there a second?
Second.
It's been moved and seconded to approve the final order in SAB 2017-81. Is there any further discussion? There being none, all those in favor say aye.
Aye.
Opposed, no. Passes unanimously.
Okay, thank you. Now transitioning to the final orders as they regard Ms. Hill in SEB cases 2015-073 and 2017-043. Those have been put together in a single final order, which propose that this board order a cease and desist regarding Ms. Hill, reprimand her, and require that she complete all training required by the Secretary of State before she serves again as an election superintendent. There were a number of allegations that were referred regarding Ms. Hill in relation to these two cases, but the only ones that really would stand legal muster are set forth in the proposed final order. Ms. Hill in November, during the November 3, 2015 City of Sparta municipal general election in Hancock County, she scheduled advanced early voting to occur on October 31st, 2015. That was a Saturday. As required by statute, the advanced voting period needs to end on a Friday. And then in State Election Board case number 2017-043, Ms. Hill had required during the November 7th, 2017 general and special elections that candidates complete background checks as a qualification requirement. That is not actually a requirement by statute. We believe that the proposed resolution of a cease and desist, a reprimand, and the additional training requirement for Ms. Hill is appropriate in this case. She is not currently serving as an election superintendent, and therefore would not be entitled to an APA hearing to require additional training under Code Section 21-2-101. And given the history of this case, how long it has lasted, taking it to an OSA hearing would be challenging, and there have been ongoing consent orders related to the government entities for whom she was employed, and so we believe that this order provides a resolution to the case and would be the appropriate resolution.
Are there any questions for Ms. Vaughn about this final order in case number 2015-073 and 2017-043?
And I would like to note, just to be clear, since this is not a consent order.
I'm sorry.
This is, Ms. Hill has not signed this or agreed to this, but the board does have the authority under Code Section 21-2-33.1 after the completion of appropriate proceedings to order certain remedies. And so, for example, like a civil penalty would be something that would have to go to an APA hearing, but given the posture of this case and the notices that have been provided to Ms. Hill, we believe that we're at the point where the board could enter a final order without her signing to consent to it.
I move to authorize the chairperson of the board to sign the final order as proposed and issue it.
Is there a second?
Second.
It's been moved and seconded that the board approve the final order proposed by the Attorney General in 2015-73 and 2017-43. Is there any discussion? All those in favor say aye.
Aye.
All those no. All those opposed, no. It passes unanimously. All right, that's the final matter. Is there anything for the good of the order from the members of the board?